number, and then you just hit the one. So you're supposed to go, where is it?
Okay. So, for some reason, something popped up.
Oh, I see. Here we go. Use
Got it.
Okay, I agree. There we go. And now I can do the VPN access.
We're ready to go?
I think they're still trying to log into the network. I don't know if you all have laptops that you need to log into or not. Apparently there's some difficulty with that.
Did you get it?
Yes.
Okay.
Oh.
Yeah.
Okay, are we ready? Good morning, everyone.
Good morning.
We are here for day one of a 6-day scheduled merits hearing. The case is Joanna Stolar versus the State of Wisconsin Department of Corrections. ERD case number 2020-02513. Can I get the appearance of everyone, beginning with the complainant, please?
Appearing on behalf of the complainant is Ben Hitchcock Cross of Cross Law Firm.
Okay. And just for the record, because I always put it in my decision if there's co-counsel or paralegals. Did you want to mention anyone?
I didn't.
Okay, fine. From appearing on behalf of the respondent, we have?
Michelle Zacard.
Andrea Olmanson.
Thank you. All right. On November 17, 2020, the complainant filed a complaint with the Equal Rights Division alleging the respondent violated the Wisconsin Fair Employment Law. A portion of this case was first before another administrative law judge for the sole purpose of hearing an appeal on the finding of no probable cause that was found in the initial determination that was issued by an ERO from the division back on August 31st of 2021. The no probable cause portion of this case was dismissed on January 31st of 2024. The remainder of the complaint was certified to hearing on the merits before this ALJ. A pre-hearing conference was held back on March 19 of 2024, which resulted in a pre-hearings conference report, memorandum, and scheduling order that was issued on March 22nd, 2024. The sole issue before this ALJ is whether the complainant can show by a preponderance of the evidence that the respondent violated the Wisconsin Fair Employment Law by discriminating against the complainant by engaging in or allowing sexual harassment. So, we are here. Attorney Cross, would you care to swear in your first witness, sir?
Sure. Before I do that, I'm going to have, I've got an oral motion that I need to make, and especially I've got some clarifications that I've got to make on your statements there.
Sure.
Sure. So for the record, I think we need to be clear that the instructions and assignment for this case began on, I believe, March the 1st of this year, when Maria Celsor sent this tribunal an email that purportedly contained a job description and also contained the assignment for this case. At some point later in the year, we've asked both by public records and by motion for all of these communications to be disclosed. For some reason, this tribunal refuses to disclose this email on March 1st on the grounds that it is a job description. And it's not clear to me why this tribunal would think it was unbiased and could accept job descriptions of this job. The tribunal already has a job description, and the tribunal, the job before the tribunal here is set out in statute and by rule, and is quite clear that it is to hear this without hearing this issue here at this contested Class 3 hearing without bias. But for some reason, this tribunal needs to have a description of what job she's supposed to do and apparently how she's supposed to do it, and refuses to produce that document to the public, and particularly to the parties who also have a right to this document here. From, again, the outset, for the tribunal to refuse to give up this document only lends, again, to the appearance of bias here, that there is, as the tribunal stated several times, that there are no secret instructions in this case. That's what the tribunal said. Well, the facts and the tribunal's actions make it clear that that's very much not the case. We then, I think, move on to, I think, March the 8th. On about March the 8th, I sent this tribunal a link to a video that contained the hearing that was just described herein, I believe, on January 31st of this year. At that hearing, the previous administrative law judge, and for the record, that's John C. Gelhard, shouted, screamed, and otherwise inappropriately tried to use his power, much like this tribunal will have done when we get there, to really for the sake of hiding this case from the public and putting their thumb on the scale. At that time, much like this tribunal did, that ALJ held a hearing, even though it was disguised as a pre-hearing conference. He held a hearing for the sole purpose of trying to elicit whether or not I was a notary. He did that, again, on the instigation and motion of the respondent, the state of Wisconsin. And I'm sorry, before we get anywhere further, I've got to make, I guess, a sub-motion here. For some reason, there is an officer in this room, and I think we need to get that on the record, Judge. Can we get that on the record, please?
You just did.
No, let's get all the appearances here. You want to get the paralegals here? Let's get the police officers that you brought in here. So let's get that on the record, please, Judge.
I asked you if there was anybody with you, whether it was a paralegal or anybody else, that you wanted to put on the record. You said no.
Mm-hmm.
I didn't badger. You said no. We moved on. So now I asked the respondent if there was anybody they wanted to put on the record. They introduced themselves, and that was here. Now, when you first came in the room, you saw the officer, and you started questioning him. Again, I did not interfere. So there is an officer in this room. Officers are quite often present during hearings. I've had to use them before. During, just to maintain an orderly hearing process. That is it. You got his name, and he gave you your badge number. Next question or next motion, sir.
So I guess to cabin that out there, what I understood the tribunal to say here is that there, in this room at the tribunal's invitation, is a police officer, an Officer Pomeroy, in the employ of the state of Wisconsin. He is a state capitol officer here, which again, this is the state of Wisconsin overseeing the state of Wisconsin, using its police powers, I believe, to intimidate the complainant. I have never been at a ERD hearing where there has been a Capitol Police officer. And certainly when I came in the room, let's be clear, tribunal, that behind me is precisely where this police officer was sitting in full view of and with access to privileged attorney-client information here. And I objected at that point that you would have an agent of the state of Wisconsin sitting directly behind the complainant. And I'm objecting now because it's intimidation tactic, and I think it's absolutely inappropriate for you to have, without any reason, cited on the record or any basis. Either you have all the officers come all the time, or you have to have a reason. And to say that they come frequently is no reason at all. We submit here that this is just another tactic. It's more bias against the complainant here. Another evidence that you have predetermined the outcome here. Why else would you invite a police officer for an officer of the court? It's outrageous. I've never heard of such a thing, and it will certainly. I mean, I don't understand why you would think that that was appropriate to bring an armed officer into this tribunal. Do you have any comment on that?
Well, Attorney Hitchcock-Cross, for clarification, there is a chair directly behind you, then there's a table, and then there's another chair by the other door. There are two entrance doors to this room. The officer was not seated beside you, behind you directly. He was seated at the other chair by the door. I did not direct the officer as to where to sit. Told him he could sit wherever he felt comfortable. You asked that he not be seated behind you in the conversation that you had with him. He then moved, and now he's on the opposite side of the room. Nowhere near anything, nor is he looking at him. As I stated, perhaps it's history that I always have had an officer in any hearing that I have. I don't know. But either way, he's here.
Well, are you stating categorically that you've always had officers at all of your ERD hearings? Is that what I'm hearing here?
When I have an in-person hearing, yes, sir.
Okay. Because...
Please move on. You've made your point. You've made your objection. It's on the record. I'd like to get to the case. So if you could go back to your other motions, sir.
No, I got that. It's, again, we've had, and we'll get to March the 8th here, but we have an issue with representations too. So I appreciate that now, and I'm clear that I understand that for all of your in-person hearings, you have always had a police officer in the hearing. And I will assume that there will be records that will be able to demonstrate that. So I appreciate that, because on other records that we have, getting to March the 8th, when I sent you a copy of this video that showed Gelhard dismissing out the hearing, what I would say is not only inappropriate, but what he knew was inappropriate. We sent you a copy of that, a link to that video. And then you sent an email to your boss, who is the person who gave you the directions that you won't give to us. You'll give us some of your communications with her, but for some reason, other communications with her are off limits. And again, when we're talking about bias, we're talking about two things. There's the actual actions that the tribunal has done that demonstrate bias, but there's also what we call the appearance of bias. And here, an appearance of bias can merely be a situation in which, just to a reasonable person, that these actions here would give rise to an inference, and again, there's Supreme Court precedent on this, that would allow a reasonable person to assume that you are wedded to a conclusion here. And in this case, it would be in favor of the state and against the worker. On that date, you sent this email to your boss. You said that I think it's unethical to look at a link from Ben Hitchcock Cross. And I wasn't really clear on why it would be perceived as unethical to receive a link. And I understood that there was some question about, was this ex parte communication here, which has led to quite a good deal of discussion about ex parte communication. And this ex parte communication with your supervisor, you divulged to us and you put in the record. And she told you that she had seen the video, because at that time she was watching a lot of videos from Deliberate Indifference, Wisconsin. We understand from different sources, for example, from Calvin Furman, that Maria Seltzer was actively watching videos and forming opinions on those from, again, Deliberate Indifference, Wisconsin. And so part of the issue here is that we're entitled to know who's making the decisions that have governed this hearing here. And that's something for the respondent as well. They should be concerned about the appearance of fairness, and that there's actually the person who's supposed to be making the decisions is the one making the decisions. But for some reason, they don't seem to be overly concerned about the process of law in this particular hearing. It may be because it's benefiting them for a time. It may be they have different views when it doesn't benefit them. I couldn't say. But on that date, March 8th, Maria Seltzer also told this tribunal, and I'm paraphrasing here, that it's okay, I've seen the video, there's no commentary on it, it's just the hearing from Gelhardt. So, what happened after that? 5 minutes after that, this tribunal sent an email out to the parties telling them that she had not watched the video, which is apparently accurate if you believe the email that Maria Seltzer and they put back and forth. And then she also added that she was not aware of the contents of the email, and which is, apparently surprising here because, again, 5 minutes before that, her supervisor had told her that there was no commentary on it, and it was just the hearing from Gelhardt. And so it's left many people who have discussed this issue with a sort of a quandary. Is it the case that this tribunal forgot what she was told 5 minutes before, or is it the case that she's not telling the truth? And that really is what we're left with here, is one of those two choices when we're confronted with those emails. Which is, again, problematic for two reasons. One, because it creates an appearance of bias, because why is the tribunal not alerting the parties to the truth? Or it creates a problem that the tribunal is not able to remember information that was communicated to her 5 minutes before. So with that in mind, when we look back recursively at the statements here that for all of this tribunal's hearings, there have always been police officers. And I guess if we just assume that's true for a second, what does that, is the tribunal afraid of the employer? Is the tribunal afraid of the worker? Who is the tribunal afraid of? That they need to have an armed agent of the state in the room with them when they conduct a hearing. And it brought me back, that question brings me back to some evidence that I have here. And the first time that I ever met the tribunal was in a hearing that I was in for Jose Garcia Joven. And somebody crossed the podium and the gaze of the ALJ at the time. There was, I think, 6 or 7 ALJs who were in training, and this tribunal was one of them. And the tribunal afterwards told me that when she was a judge, she would have used her contempt powers to enforce and to prohibit, or to rather to punish, the person who was crossing, I guess, the gaze of the tribunal. It may have been another ALJ, it just might have been a peon, I don't know. And at the time, I just assumed that the tribunal was trying to flex the fact that she had previously been appointed to the circuit court by, I believe, Tony Evers, and then appointed to this position. But in retrospect here, I think we'll say, citation, the reference, the allusion to the former powers of contempt, I think also display a fundamental misunderstanding of the role of the administrative law judge in a Class 3 hearing. And that the tribunal here has no dignity, which is something I think that the tribunal needs to understand. And another way that I've recently heard ALJ Carlson explain this is that the administrative law judges don't have plenary powers. That is because they're not creatures of the Constitution of the state of Wisconsin. They are merely creatures of the statutes. And you can see how it might be a big downgrade to go from a circuit court judge empowered by the Constitution to a creature of the statutes with 9 powers, none of which can exceed the authority by rule or law. And one wonders then why someone in such a position would be so addicted, apparently, to having an armed officer of the state appear in their hearings with them. And is it possibly, again, to focus in on the punitive aspect here, because the coercive powers of and the dignity of the circuit court are not in furtherance of a judge's ego. They're to maintain the dignity and authority of the circuit court. And I think that that is what we're seeing here ultimately is an extension of that regret and that failure to understand the reality here. Because I was given in no certain terms to understand that this police officer who is in this courtroom here today has been assigned by his supervisors to follow the instructions of the tribunal. And that, I submit, is merely an abrogation of a power that she does not have. And it's displayed manifest in physical, corporeal form over there, sir. And to have an officer who's not a bailiff, who the only authority, I mean, it is really an outrageous abuse of the tribunal's authority for this police officer to be in here today. Not only is it intimidation manifest, not just to me, but to the First Amendment, to the worker. It not only is it a complete abrogation of the Wisconsin Fair Employment Act that this tribunal is here to enforce, because we all know that the armed officer of the state is not here for the state of Wisconsin's agents. We all know that. And that is one nice thing about this case here, is it really crystallizes a lot of the issues that otherwise are under the surface here at the state of Wisconsin's Equal Rights Division, is that the state of Wisconsin's Equal Rights Division is beholden to other arms of the state of Wisconsin. And ultimately, the tribunal here is an attorney working for Tony Evers, just as the opposing counsels are attorneys working for Tony Evers. There is no distinction. The police officer in here is a police officer working for Tony Evers. And that's, I think, the big distinction here is there is really no separation of any kind. I've had contentious ERD hearings, and I've had issues with recordings, and we'll get into that when we go further on the timeline. But I've never had outright physical intimidation and threat of the use of force by the state of Wisconsin, by an ALJ. And when we go over the 9 powers of the ALJ, as I'm sure we will this weekend and beyond, we'll look into them and see where it says that the ALJ can bring an intimidator to the hearing. Because, make no mistake, that is the message here that we are getting, that this judge will try to throw you in jail and have you arrested. If you fall out of line of her understanding of her rights and authority in this case. And as we've seen before, both on the facts and on the understanding of law, there is some room for doubt here as to the extent to which this judge is fully aware. So, moving on from March 8th and where the tribunal told the parties that she had no idea of the contents of the video, that she did have an idea of the contents of the video, we go to March 15th. Now, on March 15th, the tribunal and the other ALJs met together, of course also Ramona Natera, the appointing authority, who, by the way, is appointed by the appointing authority, Amy Petchacek, who's not only a witness in this case, but also the person who can have this tribunal terminated, is also an actor in this case as well. At that time, the ALJs met and discussed many subjects that they placed on an agenda. One of the items that they placed on the agenda was a ethics opinion by Tim Pierce of the state of Wisconsin's Ethics Hotline and other resources about attorneys recording conversations. And what's interesting about that is, in no doubt was it that the conversation that we're discussing was the hearing, that the link of which was sent to this tribunal. And the reason we know that is because within moments of this counsel here sending to Maria Selsor the recording, the link of the recording of the video that this tribunal didn't know, wasn't aware of the contents of, Maria Selsor then Googled and downloaded the ethics opinion about the recording of hearings that they then shared and discussed on March the 15th. And I have it as March the 18th, but according to the tribunal, it was March the 19th. The parties met, and we had an interesting set of conversations. The first thing that we discussed was, for some reason, the tribunal at that time was not on camera, would not show her face on camera, and refused to participate in that hearing at that time on camera, which we found to be strange because such a thing had never happened before. Certainly at that time we were not aware of the department's meeting and the quarterly conference with their appointing authority. But nevertheless, we asked this tribunal why she refused to be on camera. And what was troubling there is that we got 3 different answers at that time. One of which was that this was a telephone conference. Another one was that she didn't have to hold the conference for any reason at all. A second one, which the problem with both of those things was that there was a Teams invitation and that the tribunal was merely switching off the camera. I think we went back and forth and were ultimately given another reason, I think, that did not pan out as I recollect. At no time did the tribunal divulge to the parties that 3 days or possibly 4 days before that, that she had engaged in a conference with both her peers and her boss regarding the recording of ALJs. Now, not only did the tribunal give reasons, now 3 reasons, 1 reason possible, 2 reasons they might conflict, okay, but 3 reasons, that at that point it is sort of with credulity, it's difficult to understand why anybody would be expected to give faith or credit to any of those 3 reasons at that point. You would think it would only be 1. Many times the truth doesn't need 3 different reasons. Sometimes it might, but I've never experienced that. Now, those at no time, and this is going to be another issue that we're raising here, is that was the tribunal candid with respect to explaining to the parties that it had had this conversation, this communication with not only her boss, Maria Celsor, but a official of the agency, that is Ramona Natera, which she is required by law to unquestionably, and even this tribunal admits, that she is required to divulge her communications with Ramona Natera. But in fact, she did not do that. For some reason, she thought apparently that there is an exception in 22750 for public records, which was also interesting because on that day that the tribunal said that we couldn't have, she wasn't going to tell us about the her conversation, her communications with an official of this agency, which again she's required to do by 22750. She said that there was an exception in Chapter 19. That's the public records law. And although she didn't explicitly reference it, she was talking about the case in which J.B. Van Hollen and others have a staff, what they call the staff training session, and refuse to give up public records on that basis. Again, there is no exception in 22750 for the public records law. There is no common law exception. There are none of those things. And certainly that was extremely troubling because, again, it gives the appearance, and I believe this is sometime in the end of July, and I'm skipping along in the chronology, and forgive me, Lurk attorney that's reading this, but let's be clear, things have jumped around a bit, and we only understood things when we understood them, because they didn't divulge things to us contemporaneously, which is what we're complaining about. So, again, in March, we had this pre-hearing conference in which the tribunal discussed ways to prevent this attorney from recording and otherwise having access to the performance of the ALJs, and one can only surmise that's for the specific purpose of impinging on the First Amendment rights of some, and keeping their activities out of the public eye and preventing democratic scrutiny, which I submit is an outrageous thing to do when you're a public employee accepting public money for doing a public job in public. But nevertheless, that seems to be the thrust of what happened, because not only that at that time did the tribunal not divulge that, but she directed the parties that they could not record any of her activities. She never gave any reason or justification, and merely directed us to sub G. I think it's 46, I think it's 22746 sub G, which this tribunal is attempting to turn into a plenary power, meaning the can direct or control the course of the hearing. How that's a grant of power from the Constitution, I don't understand. How that allows this tribunal here to bring in a police officer without reason or any stated reason, it's not clear to me. Again, this all smacks of a bureaucrat protection decision, because as is required by both LRC, the Constitution, and due process, the tribunal needs to give the parties enough understanding of why she's making the decision so that it can be appealed and so that there is evidence of sifting and winnowing. And to do anything less, and this is why certain violations of due process, as this tribunal has committed, are automatic, that is per se bias. LRC has found this to be the case, the appeals court has found this to be the case, the Supreme Court has found this to be the case. We look to, for example, to New Rock. And what those cases stand for is that a judge's decision needs to be justifiable. There needs to be something in the record that shows that they chose this thing from that thing. And when there is no such evidence, we begin to wonder, because what does a judge do? A judge judges. And without actual judging, without any evidence of sifting and winnowing, without showing your work, like any good educator, the public, that's what we do, we educate bureaucrats, is permitted to be skeptical. Because there's no evidence other than the intimidating police officer here in the court today of why you would invite him. There's no evidence other than this meeting 4 days beforehand where you communicated with an official of the agency about recordings and whether it was ethical to not record somebody before a hearing. That's the only evidence that's out there in the record now. You tribunal have given no reason for your decision not to be on camera. And it's also particularly problematic when you have threatened to use your contempt powers and obviously have a police officer here to enforce your decision. I've never, ever, in the 20 years that I've gone to the state office building in the state of in Milwaukee, had a reception like I've had here today. I felt like I was a criminal who wasn't wanted. I don't know how others felt, but I've never seen such a thing. It was the message to the public, to the media, was loud and clear: get out, we don't want you. The message from this police officer is very loud and clear: get out, we don't want you. And your job here, tribunal, is to hear third-class hearings and nothing else. We are not here to protect you. We're not here to protect Tony Evers. We're not here to protect Ramona Natera. We're not here to protect Amy Petchacek. But so far, when you look at the actions of both this tribunal and the predecessor tribunal, there has been nothing but a vicious assault on the complainant in the defense of Amy Petchacek and Kevin Carr. And we'll go on. And, let's say, to be clear, an attack on the First Amendment rights, and whether knowingly or not, in concert with Andrea Olmenson's attack on the complainant's First Amendment rights, when she sent letter after letter after letter after letter attacking the complainant and the appearance of the complainant's attorney on YouTube. I can't think of a single of the 60-plus page motions that this respondent has filed nearly habitually that have not included comments about YouTube and a focus on the complainant's publicizing of this case. And why that intersects here back to the 22nd is that this pre-hearing order in this case, which we only learned by public records and not because this tribunal divulged it, went through at least 3 drafts with Maria Celsoor, which I submit makes the entire pre-hearing order invalid and void and completely illegal. The law gives the agency the power to give one person, and one person only, one employee of the division, the power to hear this hearing. They do not give 2 people the power to hear this hearing, and for good reasons, and we'll get into that. But this tribunal then passed off Maria Celsoor's work as her own and signed her name to it. And the problem with that is, because I have people who work for me, and they do work for me all the time. I sign my name to it, nothing wrong with that. Sometimes they do great work. Here's the distinction. When we get work from this judge, we are doing a bias analysis on this tribunal. And when it turns out that this is the same Maria Celsoor who within 7 minutes of getting an email from me on the activities of John Gelhard, looks up an ethics rule, who spends more time trying to get to the complainant, and ultimately finds John Gelhard's behavior perfectly justified, who holds conferences not on how to have a better DWD, not on how the state of Wisconsin can make things better for, let's just say, immigrant workers. No, you guys, don't spend any time on that. What you spend your time on is how can we keep ourselves off of camera because we can't have Ben Hitchcock Cross commenting on our activities. And that's, you've been caught red-handed, and you know it, and it really is disgusting, deplorable, and you thought you might get away with it.
Your Honor, may I speak, please?
Oh, yeah, I was going to give you time to address all of his stuff. I just don't know if you want to do it. I don't know when he's pausing.
I just want to object on the record to allowing him to perpetrate the crime of disorderly conduct any further. I believe that this is bad because it's it's now in the part where it's nothing but repeated insults. It's abusive language. Earlier he was unreasonably loud. Constant insults. I don't think that this is far different from Mr. Czaplinski, Walter Czaplinski, in the famous Czaplinski versus New Hampshire case, calling a police or calling an officer or a governmental employee a damn fascist and goddamn racketeer, etc. So,
with the exception, I will note that Attorney Hitchcock Cross did not swear.
Right.
Okay.
But, yep, but other than that, I believe that this has devolved into simply a series of defamatory statements, repeated insults, and at times unreasonably loud, which I believe violates our disorderly conduct statute. I certainly feel disturbed about it, and I don't like having to listen to disorderly speech. And in any event, I have certain rights as a crime victim in the state of Wisconsin under the Constitution. And involves being protected by the state from the perpetrators of crimes, and this crime has been committed in my presence. The insults have largely been directed at the tribunal, but they have also been directed at me. So I just want that on the record, that I really don't believe that Attorney Cross is engaging in any sort of proper advocacy here, and that nor do I believe that he should be allowed to continue this sort of ongoing, disorderly, insulting rant.
Thank you.
Thank you.
So
Attorney
I'll
Cross.
continue there if I might.
No, I'm going to say something now.
Oh, okay.
Much of what I have heard has already previously been addressed by this tribunal countless times, whether it's in decisions, emails, motions. All of this has been spoken to. For brevity, I will not repeat my answers, my decisions, my explanations, my orders. I will incorporate all of the record in terms of once it was handed over to me in March, all of my responses and emails to date into the record, and whatever decisions I have rendered stand. So
Great,
is there
thank you.
another motion you have?
Yeah, thank you.
Because I
appreciate
would,
that.
because if we're just going to continue to comment on grievances as opposed to an actual that has not already been heard, because we're not going to keep repeating. Decisions have already been made, and the decisions are what the decisions are. They're in the record. They're in the file. You can bring up each and every one of these things, on appeal to LURC. To do them again now when we already have rendered decisions, the decisions are what they are. I'm not changing my mind. I'm not doing any of those other sorts of things. And so that's kind of where we're at. It
Great,
is
I
now
appreciate
7:17. This hearing was supposed to start at 9:30. So I'm going to give you a few minutes more, and then we're moving on. So please, sir.
Sure. So, and just to clarify, I think when you're saying that you've given decisions before, you have never responded one time to the fact that you've had somebody else draft your opinions in this case and not divulge that to the parties. There's been no response from this tribunal of any kind on that issue.
Well, first off, nobody's drafted any opinion for me. Nobody's written any opinion for me. I write my own opinions, and my decisions and orders are mine, and I stand by that.
But then the problem is that that's simply not what the evidence is. The evidence
Well, that
here,
is your opinion, sir, and I'm simply telling you that that's not how this works. So if you want to move on to something else, that's great, but we're not going to keep going over emails from March 1st, what happened on March 6th. Everything's in the file. I've already explained, and I'm not going to continue to repeat myself. It just becomes redundant at some point. And it really serves no purpose. I realize you may not like the answers you've received, and that's okay. You don't have to. But they are what they are. So if we could please just move on, it would be greatly appreciated, sir.
right? And again, the problem with that ultimately is that you have, when you say you've responded, you've not actually given anybody, there's nothing appealable to a non-responsive answer on what it is, why you think that sending 3 drafts back and forth to your boss is you writing the decision.
It's not a decision. Understand what you were talking about. This is a pre-hearing order. At the time I was assigned that case, I was a project ALJ. You always have to send to your supervisor to make sure whatever law you've cited is correct and that sort of thing. And that is my work product, to verify that what I'm sending meets with agency standards. She doesn't tell me what to write, how to write it. She might correct a spelling error. She might say this is not necessary, this is too long, just those types of things. But the actual decisions of what I do in a hearing, those are mine and mine alone. When I write a decision, those are mine and mine alone. And that's the last I'll say on this. Okay?
Is your recorder on? Did we get that?
Of course, it's
recorded?
all been on.
Of course, but I can't tell you how many hearings I've been in.
I don't know what's happening.
I can't tell you how many hearings I've been in.
Excuse me.
Where the hearings have not been recorded.
And that very well may be.
Push the button.
That very well may be.
Sure.
But I can't speak to what another ALJ has done.
Mm-hmm.
I can't speak to what has happened in anything else. I can only speak to what's happening here. And the recorder's recording.
So,
okay?
but you're also forbidding anybody else from making any recording. You've got an armed officer of the state to make sure that happens, and that is an issue because there's no redundancy or any way anybody can check. So it is actually very important that we, based on our knowledge and experience with other ALJs, that we make sure that you're actually recording here so that it's not just your notes, again, or your recollection, and this issue that I just raised here is brand new. You may have put it on the record, but I hadn't spotted it, that you said that you didn't know the contents of the video when you did know the contents of the video. Okay. That was not brought to my attention until just this week.
I don't understand, because the video, all the emails, this is the only one I will discuss with you. All of the emails were in there. And I do not know the contents of the email. And I'm unaware of the contents, and I will explain for the third time why, sir. I didn't view it. Somebody could tell me it's a title, like you did. This is a Gellhardt hearing. Okay, what does it have to do with this? What does it have to do with anything? It's a link. I don't know how to upload that. I have to ask somebody, what do I do? Remember, I'm just project. I'm new here. So I have to ask my supervisor. I don't know if I should be looking at this, if it might contain information that I'm not supposed to know, because I'm de novo. I look at everything brand new. It doesn't matter what happened before me. This is what I'm supposed to do. So when I haven't personally seen it with my own eyes, listened to it with my own ears, know who's in there, all I know is that the same thing that you told me, it's a video. I am unaware of its context. I cannot speak to exactly what is on it, who said what, who was standing where, what evidence was submitted, what was going on during this hearing, what was the demeanor of the parties, what was the context of what anyone was said, because I did not watch it. Okay? I'm not going to rely on somebody else telling me, hey, this is what's in it, without me personally having seen it. Other people might, but that's not how I operate. So, I stand by my email. I'm not aware of the contents. I have a vague description. Apparently you didn't say anything, but all of those emails and that correspondence that I had is in the file, and it was uploaded to the file on the same day. So to say nobody was aware, it's in there. Nothing's been hidden from you. I'm not sure what's happened in the past with other people that you've dealt with, but every correspondence that I've had pertaining to this case is in this file.
So we just can't let that stand. We just can't let that stand, because now I got to get that on the record. You put some factual assertions on the record that are just false. So to be clear, in this case here, we've had, you tried to put things in the record by putting them on the portal. That was a failure for several reasons, because you didn't ultimately notify the parties of several decisions that you were required to notify them of. And more importantly, there were several of your decisions that simply were not available on the portal. While they may have been available at some certain time, we had to go around, and you played this gaslighting game with us before, where you pretended like it was all our fault, and we should move on because it wasn't uploaded to the portal. It may have been on there there, but it wasn't visible. And we had to remind you 3 times about that issue, and 3 times you told us to move on without addressing the issue, much like you're doing here now. So that needs to be clear on the record, that saying that things were in the portal is not a substitute for sending them to the parties, either by email, if that's what's in, because there's no mention in the pre-hearing order of the portal. There's no mention that we're supposed to be, because you're acting and sighing and looking exasperated as if the parties had always known that they were always supposed to look on the portal, and as if your office had always had everything uploaded to the portal when it was. Because we can easily remember a hearing in which I'm sitting there arguing the wrong motion because the motion that was supposed to be argued was not actually uploaded to the portal. That's when I'm referring to 3 times I brought that issue up, and 3 times you told me to shut up and move on. That's what I'm referring to.
First off, sir, I've never told you to shut up, so please don't say that. That is disrespectful, and I will not tolerate disrespect. It is uncalled for. It is unprofessional. I have never told you to shut up. I don't use that word. I don't use it in my home. I don't use it in my personal life. I find it a very disrespectful term.
You know what I find disrespectful is when you
it.
say that you responded to something that you did not respond to, and then now you're focused on a word that means the same thing to me. When you don't respond and tell me to move on 3 times, you can use all the profanity you want or not. But that tells me and my client just as loudly as having this police officer here, shut up. Okay. Don't go on YouTube, shut up. Just as loudly as Andrea Olmanson's First Amendment violation letters told me and my client to shut up and get off of YouTube, just as loudly as all the motions that you heard illegally. Yeah, okay, so let's be clear on the record here that we had a little snort.
No, I coughed.
Okay. So, now we're going on to my next issue, if we might, which is simply this. We had in this pre-hearing order that what we just heard from the tribunal is she drafts her own work, she does her own work, but she submits it to her supervisor so it can be edited for standards of the department. And how that's a different statement than saying that her supervisor is editing her work, I don't understand that, but maybe she can explain that to us at some other time. Because right now, that order said that there were to be no more motions heard after a certain date. No more motions. That's what it said. But instead we got 2 60-page motions. And we got a sort of jaunty letter from the tribunal telling everybody that as they knew that everybody was ready to these motions
I'm going
to
to
be
interrupt
heard.
you, sir, because we are not going to rehash everything that's happened in this case. The file speaks for itself. We've already addressed motions that have been filed. We had a teleconference on this issue last Thursday to discuss motions after August 8th were not going to be heard. They were placed in the file. If people wanted to respond to them, they could. You chose to respond to some. One I specifically asked you to because that by statute I have to rule on. These things were already discussed on Thursday, the 26th. We were not going to re-discuss them again now. Please move on, sir.
Well, so that's, and again, what I need to now respond to, so we're clear, Clerk Attorney, is those statements were not accurate, and the record needs to be clear on what actually happened here. So I was trying to get, I think...
There was a memorandum, and we're moving on. Please find something else you want to discuss.
So the week in preparation for this hearing, and I am making a motion here that we have been prejudiced by this tribunal because she forced us to do work after and violated her own pre-hearing order here. And so again, the fact that I'm trying to get out that this tribunal has interrupted me and now stated several times her opinion of what happened, but I have an alternative fact here, and I think it's important to note that that tribunal refused to allow that hearing to be recorded, but then here we have this issue. Now, we had a hearing that was foisted upon us without proper notice. That was completely illegal. The tribunal knew that by sending us notice for a hearing that was supposedly a pre-hearing conference. Now, we objected to all this in writing on the record, and Attorney Nola Hitchcock Cross sent at least one correspondence to this tribunal on this issue, because the tribunal at one point said that she was holding this conference and demanded that we tell her when it was available, that she was holding this conference by her authority, granted to her by the motion statute in, I believe, 218. I might have that wrong. I'll live with that. And that rule, I'm quite sure it's a rule, says, among other things, that when somebody files a written motion, the other party has a right to respond in writing. Now, at that time, the tribunal didn't give us any opportunity to respond in writing. What she did was try to hold a hearing for the sole purpose of dismissing out this case. And we know that for several reasons. Because she has a track record of doing this, and the last time that she did this, she did it illegally, and that is in the Ford versus MPS case. In that case, the tribunal found, without hearing any response or conducting a hearing, that because Dr. Ford supposedly, and again we say supposedly because Dr. Ford was never given the opportunity to put her side of the story on the record at all, the judge just simply dismissed that case out, threw it in the trash. And the problem is that Lurk told not only this ALJ, but also ALJ Gelhard the month previous that they couldn't do that. And so it was extremely problematic because the ALJs, and we know this because we have the emails where Lurk sends them their decisions, this ALJ got that decision, and yet she did it anyway to Dr. Ford. She did it anyway. Apparently there's a reception. There may be a witness. Come on in. Great.
Not ready yet?
We'll be ready shortly. Thank you. So, at that time, after the motion deadline was cut off, the ALJ heard from one of their motions saying that she could be heard at any time. Now, why that needed to be heard during the month that we were preparing for the hearing, I don't know. But this ALJ decided that that was appropriate. Okay, fine. So we responded, even though under protest. And then they filed a second 60-page motion. And the ALJ demanded that we appear at a hearing, that she didn't call a hearing, with our client there at the hearing. And we know this because of the notices that she sent out later. In her original email, she said it was the parties, but of course there was no intention of making the Department of the State of Wisconsin show up. No, the whole point was to have the employees show up for the express purpose of dismissing this case. And I would say at about any given time it went up and down. Mike, I'm sure, has the pulse of this a little bit better, that we assumed that this was about 80% sure likely to be dismissed, given the actions of the ALJ and all the indications that she was trying to hold a oral argument, a hearing with the complainant there for the sole purpose of finding out to what extent the complainant refused to appear at a deposition. Now, we sent her an email saying this is outrageous and a violation of due process rights. And she responded, and this is the second time this has happened, by the way. The first time, which is when her boss, Secretary Amy Petracek, filed a motion to suppress. She initially, this tribunal, didn't give the parties a chance to, the worker a chance to respond in writing. When she was called out on it publicly, she then said, of course you can have a chance to respond in writing, even though she put in writing that you can't have a chance to respond in writing. I'm going to make a decision. And so then we've fallen back, and we've heard this twice, that sometimes the complainant doesn't respond. So I just plan on making the decision without the complainant. So when we put that in writing, that you have to allow us to respond, and you can't just hold this hearing to dismiss us out without in writing, because, you know, there's this rule that says you can't, and you only have 9 powers, and you have to follow the rule. The judge then told us that we had about 3 days to respond to a 64-page motion. Never mind that I had a summary judgment due at the end of that week. Never mind that I had a hearing scheduled for every one of those days. Because why? So that this judge, in every appearance here, had every intention of dismissing out this case. Now, at some point, I sent this judge and her superiors, the one, that she checks with to make sure that her work product is okay. Those ones, but they don't change her decisions. It's her work product. She just sends it to them for, to make sure. They might remove stuff. They might tell her to change some things, but it's her work product. We understood that. I appreciate that because I think we've moved a lot further on that issue than we were before. And even though we explained to them that we couldn't appear, that we were otherwise occupied, that Nola Hitchcock Cross was giving a presentation at our nation's capital, nevertheless, the judge sent out notices with 48 hours notice, which is against the rules, which she well knew. She had the IT person do that. So we are sitting here freaked out, trying to figure out the whole week how the heck we are going to prepare for this thing, assuming and having to tell my client that this case is going to be dismissed because this judge has a track record of illegally dismissing out cases because she gets mad and takes it out on people. And here we are, and we are assuming that nothing's going to happen, or that this case is going to be over and done with. And lo and behold, we go into this conference that the judge did not record and refused to allow us to record. And the first thing that comes out of this judge's mouth is, there's no motions to dismiss. We're not talking about any motions to dismiss. We are just going to talk about the fact that the respondent turned in half of their exhibits after the deadline. And the problem is that it's astonishing because there are 2 emails from this tribunal saying the whole purpose and the invitation to the meeting says it's to discuss the respondent's motion to dismiss. So not only am I completely prejudiced in preparing for this case here, because the judge decided that she was going to do something completely illegal that she knew, but she backed off at the last minute. She backed off at the last minute. We don't know why. Maybe one of her supervisors gave her a normative instruction. We don't know. She hasn't shared that with us yet. Maybe it was an official of the agency. We don't know. We can only go on based on the information we've had in the past because people's past behavior reveals their future conduct. So, again, we've got this email in which the judge says she doesn't know the contents of a video in which she was just told. Okay. She has a response for that. We've got several decisions that she says were her decisions, but yet people gave input and so forth. Maybe that's just sort of a issue of definition. But here we've got this third issue, which is not only completely prejudicing the worker, it is just an outrage. There's absolutely no question that the whole point of what the ALJ was trying to do was to dismiss out the case. And for her, the point is here, and I think that we all need to be clear, Lurk, and we all need to be clear, Circuit Court, and we all need to be clear, Appeals Court. The tribunal prejudiced the respondent just as much. Because by hearing, remember when the tribunals told the parties that they had to be nice to each other, and then the respondent went and filed all of these ad hominem attack after ad hominem attack, and the complainant went to the judge, and the judge did nothing. And then they continue to file ad hominem attack after ad hominem attack, or they continue to file things late and you allow them to do it, or they file after there's one rule for us. Oh, and let's remember, during this whole time that we're supposed to respond to their motion to dismiss, there was an outstanding, fully briefed motion that the judge had never bothered to respond to. And then when she did bother to respond to it, she completely denied it with no analysis of any kind in less than 3 hours. And if that's not prejudice to the complainant, I'm not clear what is prejudice to the complainant. But again, the respondent here thought that they were used to this kind of behavior. They had been encouraged. And when you hear a child screaming, you don't blame the child. What other powers do they have? They have to scream. And you know why? Because they get what they want when they do it. And when the tribunal time and time again goes against her own secret rules that she made in secret with her supervisor, it's a problem because the state of Wisconsin got used to having its own way. And then for some reason, something happened at the Department of Workforce Development, who knows what they got, but all of a sudden from one day to the next, we were going to have a motion to dismiss And then the next we're walking into a thing assuming that it's going to be dismissed because this is what this judge does. And she says there was never going to be any discussion about a motion to dismiss whatsoever. And that, I think, is the final nail in the coffin here. There is no dispute that there was absolutely no way for this tribunal to sit here and say, we're going to hear a motion to dismiss, and then when we show up, say we were never going to hear a motion to dismiss, and expect that we can have any faith in your decisions. That, I say, is the motion here. So we've been prejudiced.
What?
You look like you're bouncing up and down. Like you're,
It's extremely distracting, your behavior, Andrea. It's extremely
you
distracting.
look like you're struggling to breathe.
Are you okay?
I'm fine.
Okay.
Are you all right?
Then we have, this judge needs to recuse herself. She should have recused herself. The problem is that on that motion to recuse herself, she went to her supervisor on 2 occasions. And of course, they haven't shared those drafts with us because there's their secret work product. But the problem with that then is we can't trust that this judge makes her decisions because the track record is she doesn't. And she's admitted here now on the record that they add and they take away. And that is what you call drafting a decision, altering a decision. When somebody gives me their work and I add and take away from it, I don't suppose for a second that my influence is not on there. Now, Maria Celsor is biased towards me, and that's a fact, and we've got that demonstrated. The problem here is that because this tribunal is not coming clean with how these decisions are being made here, we're not able to fully do that analysis. So LERC, so Circuit Court, so Appeals Court, we need to be clear here. This judge needs to be recused, but also there's a bias problem with the entire department because Maria Celsor is making normative and actual decisions on behalf of this tribunal. This tribunal needs to recuse himself because on at least 3 occasions, and for certainly 1, they have misrepresented facts to the parties. And specifically, and most recently, not even a week ago, this tribunal represented to the parties in writing 3 times that we were going to have a hearing for oral discussion, oral argument on the respondent's motion to dismiss. And instead, we heard something quite different. And mostly what we were focused on that was the tribunal's insistence that they not be recorded. So when we look at the pre-hearing memorandum that the tribunal did, and why did they do it? Because yours truly sent the tribunal an email that morning reminding them of the law and that they had to file a pre-hearing memo because they refused to record, and not just because. It's extremely problematic when we have these conferences, these ALJs write these memos, and they forbid us from recording them because we can't have any faith given their secret, for lack of a better word, discussions and with their supervisors. So for all of those reasons, you have not only biased yourself and need to be recused, but you have significantly prejudiced the employee from putting on this hearing here today, not just with your decisions, but with your attempt at the last minute to try to dismiss this case and then telling the parties at that. I mean, I've never seen anything like it. She's castigated the respondents at the hearing for not doing something that she was telling them that she was going to do. Namely, it was the respondents' fault for not asking for an extension of the timeline from before. When she told us in writing 3 times that she was going to hear this motion after she said it was the deadline. And we waltz into this thing that she wouldn't let us record, and she says now all of a sudden it's the deadline. Well, who's paying for my client's time? Who's paying for all the harm that she had to spend trying to respond to this, dealing with this, the agitation, the aggravation, and now we're sitting here today. This hearing should not be going forward, not only because you have a police officer here, not only because you're biased, but because you sabotaged us at the last possible minute. That is what a motion cutoff is for. And to have a hearing and a deadline the week of is outrageous. It's absolutely outrageous. And it only fell on the employee and not the employer. So I think we're at 5 times here, Judge, when you actively put your hands on the scale. You need to remove yourself. And it saddens me that we have to say this, and you can take offense to it if you're not, but 3 times, Judge, when it can be called into question, and one unquestionably, when there's 3 times you said something that you later then said wasn't the case, you should really think about, are you able to continue practicing law when you are saying one thing one day and another thing another day? Because when you write decisions on behalf of the state of Wisconsin, the people whose lives they affect, and the workers, in this case here, it's our allegation that a state employee was humiliated and had her boobs grabbed, is the word she would use, in front of all of her colleagues at a work party. And that should be what the issue is here, but instead you're focused on denying her First Amendment rights and prejudicing her. And but for whatever we did at the last minute, we wouldn't be here today, and we all know that's the case. So with that, I'm ready to continue. I'm sure they'll have something to say.
Attorney Olmanson, Attorney Zakard, anything you want to do?
Well, I think that the record all speaks for itself. We know that this has been nothing but a series of misstatements and reversal of victim and offender. People who lie under oath, lie in pleadings, don't play by the rules and laws that everybody else is expected to play by. Let's see, what should we say here? Don't cooperate with discovery, have to be compelled to cooperate in discovery. Let me see, don't show up for a properly noticed deposition. Pretend not to understand things. Pretend that the law is something other than what it is. The record speaks for itself. I would just as soon get this show on the road and have the witness come in and testify, and we can get moving. Let me see. Attorney Cross started his rant at 9:35 a.m. That was an hour and 11 minutes ago. So we probably could have gotten through the first witness by now. So that's what I have. And then one thing that I would like to say is unrelated to this. We have not been able to download the Bates stamped complainants documents. So from the portal. So what I have done is I Bates stamped our documents, and I hope that they line up with what's in the portal. They appear to. I started on the first page with the same number that it says in the portal that they started with, and the number of pages matches up. So
We'll fix it if we need to.
Okay.
That's not a concern.
Okay.
Okay.
Thank you.
All right.
And we were able to download the respondents, or the complainants, by the way. It's the respondents that we couldn't download.
Okay.
Yeah.
All right. Well, I've heard all of these objections. Again, the record speaks for itself. Most of this has been, all of this has been discussed numerous times. Decisions, explanations, that sort of thing. And I am not going to recuse myself, despite repeated requests of same. These have been explained repeatedly. I do not feel there's any bias here one way or the other. I've always advocated for the parties to simply advocate for your client, and zealously doing so. And that, that's simply just it. I think the memorandums and everything else speak for themselves. So, at this time, I'm going to ask
Sorry,
Attorney Cross.
I did have one last thing, and I appreciate you indulging me here. At the last hearing that we had, the judge said something, and I want to be clear that it's on the record. It's something along, and I'm admittedly paraphrasing, that we will have to let Lurk sort this out. And what I took that from at that time was that she had had the instructions from her supervisors to conduct this hearing, do whatever she needed to do to get through it, and then to allow LERC or other appeals bodies to go from it from that point. So when we were talking earlier that it was night and day the difference, and it seemed like our message had some effect on this tribunal, I think that, to be clear, that was the effect that we understood it to be.
Well, your understanding is incorrect. This hearing was always going forward, as I stated. There was not a hearing last week. It's been completely delineated multiple times. It was simply just a teleconference. I began that teleconference explaining why I am so confused as to why people kept turning in motion after motion after motion after the deadlines. Even though the deadline was clear, it still kept happening. I informed the parties in emails. The file that's just going into the file. All the documents going into the file. I'm not doing anything with it. You know, some of them the complainant responded to, some of them they didn't. I did request that the complainants did in fact need to respond to the 227 483 motion, because that is a motion by statute that I have to hear. It supersedes you know, and any scheduling order I may issue. And it must be filed prior to any final decision being rendered. I felt it easier to just, everybody put their thoughts, put it down. You had your 14 days, you submitted it timely, so that I had that done prior to this case actually starting, rather than instructing people to do so mid-hearing, which I would find much more disruptive. I did bother to let everybody know that there's no such thing as a summary judgment, and went to great lengths to explain that. There's only certain ways that a case can be dismissed after it's been certified to hearing. I explained to the parties again how that works. It's 218.10, which refers you to 218.05. I went through all of the 4 specificities, explaining that none of them pertained. The complainant is protected by the Act. The respondent is subject to that Act. The complainant does state claims for which there's relief under the Act, and the complaint was timely. So any dismissal of this case would be highly inappropriate, much less, you know, there's no such thing as a summary judgment proceeding. I was interrupted quite a few times by the complainant, so I didn't get a fine on. But I just simply, because a response has not always been filed on these late things, I just wanted to give you an opportunity if there was anything you would wanted to add to that, but you wanted to discuss other issues, and that's how that hearing moved on. But nonetheless, and I explained the exhibits were in the case portal, they're bait stamped, and the hearing would proceed promptly this morning. Again, all of those were my decisions solely. Took a while to draft the memorandum, but that was placed in the file and provided to the parties as well. So we are here, and Attorney Cross, your case. So if you would please, sir,
Great.
Call your first witness.
I will. I just have one statement to just to clarify there. On the 2
no,
emails,
we're not going to clarify anything.
Sure.
You can submit it in a post-hearing brief if you'd like to. I really would like to move on. We are now at 11 o'clock. I normally start testimony promptly at 9:30. So I believe, let me see. What was your witness's name that they said? Alicia Bischoff?
Yeah, we'd like to do the telephone person, Miss Allow now.
Well, Attorney Cross, we have a problem with that. You sent an email on Friday requesting a remote witness. I sent you an email in reply after I was done with my hearings, which lasted all day Friday. I tried to respond to things in between. You unfortunately did not respond. As of this morning, you still have not responded to that. It's a little late when a hearing starts on Monday to discuss I want a remote witness. When we sat for the pre-hearing conference, I gave the parties at that time opportunities to how we wanted to do this. A majority of people prefer to hold the hearing, by video, by Teams. It's convenient for the parties, for the witnesses. Nobody has to sit around and wait all day, waiting to be called. You don't have to worry about travel, hotels, witness fees. It's just parking. It's just easier. You insisted on an in-person hearing. I gave you the opportunity at that time, a variety of different things. So we're here in person. I asked you Friday, and I notified everyone that you were requesting an out-of-state witness to appear by phone. It was extremely late notice, especially since we have this here in person that you requested. And then I stated that prior to any decision, further information was going to be required. I asked you to provide the name and address of the proposed out-of-state witness and any other witness you wish to share regarding the importance and the necessity of this witness to your case. I then allowed the respondent to weigh in briefly, 1 page, as to their position, and I would like to congratulate you all on doing something in simply 1 page and not 537. In any event, I've waited all weekend. I've checked my email throughout the weekend, Friday night, Saturday night. Even this morning, I entered this building probably about 6:45, and I still have not heard from you as to who this witness is. At this point, it's a little late to say, I want to call so-and-so when we don't even know who that person is. I don't know if they have any of the exhibits that either you want to show them to cross-examine, to direct them with, or whether the respondent has been able to show them any exhibits. They're not going to be able to verify anything. It's extremely late notice to do so. So I don't know whether this is a key witness, if it's a peripheral witness. I know nothing about this individual.
Why does that matter?
Because if it's a key witness, like let's say perhaps it had been your client, I would have wanted them to testify in person. That's a primary witness. Okay? But I don't know. I mean, as to what they're talking about, I don't care. I don't want to know what their testimony is going to be. I just want, what I simply asked you, was it a necessary witness? What was the importance for you being able to prove your claim? So that weighs heavily in my decision. But you responded to none of those things, and now you're coming in here, again, it's at 11 o'clock, to say, oh, I want to call our remote witness. Did you wish to add anything since you did not respond to my email?
Sure. Like I've said, Judge, you've had us running around here responding to things that you didn't ask us to respond to. So it's greatly prejudiced our ending. Her name is Kelsey Allow. She is going to be a witness to the fact that she suffered similar sexual harassment at the hands of Alicia Miller, as did the complainant. She has a former employee of the department. She has since moved out of state. I believe she's about 200 miles from here in Illinois.
Responded.
The Alicia Miller claims were the no probable cause claims that were appealed and then were dismissed.
Yes, I'm aware of that. But he said Kelsey Allow did what?
She's got a discrimination. She experienced sexual harassment at the department and how the department dealt with it, and that's what her testimony is about.
Didn't he just say experience similar harassment at the hands of Alicia Miller?
Yeah, Alicia Miller, there's no doubt about it. Right.
The Alicia Miller claims are dismissed.
They are. They are dismissed. That was part of the probable cause. I think I have more trouble with this late notice of finding out that that's who this witness is. She's clearly on his witness list. That was filed timely. So the parties did have notice that she was on the list. And I'm looking at this, I believe she's number 12. Miss Miller is number 6. The probable cause portions have been dismissed. That's the Alicia Miller, all that. That's not, and we can argue the relevance and objections as each witness is called if you have an objection at that point in time. I will always hear from what the objection is. I will then ask for a response to that objection, and then I will ultimately make my decision, and then we will move on from there. We're not going to go back and forth.
Excuse me, though, Judge. I know she's available today now. Would it change the decision making if we were talking about Wednesday, for example?
I'm sorry, I didn't hear that.
Okay. Attorney Hitchcock Cross has said he knows she's available right now this minute. What he wants to know is anybody's opinion change if he were to call her later, say, for example, Wednesday. I don't know I'm not understanding the relevance of her testimony if she's going to be corroborated or corroborating any testimony as it pertains to Alicia Miller, since those claims have been dismissed. I'm not understanding.
Well, sure. First of all, I don't know that they have been dismissed. I know that what is at issue here is whether or not the department, let's say, condoned or allowed sexual harassment. And to the extent that they condoned or allowed sexual harassment with Alicia Miller, I don't know that that's not at issue here. And second of all, I don't know how the fact that, let's just say, all the claims for Alicia Miller were thrown out, or, that's what Gelhard did. Let's just assume that that was the case. That still would not mean that how the department responds to this person, Ms. Alau's claims here is not relevant to whether or not the department responded to Ms. Stolar's claims appropriately. So I'm not clear how this could possibly not get in. I get what you're saying about the time. As to that, I mean, if there wasn't an issue from Friday night at 5:30 till this morning, and frankly, I was preparing for this hearing, so I may not have seen the email, but nevertheless, that's why I suggested till Wednesday. That would give you a full 48 hours for whatever other issues that may need to be resolved.
Okay. Just give me 1 second, please. Okay. So the two claims that were in the probable cause portion dealt with discrimination against the complainant in terms or conditions of employment because of sex. And they had it in brackets: discipline, harassment, intimidation. And then the second one, discharging the complainant because the complainant opposed discrimination under that act. And that was a claim of constructive discharge. Now, because I have not read anything pertaining to the probable cause portion, okay, it didn't apply to me. So this is the first time I'm looking at what these claims are, okay? So I'm simply asking, because I don't want to sit here and read 500 pages of documents. So if the parties could please educate me. Mm-hmm. Did those discipline, harassment, intimidation claims, were they based on the Alicia person?
I would say, yeah, I don't disagree that she would be, for lack of a better word, the central bad actor in that case, as opposed to, the problem here is, and that case is also talking about constructive discharge.
Right.
And that constructive discharge is clearly related to the Teutons and the fishing expedition, for lack of a better word. So and this is why the department writes these like this. What I understand is at issue is not the discharge, is the
Correct.
terms and conditions of employment, and whether or not the respondent appropriately responded to her discrimination. And so I would submit, and I haven't seen that. The other hand is we never had a hearing, so it's hard to know. There was no issues fleshed out.
Okay.
Right, it was immediately dismissed at the thing because I didn't supposedly respond to Gelhardt immediately. That's what you would have seen had you actually watched that video.
So at the probable cause hearing itself, that's when it got dismissed?
That's right. For supposedly not responding to Gelhardt within 3 seconds.
Did it get dismissed at the probable cause hearing? That's what I just want that. Is that
Yes,
so you're
it
there?
did.
Yes or no?
It did.
As to why, that's a whole nother. I'm not getting in the middle
Sure,
of
but
that.
we don't dispute that. That it was
Okay,
dismissed
but
at the
that's what happened.
That's
Okay,
correct.
so we don't know the outcome because testimony, none of that stuff
That's correct.
ever happened.
That's
Okay,
correct.
all right. Because I know I'm just supposed to hear as to whether engaging in or allowing sexual harassment, not so much that this particular person intimidated me or this person harassed me or this, other than what we have here that happened allegedly at this fishing thing, right? I just know it was a fishing thing and something happened so it shouldn't have happened, therefore we're now here. And
Right.
then what did the department do or not do to either have prevented it, adjusted it, taken immediate action to correct it, and what flowed from all of that? Okay?
Yes, and my understanding that she made complaints from the Alicia Miller one, and the question is how were those responded to appropriately?
Well, that part of it's dismissed. So the Alicia Miller stuff's going to be,
How so?
well, if she was the one that she claimed originally had harassed and intimidated her and caused issues, that portion was part of the probable cause. That's what I'm just asking.
I disagree with that, and I think that both Alicia Miller and Teuton and Hartzheim did all of those things. And
Okay.
the question at issue here is whether or not how the department responded to those things. That I think is the issue. I don't have any evidence. We're not the determined. All those things are not in the record, and the only thing that we have to guide us here is the statement by the certification to hearing, that's my own. Based on
that's all I've got.
the
Like
work
I
and
said.
everything. That's my only understanding, and what you've said before. So
Yeah,
I just don't.
so-
The
so I
cabining, I don't get yet. I don't get because the complaint refers to both Miller and Hartzheim and Teuton. It does not necessarily refer to one or the other. I'm hearing murmuring, so I assume there's some disagreement from the other side.
I'm sorry. I have I don't know if it's mom ears or what, but I have a tendency to turn out peripheral noise, and I only focus on the person that's talking. It drives my kids nuts. But
I adjusted, but I understand. But so she seemed like she needed a chance to speak, and that was only.
okay.
Yeah.
Like I said, I apologize. I wasn't here. I was engaged with you. Okay. So, which one of you?
Well,
Okay.
first of all, I just wanted to indicate that Ms. Lau has a pending case that has not had a decision on probable cause yet. She was not an employee at the same time as Ms. Stolar,
Okay.
so they didn't work together at all. And in terms of what the issues were on this case, I submitted a letter to the ALJ that spelled out the different portions of this complaint, what was going to be heard at the probable cause hearing, and there was a ruling on that. So
Okay. Again, didn't read it. Not me.
mhm,
I was very clear on that.
yes,
Yeah.
my understanding is that the only issue is the sexual harassment.
The sexual
which-
harassment which occurred at
the fishing.
the fishing and everything that stemmed from that.
Yes.
Okay, at this time, unless you have another offer of proof, and I'm going to give you an opportunity to do that, sir, not right this minute.
I understand.
You're busy. Okay? Then perhaps we might hear from her. But at this moment in time, my ruling is no.
But so I understand for the offer proof later, on the issue of relevancy, or I'm not clear?
Well, I don't see how she has any, relevancy primarily because I don't see where it's a portion of the case that's before me. And I guess if you could clarify that for me, because I'm just missing it. I don't see it.
And I get that. Here's my problem with your request. When you're saying how can I clarify it for you, I don't know how I could do that without appeal to extrinsic sources. So I think I could clarify it by explaining to you we could look at what happened in the other hearing, but I think again it's what's certified to this hearing. That's the only thing that's plus the complaint. So the complaint says Miller, it says Teuton, it says Hartzheim. The certification says terms and conditions, and that's where I'm at.
Yeah, basically it's engaging in or allowing sexual harassment. I mean that's pretty much it. That's what I'm dealing with.
Right.
But it's the other stuff I think was delineated into as far as discipline. That's got to be the Alicia person, I think, because I think there might have been some allegations that she was picked on, she was treated differently when people came in the room. They asked her to do stuff that they didn't do with other people, like when she checked in. You know what I'm talking about? When you come in the building and you swipe or do whatever. And that there was some intimidation factor there, maybe because she's her supervisor, that kind of stuff. And then general harassment that she was doing from that.
Right, and why can't we discuss that?
But that was harassment. What we're dealing here is not general harassment. It's sexual harassment. That's what I'm doing, engaging in or allowing sexual harassment.
Well, now
the only sexual.
Excuse me.
I'm going to give you an opportunity to tell me where I'm wrong, because I very well could be. That's why we're talking about this, okay? What I have is engaging in or allowing sexual harassment. I'm not aware of any other allegations of sexual harassment other than with the guy who allegedly, squeezed her boobs, right? And then you've got the other one, I think his name is Hart. I don't know who these people are. But there was somebody else who said, can I see him? That kind of a thing. That's sexual harassment. That's what I see as the claims for sexual harassment. I'm not aware of engaging in or sexual harassment from the Alicia person or anybody else. That's why I say those portions were in the probable cause. So I don't see what that has to do with what happened at the ring.
I got it, and I appreciate that. And that's a really good example of why you shouldn't be on this case. Because the problem is that that's a statement of prejudice and bias to the fact that apparently there is a belief that, and we're going to use boobs, I'm going to use boobs throughout the rest of this hearing because that's the word my client used. So it's not my preference, but that's what we're doing here. The fact is that we submit that and allege in the complaint, more importantly, that but for my client being female, that Alicia Miller would not have treated her the way that Alicia Miller is alleged to have treated her. So when you say things like boob grabbing and show me your boobs are examples of sexual harassment, that's fine, but that limited view of sexual harassment is problematic, again, for two reasons. A, because it shows that you're wedded to the pre-conclusion, and two, because it allows, again, but for the fact that she's female, she wouldn't be treated this way. And that but for test is the important thing in any kind of discrimination that we're talking about here. So, for example, some people don't like women who have blonde hair, okay, for example, and but for you having blonde hair, I'm going to sexually harass you, okay? Right. Some people don't like women who conform to other ways to gender stereotypes, and they get discriminated against for those reasons.
Well, that's why I'm asking. Was there a sexual harassment allegation of Alicia? That's what I don't know.
But it's in the complaint, so that's the problem.
But again, everything's all convoluted in this complaint. When I read it, some of it just simply did not make sense. So I'd rather ask people than assume. So
I understand.
you're saying there's a sexual harassment portion that pertains to Alicia that would have continued on to the merits portion.
Yes, ma'am.
That's what I want to know.
Okay, and one thing, can I suggest then that we tell this witness that she, in fairness to her, that she won't be heard today, and that we either make a decision after that or something else?
Absolutely.
Okay.
Yeah, don't keep her waiting.
Can we I
Okay.
do that?
All right. Did you hear his position?
Yes.
Okay. Now I would like to hear from your side as to whether he says that there's a sexual harassment portion, just like there is in regards to, where is it? That Alicia Miller is still included in the part of the merits hearing where it says that the respondent engaged in or allowed sexual harassment.
No.
Wait a minute. First, let me make sure. I don't want to speak for Attorney Hitchcock-Cross. Did I say that right, sir?
Yes.
Okay. All right.
Do you want me to respond?
Sure.
Okay. There was initially a split decision.
Yes.
Or what can I say?
Hybrid.
We call them a split.
Determination, split decision
whatever.
by the investigator, probable cause and no probable cause. The Alicia Miller claims were no probable cause. That's what was at the probable cause hearing, or that's what was taken to the probable cause hearing, where no witnesses were called and the complainant didn't show up, and those claims were dismissed. That's cutting to the chase.
Okay. And Attorney Cross's position is that while the no probable cause portion of this complaint was dismissed at hearing without hearing from any witnesses, for whatever reason, I don't need to know the specifics, you're saying that her sexual harassment claim survived and would have been certified to hearing.
That's my understanding. And I think and to be clear, there's no disagreement about that as far as Tewtown and Hartsheim. I think the only disagreement that we're talking about is whether it's Miller as well. And I think it's Miller again because it's to the complaint, and I think there's facts alleged in the complaint that but for the Stolar sex, that Miller would not have treated her the way that she treated, and that she made complaints about it, and it's the response then by the respondent that should still be at issue.
So that would be the allowing portion or engaged in
Yes,
the
ma'am.
allowing portion. Okay, so well, I obviously have quite a bit of homework to do tonight. I'm going to do some research on this, and then I will. I'll have a decision for everybody in the morning. Okay.
Perfect.
As to that, but thank you for answering my questions, both of you. But I think I've let it known from the beginning. I don't look at the other stuff if it doesn't play through. All right. Complainant said Alicia survived. No probable cause. Sexual harassment. Okay. All right. If anybody would like to, I don't know if you have time tonight. I'm usually up till midnight, and then I get up at around 4:30 or 5. If you want to give me, and I'm talking brief, like a couple paragraph. You don't even have to put it in a formal thing. Just do it in an email. If anybody could give me a brief summary of their position, so that I can then have something to research off of, you could do that tonight. If you could get it to me by, I don't know, 8 or 9 o'clock. You're welcome to. I'm not requiring you to.
Thank you.
But after 9 o'clock, if I don't have it, I don't have it. I move on and I look at other stuff. Okay.
That's a way better deadline than 4:30. That's what we want. All right.
Okay. So we're good on that? Any other housekeeping issues before we call your first
Where
witness?
would you like the witness to sit?
At the end of the
Perfect.
table?
Okay.
That way I want to be able to look at whoever it
Do you
is
want me to
directly.
get her? Would you like to get her?
It doesn't matter. I can go do it if you don't feel like getting up.
After you.
Okay. All right. Well, who am I looking for?
Miss
I forgot her
Bischoff, I
name
think.
again.
Alicia Bischoff, as I recall.
Oh, hold on. Let me pull up your witness list again. Nope. Wrong. Alicia Bischoff. Okay. Okay, I will be right back. Does anybody need to use the restroom or take a brief
Yeah,
break?
why don't I take just a
Okay,
minute?
I have no idea where it is in this building.
I'll find it.
I mean, I had to find this place, so don't ask me where anything is, okay? So,
Should be like a two-page document with just standalone.
thank you, Judge. And it's Bischoff? I don't want to stroke.
This is the good one. This is-
I don't know.
No, Mike, this is the one for her. So, because you need to find the witness and exhibit list?
Well, I would need that to know which number it is. It should be on your laptop.
We'll get it, we'll get it.
Are you recording this on your phone?
No,
Because it says recording.
I don't know what you're talking about. That's for, no, I just had that with, talking with the witness out in the hall.
Whose phone is that? Whose phone is that?
That is my phone. I just had that on, but with the funeral home.
Why does it say recording?
I don't know, I'm not even over there.
Well, it's recording on its own.
But you're gonna be at the head of the table in the red chair, right over there, okay? So if you wanna put your stuff down.
I have
make
all
sure
of
we
my
have
things
it
already
for the
verified.
restroom. Apologize for the delay.
I
You're
don't know
welcome.
what you mean by your thing.
Are you entering me into the record here?
Yeah, so
I
you
don't do that.
Okay,
I don't know
then
what you're
just don't
talking
worry about that then.
No, I am gonna worry about that.
She's playing with my phone
I
back there.
didn't touch her phone.
Oh,
I really need to use the restroom.
oh,
Sorry,
yeah,
you
yeah,
know.
no. That's what everybody's doing.
Did you find what you needed over here?
No, I'm not sure which is the last one.
Do you all know any of your witnesses' email addresses? Because they weren't included on the witness list like they were supposed to be. Because I
Okay.
have to put them in the log.
What's the question?
Her email, do we know what it is? So I don't have to ask her? Yeah.
I don't know.
All right,
Maybe
I'll
we
ask
can
her.
ask her.
I'll
Yeah,
I'll
yeah.
ask her.
No, this is,
Okay, thank you.
this is the 900 pages of the exhibits. They're going to be smaller, maybe after
They're
this.
in here, yeah.
After this, way after.
Did you say it's in 900?
Number 2 is 900 pages.
Oh,
So
that's,
anything that falls
Let's see.
afterwards is going to be.
Sorry, I have to count it.
Oh, no, you're fine, you're fine.
Oh, yeah.
Is drinking soda allowed in the hearing?
Honey, help yourself.
Okay, thank you, I have to go get myself.
No. And I think it's that way at the first thing, and then you go left by the cafeteria, and you'll see the vending machines in the back.
Okay.
That I did find.
They're in there, they're just like this.
I know, I've seen them, but I don't see them. Okay.
I see them now.
Okay, we are back on the record in CR 2020-02513, Joanna Stolar versus State of Wisconsin Department of Corrections. The appearance are the same, although we do have a witness who is here for the complainant by the name of Alicia Bischoff. I have not sworn her in yet. The respondent wanted to make a brief record. Attorney Zakor.
Thank you. I just wanted to inform this ALJ that as I was getting up to leave the room to take a break, I noticed an iPhone sitting on that table in the back of the room, and it looked like it said recording 1 hour and 51 minutes. And I asked if somebody was recording the hearing. I asked who the phone belonged to. I believe it's the unidentified woman that's sitting in the chair against the wall. And then she made a statement that I was messing with her phone, but I did not touch her phone. I could just see the screen, and I'm just concerned that perhaps this is being recorded when the tribunal asked that it not be recorded or ordered.
Well, thank you. This tribunal did issue a pre-hearing order. That pre-hearing order was issued back on March 22nd. That specifically addressed the official record of this hearing and how that what that would be, as well as there would be no recording of any pre-hearing conferences, hearings, or teleconferences. And pursuant to 227.46 sub 1 sub E, and that the official record of the pre-hearing conference is always the memorandum. That's pursuant to 227.44 sub 4 sub B, and that audio video recording on either a pre-hearing, hearing, or teleconference would be prohibited, especially without prior authorization from the ALJ. The audio recording of the hearing is that of the ALJ, and that's pursuant to 218.19. So I guess I have a question. Have you been recording what's going on in here?
I am not recording, and I've already spoken to, I have a written permission for publication that I'm working on from the Ramona Natera, and Amy Petchacek is on it as well, about my purpose and what is being, what my purpose is here.
Okay, I don't even know who you are, so for the record,
You're requiring an observer to provide their name. I just want to check. Like, I don't usually do that when I'm observing something.
Well, I don't know if you're observing. You seem to be helping Attorney Hitchcock Cross with exhibits and that sort of thing.
I'll
So
help anybody who needs it.
okay, but
Even you.
it's again. I have orders. I don't have anything from you. Nobody's turned anything into me saying anybody is allowed to record this hearing.
I'll provide you a copy of it.
That would be great.
Okay.
Do you have it?
No, I can pull it up, but.
That would be good.
Okay.
Yeah.
And Your Honor, one other thing that I would like to note for the record, I think I neglected to identify Stephen Ross, our paralegal, as also being here.
Okay.
Thank you.
I believe it was authored by Maria Seltzer. And it's not connecting fully to this, so if you're waiting for me, it might be a while.
I'll wait.
It's specifically from her, but that's the stuff. Caitlin, Madeline, Madden. There's hundreds of emails, so I apologize from that
No.
people and Matt White.
Please don't apologize. I appreciate you
Well,
taking
we
the
will-
time to look for it,
I'm trying to find it. There's hundreds.
because
I remember her directive. though.
I'm not aware of any such thing. I certainly haven't spoken to any of those individuals in regards to that. Nobody's told me anything in regards to that.
I didn't doubt that.
I have authority under 227 to direct the course of this hearing.
Yes.
And statute tells me what the official record is. So if there's something going on that I'm not aware of, I appreciate you informing me.
Well, I really, this is kind of stressful for me looking through all these hundreds of emails, and I feel as if I'm holding you up.
You're not.
Can you go ahead and I'll continue to look for it, because I do want you to have it. There's multiple communications.
Not if you're going to continue to record, no.
Well,
I will not continue this hearing until I find where you have written authorization to record this particular hearing. When I have a scheduling order that all of the parties are aware of. We discussed it again at the teleconference on Thursday. It's been discussed numerous times. It was also
I'm
in
not a
the
party.
memorandum. I understand that, but
I'm a
there's-
writer.
I'm sorry?
I'm a writer, an author.
That's fantastic.
Thank you.
I love to read, so I think
Topic too.
that's a really cool thing.
Thank you.
However, there's nothing in the statutes that say that, in fact, this is an open hearing. I don't have
Carlson told
any.
me otherwise last week.
I'm sorry?
Carlson, Judge Carlson told me otherwise
Right.
last week.
Well, the thing is the way
Everybody just
227 works is that every ALJ has the authority to conduct the course of. When it comes to 227, 48 or 46, excuse me, ALJs are afforded the authority to conduct the course of the hearing. The Equal Rights Division can always come up with an administrative rule pursuant to sub 2 of that chapter of 2227. And they can hold hearings and public meetings and promulgate a rule and then establish an all-up rule. They have the authority to do that. But there hasn't been a rule set that these are actually open hearings. So what you have to look at is first what 218 says. 218 will tell us that parties may appear at a hearing in person or by counsel or other representatives. There's nothing statutorily that requires a party to appear in person. 218.11 is silent whether it shall be in person. 218.18 doesn't even require people to appear in person.
I did find it.
So you have to go to 227 for guidance. And 218.18.1 tells you the procedure. That's how it's titled. And
But
it says
Judge,
that
we've had
hearings.
testimony on the record
I
that
can
you
read it now.
have
No,
gone to your
I want-
supervisor for guidance here. So that's problematic when you're saying, you know, the source of your instruction is the law, but you're also telling us the source of your instruction is your supervisor.
No, I have to send her a draft of the pre-hearing order. I don't get instructions from her otherwise. Please, don't interrupt. I was very cautious with everyone else. But anyway, the procedure under 218 tells you that hearings have to be conducted in conformity with 227. And then you go to 227-46 1E, and that tells you that the ALJ has the authority to regulate the course of this hearing. And as such, I wrote an order that said, we're not doing this.
But Judge, the fact
stop.
is that you
I'm
wrote
not
the order
done.
with
I
the-
am not done. All of my orders are the same. You don't get a special order. All of my orders, the first 4 points are the same. The only thing that changes is the type of case and the issue. The remaining of my orders are all identical. I don't make a different order for each case. That's time wasting. The only thing that should ever change is the issues, whether it's a probable cause or whether it's for merits, because there's certain paragraphs that need to be in there. And obviously, if you have a disability case, then you have to account for expert reports and that sort of thing. But otherwise, they're the same. Okay? So you have an email.
Yes. I prefer to read it.
I prefer to see it.
Okay, you can see it.
Okay.
This is our, it's long, it's very long,
That's fine.
and you can, you know,
Let me.
it says all hearings are open, just
Okay.
as in all matters.
All right.
Yep, you go ahead and read that, it's long.
Do you want her email address?
Oh, wait.
Whose?
Yours.
Like I could email
Mine.
this to.
Yes. If
That's
if that'll be easier, email the entire thread.
But it does end in saying to highlight,
Well, I don't know what the discussion was, and I don't know what anything.
it's about open
Okay,
hearings.
Okay.
All hearings are open.
Okay.
We are open, transparent government.
Oh,
Open,
wait a minute. Hold on.
this hearing, open and accessible to the public like all our hearings. We've had
Okay.
extensive discussion
Okay.
about this.
Well, that is somebody else's hearing on that. The hearing schedule
all
will
the
be
hearings.
open, like all our hearings, I assume. Okay, nobody's told me that. As a reminder, that's open records. So this has
And this
to do
is
with
a
something
lengthy,
else.
well, it's about attending a hearing
Yeah.
as an observer.
Okay.
That's what it's about. But I would be happy to send it to you.
Okay. So you're more than welcome to sit in here, but you're not able to record it. So
Okay, so
that you do not have the
I
authority to do.
do have a discussion with them about the article that the series I'm publishing.
That's fine.
Okay, and it does require, like any media person and author, to record those pieces. So I can send you that as well.
Send me that as well.
Okay.
Because again, these are all
It's a
things.
multi-part series.
These are all things that are
exciting.
important to note.
Yes, they are
Because
important to know.
if I had ever been informed by anyone,
Yeah.
then that would have been addressed and corrected.
The
But-
miscommunication is staggering.
But I do not know. I conduct my hearings in this manner. Everybody gets the
We
same.
wouldn't know that. We just go like what's general and
Right.
what's written.
Well, there's no policy. There is no statute. There is no rule that says hearings are open to the public. In terms of what I can find on our website
There are
in the
rules
statute.
that dictate the decision making, and when you go outside of those rules, they infringe on other pieces. So like the rules are there to guide your decision making, and
But
outside of that, it
I'm
falls
talking-
in another area.
I'm talking into whether hearings are open or whether you may record
And
at a
they are
hearing.
open. That's been well established in about 15 other cases.
Well,
At least, and that's just me.
well, there's not case law on it, and there's no statute on it. And if directives have come from
But
somebody
there is.
else, if directives have come from somebody else, they have not been disseminated.
I believe you.
Okay?
I believe you when you say that.
They have not been disseminated.
I
Okay.
think that's true.
So if you could please send me those, both of those.
Give me your email.
Yes, it is.
Hold on.
I don't even know what it is. I have to look up at an email I sent. Okay, you ready?
Yes, I am.
All right, it's my first name, Larisav,
ISAV. Okay.
dot, and then it's long.
Okay.
B as in boy, ENITEZMORGAN at dwd.wisconsin.gov.
Okay.
So it's my first name, middle initial, then dot, and then my last name without the hyphen in it.
Just like
Okay.
Maria Seltzer.
Okay.
Pattern.
All right.
So it's LarissaV.BenitezMorgan at dwd.wisconsin.gov.
I will forward them, and then if you, as you look at them, if you want any of the other, because I believe everybody should know everything to make a fair playing field. So I will give you whatever information you desire.
And you'll share that with the parties, right, Judge?
Share what with the parties? Her emails?
Right. The emails that you're accepted, that we're talking about on the record here in this case, and that you're deciding on this case in this parties too. Yeah.
Oh, everything she sends me, I'm going to put it in the file,
Great.
Beautiful.
so it's all going to be there
Great.
Thank you.
for the record.
That's what we like to
But
hear.
I'm not going to turn around and forward it to you, forward it to everybody. It's just going to be in the portal. Okay? So
okay.
everybody should be able to access that.
Thank you, Judge.
You're fine. And just so I know who it's coming from, the last name is
Keither.
Keith?
Keither. Kuether.
Just ask Maria Seltzer, she'll tell you.
I don't want to talk to anybody.
Oh, okay.
I'd rather ask her what her last name is. That's all. Okay?
Now you have it.
Okay.
One other thing, as part of my duty to candor to the tribunal, I know that if I am aware of governing case law, I need to provide it.
Yes.
As much as I'd like to say that this hearing shouldn't be public, there is case law, and I'm going to send it right now to everybody if that's all right.
Okay.
Wow.
I'm very.
This is, I like him, I can't believe it.
Thank
I'm
you.
gonna have to take a second here. I'm like,
Okay. What do we got?
wow, I can't believe that, I can't believe it.
That's good news.
Wow,
Thank you, ma'am.
wow.
I just have a duty.
You can't understand unless you deal with it, you know, so, thank you for that.
What's that casing to do?
Oh, she hasn't gotten
I
to it
just
yet. We were
forwarded
waiting
it
for you to
to
come
you.
back in. Okay. What do you have?
It's Ivan Kropyuka, K-R-O-P.
Okay. That's like okay. I've got Ivan.
And then Kropiwka versus Department of Industry, Labor, and Human Relations. It's 87 Wis 2nd 709.
Well, with,
It's a 1979 Supreme Court case.
Wisconsin Supreme Court.
Yep.
Okay.
so with that in mind, if this is open, then obviously we can record because that's the law. And so your
Well,
order is
hold on.
illegal, and
Hold
then we
on.
can record then.
Hold on. I want to go through things one at a time. Let's
Oh,
not
okay.
interrupt everybody, okay?
Mm.
All right. So it's 1979. Okay, it's 87 Wis 2nd 709.
Yes, and I just emailed it to everybody.
Okay.
I apologize
And
for
having-
throwing this wrench into everything, but
Just because a hearing is open does not necessarily mean
No,
you're
it
allowed
does.
to
It does.
record.
It does.
Well, I'm glad you think so. I'm going to want a source that tells me that too. That open means record.
yeah, I take the position that it doesn't mean record. I mean, just as news media outlets have to get permission to record in
Exactly.
circuit court.
Yes, you do. Even in municipal court, you have to
Well, both
get
of those
permission.
judges have dignity. That's the distinction there. They both have plenary powers. That's why the Supreme Court rules are applied to them, because they're members of the judicial branch. This is a public hearing open to the public conducted by the administration branch, and we are allowed to have, because see, here's what the situation is you're saying that it's my understanding that the law is that if it's a public hearing, we can record. And you're saying that I need to show you something there, and I'm saying I don't believe you have the authority now to prevent us from recording this going forward, and I think you never did. And based on what I'm understanding and hearing, not only, again, have you prejudiced the parties, but I don't feel, based on my understanding of the law, as long as I'm open and notorious about it, that I have to follow what I understand to be an illegal order. So I think that is a clear understanding of, or statement of, I think, where we're at now, that we're clear that this is an open hearing.
Well, we're not clear. She said she found a case. I'm reading it. You might want to as well. I don't know if the hearing, if this has anything to do with recording or anything else. So I'm going to read this, okay?
You may want to consult the Attorney General.
Oh, I will. I'm not going to make any decisions.
Public Meetings Handbook. Well, but so until you
Well,
make
this isn't a public meeting.
until you make a decision,
This isn't a public
I'll
meeting.
keep that in mind for future reference.
This is a hearing.
Until you make a decision, I think the state of affairs, if we all are on the same page that this is an open public hearing, that the thing to do is to allow people to record, and then if you have some basis in which you can prevent people from recording, then we can move forward on that basis. If you can show that it's within one of your 9 powers and not otherwise authorized by statute and or rule, then we may be somewhere. But again, this is more evidence here that we are grasping for powers that we don't possess. And maybe if we started on a basis of the 9 powers as our touchstone and not other things, we might be farther.
Because he was not provided an interpreter. Who are Labor and Human Relations?
Stolar.
It, you,
Yeah, it's previously.
yeah,
It was previously who?
Labor and Review.
it's before we had DWD.
That's where everything went?
Yeah, well, I mean, state employment cases went to the Personnel Commission,
Right.
and other cases went to Diller. Other discrimination cases went to Diller.
Do you want the email about the publishing of the articles too?
Sure.
Okay.
Well, that statute has changed.
Oh.
Statute has changed. It's referring to you to 1973. That statute no longer says that.
It says
So-
renumbered as 227.44.
Correct. And nowhere in does 227.44 states that it's an open public hearing.
Okay.
So, yeah.
Okay.
So, that's the problem you have. This case is so old. Okay? This case, Attorney Cross, refers you to Section 22707, 1973 stats, which at that time read that prior to the final disposition of any contested case, all parties shall be afforded opportunity for a full, fair, and public hearing after reasonable notice. That statute has now been amended, and it refers you to 22744, and nowhere in 22744 does it tell you that the hearing is open. So while that may have been the case, statutorily in 1979, that is not how the statute reads today. And
And so you've got some proposition that says that this case has been overturned in some way?
not that it's been overturned, but it directs you to a different statute.
Oh, okay.
And
But
that's what
the
I'm
law.
telling you.
Right, the law is what this case is and not the statute.
Well, when the law says, the statute says this, and then you go to the statute and it does not say that, there is a problem. So, if somebody has something that tells me that this administrative hearing is open pursuant to statute, we already have permission from Ms. Kiefer, it appears. I still haven't gone to check and see if I have all the emails yet. But clearly somebody says that she was allowed to come in to that other hearing, whatever it was.
Never
But
been denied.
I don't,
I know you don't.
okay. I don't doubt you,
I appreciate it.
okay? Please. I'm just saying I haven't had an opportunity to look through all the emails. What you showed me said that you could come in. I mean, that was clear. Okay? So you're here. Welcome. But I don't have anything here that says anything about recording or anything else. This case appears to be case specific. It's dealing with a gentleman who had a disability. The issue was whether or not he was denied an interpreter at that hearing, not the sole issue as to whether or not hearings are open or not. But the statute that they point to was a 1973 statute, which has since been amended. So, and nowhere in there does it say that. So I'm going to stand by the same thing. You are welcome to be here. If you have something in an email, direct my attention to me that states that you're allowed to record this.
You should have a couple.
All right, I'm in my inbox, and so far I have nothing.
It should come your way. I did send it unless, there's, your name populated and I forwarded it to you.
Yeah, I don't have anything.
Might just take a couple minutes for sync up, but I do have in my sent as well. So far I've sent you 3, but I've been, if you do want me to send you all of them, I've been on 15, 20 cases.
Okay.
And I've reviewed 350.
Okay. I don't know what anybody else does. Okay.
I know. I'm just saying, I want to give you what you need.
I
but
just
don't
want
wanna
some.
overload
No,
you.
all I need is something that says,
Yeah.
whatever email that says you were authorized to come in at any time, and then you give me that email thread that says that, and then give me the email thread that says you're allowed to record anything.
Well,
Because I don't think you
you'll
are.
see the recording part in the next one.
But I don't have anything
Because
from you right now.
sometimes there's not court reporters. Like, I don't even think there's a court reporter here.
Not today. People can request them, but they have to. They have
They have to
to.
pay for them.
Right.
It becomes cost prohibitive.
Yep.
For some parties, others have a budget.
Yeah.
Also, the definition of public is open to interpretation, and we're looking, now I appreciate her bringing the case law forward, I really truly do. I have a whole file of cases, but I didn't know I was gonna be put on the record here today, so I didn't come prepared for that.
Oh no, that's fine. That's fine. I don't mean to put you on the record. It's just that my order is very specific, and I don't like things coming up at the last minute that nobody's prepared to address. And this is just very clear. Because there's only one record, and the problem you have is sometimes people cherry pick what comes out of a recording.
True.
You see it all the time in politics,
Yeah,
where
yeah.
Things are taken out of context and that sort of thing. That's
Yeah.
why there's only one official record, and that is the hearing record that I make, unless a party has brought in a court reporter, and then that is the hearing record.
I agree.
So that is the problem with multiple people recording. It's been done before where people have recorded
The
stuff,
recording
and then
is
it turns
not
around.
public, though. They,
I'm sorry, what?
ERDDWG sometimes prevents the recording from becoming public. So that is the hurdle that I'm.
I don't understand why.
I don't
Anybody
either.
can get this recording.
They don't.
Well, you just put in a Freedom of Information request with the file number.
Just
I don't know if
like
they
that.
charge you, and they should be giving it to you.
Well.
It certainly would happen in my
sometimes
case.
it's $2,000-3,000.
Well, again, I don't do the bills. I don't know how these things
No.
go. All I'm saying is, anybody who's ever
One side
requested
doesn't
a
get access to the record.
yeah, anybody who's ever asked for a copy of the hearing record
Lucky.
has gotten it. Because
Not true.
I think, for me, I can't speak.
Okay. No,
I
know that
don't
you
know
have
about
to
anybody
remember
else, okay?
Our experience is different than yours.
Okay, well, and I don't know, I have nothing to say with any of that. But until I hear otherwise,
Understood. Thank you.
all right, I still don't have any emails from you at all. So I'm going
I
to,
can show if you want to look at them in my phone.
no, I don't understand why you can't forward them to me.
I did.
Well, I don't have anything. I've shut down my email. I've brought it up again.
I don't know what else to do. Like, do you want to check and make sure I didn't put the wrong? Like, these are the 3 that I sent to you in my sent. It's
You put a period no, you didn't spell my last name right. It's easy.
There you go.
okay. Maybe you should type it. I might not have
It's
picked my-
it's everything's correct. It's Larissa,
Okay,
L-A-R,
wait. All right, because you populated. Okay, so
L-A-R,
LAR.
ISA, dot, B-E-N-I-T,
IT.
easy, Morgan,
At
DWD, DWD,
Fat thumb.
dot Wisconsin,
See, and you popped up.
dot gov.
Okay, so I'm gonna resend those. See, now I'm worried. Okay, it populated.
Yeah.
So
Yeah.
I have to select that, otherwise it won't let me send
Right.
it.
Well,
But that's what happened before. So I'm gonna,
that's right.
okay, so let's see if it goes.
So now forward everything.
Okay, here we go again.
Yeah.
Just gonna start with these 3. Okay, I will go sit down and send for these 2. Thank you.
Okay. But if you have something that says you can record, I need that. Otherwise, I'll be more than happy to make sure that you get a copy of this.
I'm happy with that too, as long as it's not blocked from like people accessing it. That's
No,
the next
anybody
hurdle. You
can
say
fill.
that, but that's not what happens.
Well, it should.
I know.
And
I know.
I've never had anybody in any of the hundreds of cases that I've handled here
It's lucky.
that has said, I need a copy of this. I let the secretary know, because I don't do it. I don't make the copies. I just download the thing. I let the secretary know this person's requesting
I'm
a
glad you
copy,
feel that way.
and then it goes out.
Thank you.
Okay? So that's
I don't
how
have a problem as long as we're not denying.
that's
records.
how the public knows what happens in a hearing.
Yes.
Because they can get the recording and they see everything.
Yes. And
Okay,
sometimes the,
so-
the actual plaintiff.
So
Yeah.
that's how that's going.
Perfect.
So
I
that
have no
that's why it's
problem.
like there's no need for 50,000 people to come in here, because you can always get a copy of the hearing. And if you let me know I would like a copy of it, guess what? I'm going to forward that request.
Yeah.
Okay?
Yeah.
So that's how I do things. I can't speak to anybody else. I'm not their boss.
Right.
Okay? So I don't know how those things work. But until I have something that says anything about a recording, those are my concerns. They've always been my concerns with anything.
And I will just say, I've said it several times, but just to make sure it's clear, I did not come prepared to have this discussion, so I have many, many things available with my multiple ongoing discussions with DWD decision makers at the highest levels, including the government.
Oh, I don't know who.
office.
I know none of these people.
I don't think you probably need to, but I do want to say that the communication that has been etched out in those ongoing discussions is addressing all the pieces that we're talking about here today. That's the only reason I bring it up. I'm not, I don't care if we know those people, but they are decision makers in our state, and they have been very clear to me in writing formally that what I am allowed to do as a citizen and a writer, and what is proper in statute and law for our state and country. So that's all I wanted to say. Thank you.
Yeah. Now I've had reporters, but they always let me know ahead of time that
Sure.
they want to come in. They show their credentials,
Yes.
and then that's not a problem. But just
Sometimes it
so
is.
Joe Blow
sometimes it's
Smith
not.
that just wants to show up, it's like, what are we doing here?
Right.
And no, I don't allow recordings of my hearings for the reason that it's not the official record. And people aren't going to cherry pick as to, taking things in and out of context and that sort of thing. If you're going to do it, here's the entire record.
Yes, it should be raw, unedited from start to finish.
Correct. Okay. I'm still...
Now,
This is a whole bunch of, basically you've got a whole bunch of open records proceedings. Pre-hearing conversation here.
Well, that's what I just showed you when I.
Right, I know, I'm looking.
And
For
we
hearing
had a 2-hour
conferences, art
discussion
readings.
with Judge Carlson last week as well.
No, I have no idea what he does. I don't ask people what they do in their hearings. I don't talk to anybody
We
about...
don't know either, but we find out once it transpires, which makes it difficult for us to come into a setting knowing what that individual's,
Well, my order's been issued since March, so it shouldn't have been difficult. You came here with Attorney Hitchcock Cross, so
I
clearly...
did not come here with Attorney Hitchcock.
I'm sorry. You guys all seem to be kind of working together. My
I did not come with
apologies.
him.
But,
And I've been here many times on my own.
you correctly.
I speak to Ms. Flores, Matt White, Caitlin Madden, Jennifer Wackhauser,
Yeah, I don't
and the
know.
list goes on. Well, those are your decision makers here at the state level.
Okay, I just do my job. I don't know who they are. So, sorry. Because all that stuff's about...
But they're overriding what you're saying.
Well, and that we'll have to deal with.
That would have to be dealt with, I would think. We've been trying to
Yeah.
get to that. I am not trying to be difficult.
honestly, I don't think you are. I think you've been very pleasant. And I thank you for helping to educate me. Again, there's no ego here. I love to learn. That's why I'm like, you got a case? Quick, let's read it. Let's see what it says. So that's not a problem. All right? So please don't ever feel that way. I think part of the problem here is people are equating with this with an opens meeting law, and our pre-hearings and hearings don't fall under the rubric of open meetings. I know, but this is completely incorrect. What I'm saying here is not the correct analysis that should be done in terms of statutory construction. So they don't fall in.
I think this will all be a moot point very shortly because I will be leaving shortly. So.
No, but it's not, because it needs to be taken care of. Okay. All right. Again, I don't have anything in any of these emails that says you can record. I will be more than happy to see to pass on any recording, any FOIA.
It's off.
Okay. And I thank you for that. And you will be one of the first people I contact, since I now have your email, if that gets changed, so that you know in the future with hearings with me.
I appreciate that.
Okay?
Thank you.
You're more than welcome. But there's nothing here that anybody has the authority to record. Okay. All right. So I think we've resolved all of that. Can we now please call our first witness?
Well, we could have called our witness some 45 minutes ago, but you had a discussion about not allowing the media to record this hearing for some 45 minutes here. So we're continue to be ready, but you know, it's when you put things like that, we're going to have to correct the record every single time, Judge.
Well, I thank you for that, Attorney Hitchcock-Cross, and I did not consider, and nor do I consider Ms. Cuther to be the media per se. We've established she's a writer. She has not established any media credentials for me. She's more than welcome to remain. But the authority for this, there's no statutory case law for this meeting, this hearing being open, as this is a hearing, not a meeting, nor does it fall under open records. So, with that being said, let's call your first witness.
And I just need to point out as well,
to,
so that I can be clear, I understood that Dr. Keither had put in front of you several correspondence between her and your supervisors. These are the same supervisors who edited your draft for the pre-hearing order, in which you explained to us that you took guidance from, and they asked you to add things and took things away. And this is also the pre-hearing order upon which you rely for the proposition that you have the authority to close this hearing from recording. And again, as you note, you say that you have the decision and the discretion here, but in fact the record shows quite clearly that the discretion is being shared between you and Maria Celsor, the person who I understand gave Dr. Keither permission to record here today. We obviously then will need to bring her, that is Ms. Celsor, as a witness on this case, so we can straighten out what exactly her instructions were to you and to Dr. Keither here, because obviously we've got time. Time isn't an issue, and if we've got 45 minutes to talk to Dr. Keither and look at case law while the witness is standing here waiting, obviously we've got time to examine Maria Celsor about what instructions she gave you on this case and what exactly the policy is for the DWD. So since we've established that as a source of rule and authority here as well by your own testimony here today.
well, first off, I'm not giving any testimony. I thank you, Mr. Hitchcock-Cross. Ms. Kiefer was here. She didn't introduce herself, had no idea who she was. it came to my attention that she was recording. There is she has a variety of emails. I have not read them all. She showed me one at the very end. It was referring to another ALJ's case. I do not have, I have not looked at all of these emails. I am not seeing the specific email thread that she showed me in the 3 that she has sent me. These are all pertaining to open records request and that sort of thing. I'm now looking through the 3rd one in terms of, again, open records requests is what they appear to be. I don't have anything. I'm looking for what says here. It's in regards to a specific hearing.
So once again,
So,
the point
no,
is-
I'm not done. Please, don't interrupt. So, anyhow, the recording, it says here in this one email that any recording is accessible to the public through open records. You can attain that. They were referring to a particular hearing that occurred in November of 2022, and where she said that would be open. But she said, and then it's referring to pre-hearing conferences and that sort of thing. Now, I have already directed. Is it doctor?
Oh, yeah.
You left that part out.
That's okay.
No, it's not. You have a title. You deserve to be called by it.
Thank you.
Okay, so Dr. Keither?
Keither.
Is more than welcome to stay at this hearing. I do not have any authority that says anything about recording. That being said, this could all have been handled if people had just said what they were doing in the very beginning. Now, could we please call your objections and everything are noted for the record. They're on the record. Let's call Miss Alicia. Is it Bischoff?
Alicia.
Alicia. Could you raise your right hand, please? Do you affirm or swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Anybody lower your hand?
You ready? Okay. Have you testified before?
No, sir.
Okay. Have you spoken to either of these, anybody at this table, about your testimony here today?
No, sir.
Okay. Do you know, actually, let's start with this. Have you ever been employed by the Department of Corrections?
Yes, sir.
Are you still employed there?
No, sir.
When was the last time you worked?
I resigned in April of 2023.
Okay. And when did you approximately start?
I started in April of 2019.
Okay. So about 4 years?
Yes, sir.
Okay. And where did you work at the department physically? Like what location?
I worked at Dodge Correctional Institution in North Lawn.
Okay.
I volunteered at Lincoln Hills Copper Lake School for 2 weeks. I promoted to sergeant to Oak Hill Correctional Institution, and I also volunteered at Columbia Correctional Institution.
When did you get promoted to sergeant?
I had 2.5 years in at Dodge.
Okay.
So November of 21.
Okay.
So I believe actually April of 22 was when I resigned. Was 3 years instead.
Do you know why you resigned?
Yes, I do.
Why did you resign?
Personal matters.
Okay. Do you know Alicia Miller?
Yes, I do.
How do you know her?
She was a lieutenant at Dodge Correctional Institution when I was an officer.
Okay. But not sergeant?
No.
Okay. Okay. Because you would have transferred.
Yeah, I promoted and transferred to Oak Hill.
Okay. And do you know Joanna Stolar at all?
Yes, I do.
How do you know her?
We were both officers at Dodge Correctional Institution and worked a couple of shifts together.
Okay, and would you both have worked under Alicia Miller at any time?
She would be on shift, yes.
Okay. And can you describe Miss Miller as a boss?
Not my favorite.
Okay. And I can understand that, but we're gonna, just so you can explain it to the judge here, why wasn't she your favorite?
It seemed as though she was, I'm trying to find the words, I do apologize. I guess the phrase that isn't really professional would say she had it out for young women that were in her 20s. So she would more or less let stuff go for other staff members,
Okay.
but not for specific young females, which I believe there were about a handful of us, no more than 10.
Okay. And
But she gave us a hard time.
this is going to sound rude here, and I apologize for having to do this, but were you one of the young females that we're talking about?
Yes.
Okay. And so did you witness her treating young females differently than other employees of the DOC?
There was an investigation that was done about it, actually.
Okay. So before we get to the investigation, is there anything specifically, examples that you can remember of her giving, treating the young females differently, including yourself or others?
So in the institution, you have to have a clear backpack.
Okay.
But if you don't have to, but I don't remember if it was mandatory at that time. I don't believe it was. Numerous other staff members didn't have clear backpacks, and at that point in time, I did not.
Okay.
And out of all of us coming in for first shift, she picked me out and said, tomorrow you better have a clear backpack.
Okay.
So I purchased one, and not only did the one that I purchased, it was clear, she actually purchased the same one.
Okay.
So I'm like, oh, well, that's interesting.
Was there a problem with the backpack after you purchased it?
No.
Okay. And was that your first negative interaction with her?
No, I believe there was one interaction that I was running late for. I had made it into the institution on time.
Mm-hmm.
I just didn't make it to my post in time.
Okay.
Which, understandably so, but I did get written up for it.
Okay, and did you ever experience anybody that wasn't, I guess we'll start with males. Did you ever experience any males showing up to their post not on time and not getting a reprimand for that? And sorry, just for the recording, was that a yes?
Yes, sir.
Okay.
Granted, during different times too with the amount of vacancy that we have in overtime, there were times of everybody had to replace everybody. So it was a string of you needed to relieve this person, to relieve this person, to relieve this person to get to the post. So there were plenty of those times that happened, but in my case as well. But
Okay, and was there, so what I think what I'm understanding from you is you're saying just in the normal course of work at DCI, you're going to be late to your post because of the logistical situation. Is that fair?
correct, yes.
Okay. And then are there situations, or I guess when you got written up for that, did you feel that that was targeting you as a young female?
Objection assumes the fact not in evidence. There's nothing in the record that says she was written up yet.
Maybe I misunderstood that, and that's fair. Let me clarify then.
I thought she very clearly
She did,
testified
okay.
that she came in on time, but for whatever reason, it's difficult logistic-wise to get to her post, and so she was written up because then subsequently Attorney Hitchcock Frost then asked if he'd ever witnessed any males that did the same thing and that. So I'm okay with foundation because I think that's what she testified to.
Great, okay. So, and this is the one problem, we don't have a reporter here. I have to remember what the question was that I asked. Do you happen to remember what it was?
I
What?
apologize, no.
And I think that was able to reconstruct it like this. Is there anything about when you got written up that made you think that it was directed at you as a young female?
I would say no.
Okay. And when you started at, well, let me back up. Did you start at DCI at Dodge Correctional?
Yes, sir.
Okay. And do you have a problem me saying, Judge, me saying DCI?
Is that what it sounds for? Just as long as I know what the acronym
Yeah,
is.
DCI is
Okay.
the institution that we're talking about.
DCI is going to be Dodge Correctional?
Yeah.
Yes, ma'am.
Okay. No, I have no issue with that. Does anybody have any issue with the abbreviation of that?
Not at all.
It works fine. Thank you.
Good. I like to try to sound cool when I can. Okay. So,
Okay.
all right. I'm going to
Okay.
let people, if they want to get you. Okay. So, when you started at DCI, did you hear anything about Alicia Miller at that time?
More or less.
Objection, hearsay, and form of question.
I'm going to sustain that. I'm going to ask you to rephrase if you could.
On hearsay?
Well,
And form of question. I also raised form of question.
yeah. I would ask you to rephrase what did.
Sure, I understand. I think I can make that clear. When you started at Dodge Correction, did you talk to anybody about the conditions when you were first there?
Okay. I mean, yes, I did. I get along very well with a lot of people at work. When I did work there, of course, you become sort of family in a sense, or you become close to the sense that you want everyone to go home safe at the end of the day. There is a couple of people that I did talk to, but as far as minding your P's and Q's around who to kind of watch out for, stuff like that.
Okay, and were you ever warned about Lieutenant Miller?
Yes,
Okay, and what was the warning?
to definitely mind your P's and Q's.
Okay. And was there anything specific about whenever you were warned about how she treats females or anything along those lines?
Yes.
Okay, what can you explain to us what that warning would have been?
It would have been of that is just the sense of you get treated differently, of you're more on her radar, that you have to mind your P's and Q's, otherwise she's going to look for anything and everything.
Okay, and were you told this by more than one person?
Yes.
Okay, were you told this by anybody who was male?
No, I don't believe. Well, there might have been a couple, but not that, mainly more female. There was one male, for sure, yes. That actually, he was, I don't remember what the word is, but like a mentor for my investigation that sat in on
Okay.
it. So he was like a representative, I guess.
And when you say your investigation, what are you referring to?
So at Dodge, there was an investigation that was conducted on Alicia Miller.
Okay.
With, I believe Johanna Stolar was one, I was one. There were a couple other females that got pulled into this investigation on harassment.
Okay, and I think what I don't understand, and hopefully you can help me there, is did you file a complaint against Lieutenant Miller at any time?
I did not. I was a witness
Okay.
at that time as well.
And do you know who filed the complaint when you were a witness?
I do believe it was Johanna Stolar.
Okay. So, and just if we can assume for a second that Johanna Stolar did file a complaint, are you aware of any other complaints against Lieutenant Miller for along the lines that we're discussing?
Beforehand, no.
Okay, how about afterwards?
Objection, hearsay,
Yeah, I wanted to.
and relevance.
Two things. I want to back up because you were asked, were you aware of, who filed it? And then you think. So I want to know is, do you know for a fact who it was that filed that complaint? You said it wasn't you.
It
harassment.
definitely was not me.
Okay, that's that's fine. But do you know for a fact who it was, or are you guessing?
I don't recall.
No problem.
Okay.
So, I can handle that, Judge, and let me deal with that as I will. I'm a little puzzled as to the hearsay decisions here. You know, I don't need to, thought I wouldn't need to go down Rutherford or anywhere else, but I think we can do that.
Well, I think when you clarify this, this will be here. I just kind of got muddled
Okay.
with her testimony. So I'm not saying it was or was not hearsay. I think we just needed to clarify a few things.
Sure, and muddled I totally get. I've heard that before about some of my work. The thing that I don't understand is hearsay. That has generally never been a bar to evidence, certainly not from the first witness this early in a ERD hearing. So that's what's baffling me.
Well, rules of evidence are very loose.
That's right.
I'm more in terms of allowing everything in than rejecting everything out. But when it comes to testimony, when I later have to determine findings of fact, I can't make a sole finding of fact or rely on nothing but hearsay. So if we could clarify what she knows and what she doesn't, it makes it a cleaner record.
I
That's
understand. I can handle that. Thanks for that guidance. Okay, Miss Miller, do you know what an 15807 form is?
No.
Okay. If I showed you this form here, would that refresh your recollection?
Can you identify for the record, please?
Sure, this is Complainant's Exhibit 8.
And what is the Bates number on it, please?
I believe it's 993 and 994.
Yeah, I recognize this.
Okay. All right. Since we haven't discussed this, I find this much easier to do. If it's something that you're going to want to mark and move into evidence, I like to do them as we do them so we don't lose track.
Fair.
Okay?
Okay.
So is this going to be your first exhibit?
Yes. Right now, though, Judge, was trying to refresh your recollection and so I think I got that out of the way.
You did?
Okay. Are you able to identify this document?
Yes.
Okay.
Okay.
Then now I would move to get it into.
Okay. It's been marked. And what was the Bates number?
So that's a thing.
Did you want this cover?
No, sir.
Oh,
I
okay,
just
okay.
want the
Okay.
actual Bates number
For the
on that
record,
exhibit.
Judge, it's Complainant's Exhibit 8, and that goes from the cover sheet at 992, and I believe it ends at 994.
Okay. So the Bates number, ERD 992?
Stolar, 992 through 994.
Okay. Are you going by your Bates numbers
Yes,
or the
yes.
ones that we put? Because what the ERD numbers are, that's what we use for hearing, not whatever Bates numbers the parties have
Where
used.
would I have gotten those if I had those?
When we talked on Thursday, I told everyone that your Bates numbered exhibits were in the portal, and those were the Bates numbers that we used at hearing. Because sometimes people Bates stamp things for depositions, and then they get all jumbled. So they've been available, but that's okay. I can cross-reference.
I
just have to.
appreciate that. There was a lot going on there.
I know. Okay, hold on. Let me find some things, and then we'll fix that up. I just don't want to lose track and not include an exhibit that you have presented, because I didn't write down the number right. So what did you? I see your Stolar number. Okay.
You're on the, okay.
What number did you have?
We have Exhibit 8, and again, our Bates numbers are 992
All right, let me find it.
through 994.
Okay. So Stolar 992. All right, it's way down there.
Oh, yeah.
All right.
You know, Judge, if you type 992 in the page number spot, it'll take you right to that page. I taught that to Alice DeLau, and she was...
No, I did that, but my version of PDF doesn't do the searches and the things that it's supposed to. So unfortunately, that doesn't work, because sometimes I'll just do a flat-out search. Okay, so now we have, so that's Stolar 992, and it goes on to 993. Is that correct?
I believe it's 994. The cover starts on 992 and it ends on 994.
I'm not worried so much about the cover. I'm looking at...
993 to 994, Judge.
Okay, so that's going to be ERD number 993 3 to 994, and this is investigation. I'm going to call it an investigation Alicia Miller interview. And for the purposes of this hearing, this has been marked as Claimant's Exhibit 1. It has been marked. It has been offered. Objection from respondent.
No.
Hearing no objection, it is admitted.
Okay,
Thank you.
thank you. Do you, now seeing this document, does this refresh your recollection about the complaint?
Absolutely.
Okay, and what, did you give testimony or an interview with regard to a complaint against Ms. Miller at any time?
This one specifically? Yes.
Okay. And did you give any other, besides this, what's documented here, do you believe that you spoke to anybody else in the DOC regarding Alicia Miller?
Outside of record?
Right.
Yes, absolutely.
Who would have that been?
Of who I spoke to about Lieutenant Miller?
Yeah.
Numerous other young females.
Okay. But like any other white shirts for management, for lack of a better word?
Yes, actually.
Who would that have been?
Lieutenant Batan Kulabali.
Okay.
Batan Kulabali.
Means daughter of the morning, Judge.
And how can you please say that first name again?
Batan. Batan.
And the last name was?
Kulabali. So Coulibaly. I don't know if he works for the DOC anymore.
Okay.
Okay. And what I see here is a fairly short interview. Is that fair?
Yes.
Okay. And do you believe during this interview that you were, well, let's start out. Do you believe that Alicia Miller was harassing DOC employees because of their sex?
Yes.
Okay. And do you believe that you explained that to the Department of Corrections in this interview?
Yes.
Okay. And just with this interview in front of you, can you show us how you explain this to them?
Well, especially at the bottom, would you consider that she treats females to be, or would you consider the way Lieutenant Miller treats females to be intimidating? And I said, I think she tries to be intimidating, and when she doesn't seem to be succeeding, she will disengage or she will engage. It's more towards females than males.
Okay.
Also, the fact of if there was anything I'd like to add,
Mhm.
I was pretty much afraid to answer because of retaliation.
And you say that specifically?
Yes.
Okay. And did, just starting with the retaliation, after you gave this interview, do you believe that the Department of Corrections took any steps to prevent you from being retaliated against?
Objection.
I think that this is relevant. It's going too far afield. This pertains to claims that have been dismissed.
This is part of what I said earlier. We were going to, I was going to make a ruling on as to the claims against Miss Miller. I agree we're going a little bit far. I think you've introduced some important testimony through this witness as well as this exhibit, but we're not here for Alicia Miller probable cause. So I'm going to ask you to kind of wrap it up with this.
Sure, and I'm going to counter, and I'm going to say Rutherford, I'm going to say Brown, I'm going to say Bowen, I'm going to go off of all of the decisions that Lurk has said that you are not to restrict testimony unless there's a timing issue or it's cumulative or repetitive here. You had an hour that you wasted that we weren't able to get to because you wanted to talk to Deborah Keith or a non-party about whether she was recording this thing, and you wanted, that was the primary concern here. Now we're trying to get relevant testimony out of this witness on how the Department of Corrections is responding to harassment complaints, and now all of a sudden we don't have time? Is that what I'm understanding here, Judge?
I haven't said anything about time. Attorney
Well, then
Hitchcock
she
Cross.
should be allowed to continue.
Please don't interrupt. You can't ask me for something and then cut me off. Tone is not necessary. I didn't say anything about time. I'm concerned about relevance for the issue that is before this tribunal in regards to Ms. Stolar's case. We started off, does she know Stolar? Perhaps she might know something about Stolar's case. Perhaps Stolar might have confided in her. But now we're going off of an investigation that happened at some point with Miss Miller. She doesn't know who brought this to the attention of these people. You know, I'm just saying, you know, I think we're going a little bit off field. I don't know, and nor have I determined yet, that the claims against Miss Miller were dismissed at the no, you know, as it pertained to her, were dismissed at the no probable cause. I've heard argument from both. I'm waiting to hear, but all I'm asking is if we cannot go so deeply down that vein, and if there's other testimony you could try and elicit from her. That's all.
What I'm saying is, according to the precedent in Bowen and Burton, that these kind of a priori decisions to restrict evidence and other heavy-handed decisions to restrict the hearing of evidence are per se bias, as been determined by Lurk. So just once again, we're going down this road where you've just said that you think that there is some limits to Alicia Miller.
We discussed that prior to this hearing even starting. The no probable cause section of this case pertained to the claims, but both parties have already said that that's been dismissed. You have now said that no, you believe that there might be some as it pertains to Ms. Stolar. So I'm waiting to hear on that. That's all. That's all I've said. Okay? Please continue with your examination of this witness.
Okay. Do you feel like the Department of Corrections protected you from retaliation?
Objection, lack of knowledge, or there's no foundation about that she was retaliated against.
Sure. I didn't ask her if she was retaliated against. What I asked her was, did she feel like the Department of Corrections had protected her from retaliation? That's my question.
I thought that was already asked and answered.
I'll let her answer.
I would say yes. But it is hard to determine otherwise.
Okay. And so, did you feel any negative reaction from Alicia Miller after you gave this interview?
Not any more than usual.
Okay. Now, I don't know if we got this answer, your question yet. Do you know, you did say that, sorry. Do you believe that Joanna Stolar had similar problems with Alicia Miller as you did?
Yes.
Why do you believe that?
We did work on the unit, or specific units together for, I believe, a couple of shifts. And she did mention some of those things of, do you have issues with her?
Okay.
I'm going to move to strike as hearsay.
It's a party. It's not even hearsay.
Okay. I've heard your objection. Attorney Cross, will you please speak to party opponent?
Sorry?
Your response to their objection, please.
My client is a party. It's not hearsay when you're talking about what my client told her.
Exactly. It's a statement by a party opponent. Your objection's overruled.
I'm sorry. So, can you tell us what Ms. Stolar told you about Alicia Miller, please?
It would be a lot of the same things, so she was just given a hard time of certain things. What they were, I don't recall. They were a couple of years ago.
Sure. Do you believe, based on what she told you, that she felt she was targeted because of her sex?
Can you ask me that question one more time?
Absolutely, I'd love to. Do you believe, based on the conversations you had with Joanna Stolar, that Joanna Stolar thought that Alicia Miller was treating her differently because she was a female?
I
And I have a standing objection to this. First of all, it's a speculation as to what's in Joanna's mind. And second of all, what Joanna thought may not have been, I don't think is relevant. What actually happened is what's relevant.
Attorney Cross, did you want to respond?
I don't have
before-
any more response on that.
Okay. The witness can speak to what Ms. Stolar told her. That is not an issue. As to what Ms. Stolar was thinking, nobody reads somebody else's mind. I didn't take the question as what was she thinking, more of, I mean, she could even speak to her demeanor. How did she appear? What did you look like? Was she frazzled? I mean, you can speak to what you can see. And I didn't take that question as that. So, so I'm not going to say it's hearsay unless we're talking about, you know, what do you think? Or what do you, I mean, those are, you know, we would have to go a little bit further. And then we're dealing with mental impressions and everything else. And rules of evidence are lax at administrative hearings. So if you don't recall your question, your question, I believe, let's go back to,
Okay.
do you have reason to believe that Miss Stolar was targeted by Alicia Miller because of her sex? Your response to that was,
Oh, I mean,
do you know?
no.
Okay. I appreciate that. Now, let's talk about are you aware of a fishing trip
Fishing trip.
to Lake Emily?
Are you talking about
Sure.
the DCI like annual ice fishing on? Oh, I thought that was on a different lake. I apologize.
Okay, but that sounds about right. And, have you ever been invited to that?
I don't believe so, no, but I have heard about it.
Okay.
And heard about the happenings.
And what did you hear about it?
Multiple different things. There were a lot of people that went, and there were a lot of not great things that happened.
Okay. And do you know that after that event, did you know if the Department of Corrections had another fishing tournament again?
I don't believe they did.
Okay. And do you, when you say you weren't invited to that, do you know why you weren't invited to that fishing trip, for lack of a better word?
I think I was still new yet at that time. I think I had less than a year in, so.
Okay. Now, and did you know that some people, did you know of others that were not invited?
No.
Okay. Now, while you were working at DCI, did you ever hear any rumors about Joanna Stolar?
Yes.
Okay. Broadly speaking, can you tell us what those rumors were?
Her relations with different staff members at DCI.
Okay.
A little bit of her home life, but not a whole lot.
Okay. And we're talking about relations. We're talking about something warmer than ordinary friendship. Is that fair?
Absolutely.
Okay. And I mean, was this for lack of a better word, is this a frequent occurrence that you heard these rumors?
Yes.
Okay. And now that you said frequent, can you tell us about how frequent they would have been?
Oh. More than monthly, but less than weekly.
Okay. And were these rumors, were they coming from one gender of person?
No, they were coming from both.
Okay. And were they coming from officers only, or were they coming from others as well?
They were coming from others as well.
Okay, what's the highest ranking person that you recall hearing a rumor from?
Lieutenant.
Lieutenant. And what was the subject of this rumor, if you recall?
It would definitely be sexual relations.
Okay. And I'm sorry to have to do this, but just to be clear, this is a lieutenant's telling you that Joanna Stolar is having sexual relations with somebody. Is that fair? I can ask it again. Did you not get it?
I did.
Okay.
I'm just trying to recall, and I don't recall.
Okay. That's why we were asking those questions. I appreciate that. But what I just described, in other words, Joanna Stolar, a rumor about Joanna Stolar having sex with somebody, and a particular employee at the Department of Corrections.
Objection leading?
I think we're getting on compound because I'm trying to write notes.
That's fine. Okay, and I'll strike that question and start over then, and because I do it as compound as can be. So, I guess just starting with rumors, did you hear anybody say that Joanna Stolar was sleeping with other department employees?
Yes.
Okay. And how about people who weren't department employees?
Not that I can recall.
Okay. Was it more than one different employee?
Yes.
Okay.
Question. The more than one different employee, are you talking about you heard it from more people, or the rumor was that she was sleeping with other people?
The rumor was she was sleeping with other
Okay,
people.
all right, because there's a difference.
I was gonna rehabilitate Judge, but I think we're working well on that one. Okay. So but also then, did you hear those rumors from more than one person?
Yes.
Okay.
I hate to say it, but rumors spread like wildfire in that institution. It's a big long hallway, and you can make it from one side of the institution to the other, and it'll spread before you walk it.
Okay. And did you feel, based on your knowledge and experience working with Joanna, that there was truth to any of the rumors?
I would believe there is truth to it.
Okay. And did you think that some of the rumors were false?
No.
Okay. In other words, you believed at that time that Joanna Stolar was having sexual relations with multiple DWD employees, or DOC employees. Okay. Okay. Did you ever hear Alicia Miller spread any of those rumors?
I tried to avoid her like the plague.
Okay. Did anybody ever say Alicia told me that, or Lieutenant Miller, or anything else along those lines?
Not that I can recall.
Okay. When you heard any of those rumors, did you ever report any of them to anybody?
No.
Did you ever file a complaint based on any of those?
No.
Okay. Did you believe that we're just going to say rumors, did you believe that was the communication of rumors? Do you believe that was against the policy at any time?
I'm sure it was, but that I could believe. I'm sorry, one more time.
Sure. Do you think the spreading of rumors, for example, that Joanna Stolar is having sex with other DOC employees is against DOC policy?
I would believe it's against DOC policy, but it didn't stop anybody from that happening for anybody.
Okay. Do you believe that females were particularly targeted as subjects for rumors at DCI while you were employed there?
I was subject to one of them, yes.
Okay. Was that similar in nature to the rumors against Ms. Stolar?
Yes.
Okay. How did that make you feel when you had a rumor that was spread about you?
Like a fish in a fish tank.
Why?
You just have everybody knowing your business that doesn't need to know your business. These are your personal... This is part of your personal life, and it's mixing with your work life.
Okay. And were the rumors about you, was there any truth? I don't need to know what they were, but just was there any truth to that rumor?
There were some, yes.
Okay. And how did that part make you feel?
That's hard to say.
Okay. Do you feel that you were targeted at DCI because for rumors because you were female?
I can't say just because I was female, but I would say that I wouldn't say just because I was female.
Okay. Do you think Lieutenant Miller took any steps to prevent the spreading of these rumors?
No.
Okay. Do you think anybody else at the Department of Corrections took any steps to prevent the spreading of these rumors?
No.
Do you think Lieutenant Miller was aware that these rumors were being spread?
Absolutely.
Why do you believe that?
Because she spread rumors about me before.
And why do you think that she personally spread rumors about you?
Because I was told by a supervisor.
Okay, what was the rank of that person?
At the time I think he was a captain.
Okay. Do you think, just generally speaking, that there were more rumors about the female DCI employees than there were about the male DCI employees?
I would say so, yes.
Okay. And you feel that Lieutenant Miller was aware of that disparity?
Absolutely.
Okay. Now, if I can talk to you about, and I'm going to keep calling it a fishing trip, I hope that's okay.
That's fine.
What did you learn, if anything, about the fishing trip after it happened?
Oh. Probably not to go to them. Lots of drinking, everyone acting not themselves or professional.
And just, can you slow down and explain to us what you mean by that?
I guess what I had heard was that she had been touched by somebody that was not it. There was very mixed feelings on if it was welcomed or not.
Okay.
Of the state of both of the individuals, of Johanna or the other party.
Well, let's pause right there for a second. Did you, I guess, what, if anything, did you hear from Joanna Stolar about what happened at the fishing trip?
I heard nothing from her. I've heard all hearsay.
Oh, okay. And did you hear anything from, do you know Mr. Toutant at all?
Yes, I do.
Okay, how do you know him?
I worked with him. He was a sergeant at DCI until after that incident, they moved him to Waupun, and I haven't seen him since.
And he was still a sergeant when he was moved, as far as you know?
I don't recall. He might have been demoted.
Okay.
But at Waupun, they have a very big vacancy, so you got put into any slot that they needed you.
Okay. And do you believe that he moved to Waupun by choice?
No.
Why do you believe that?
Because with the hearsay that was happening, he and the investigation that supposedly had happened, they had done that for her protection and as punishment for him.
Okay. And when you heard of, I guess this is after the fact, rumors about what happened.
Yes.
Is that fair to say?
Yes.
I thought I understood you to say that some people were saying Joanna Stolar, welcomed it. Is that true?
Yes.
Okay. And was that a common rumor?
Yes.
Okay. And maybe I just don't get it, but what is your understanding of more or less the allegations of what happened to Miss Stolar on the fishing trip?
My perspective of what happened was that they both had been drinking, and she was very flirty, and he made a move, and as far as I know, she was okay with it.
Okay. And how did you come to those conclusions?
All hearsay with rumors.
From other, I guess what I'm trying to understand is this is from DCI employees, right?
Yes.
Okay. And about how many were there? sorry, and let me break this up. Because part of what I'm trying to understand is, do these people give you the sense that they saw what happened?
Yes.
Okay, about how many people gave you the sense that they saw what happened on at the fishing trip?
I would say at least 10.
At least 10. Okay. Would it surprise you to learn that nothing like 10 people say they saw what happened on the ice when they were examined by the Department of Corrections?
No.
Why not?
Nobody wants to get pulled into an investigation that ruins their little fishing trip.
Okay. And did you ever learn of any criminal charges being pressed against Mr. Teuton?
No.
Okay. Did you ever hear anybody say that Joanna Stolar did not welcome being touched by Mr. Teuton?
Not until after the fact of her pressing charges.
Okay. So you were aware at least that she pressed charges against him?
After the fact, yes.
Well, she wouldn't have done it before the fact, right?
Very true.
Okay, so why, do you know why, did she give you any information on why she filed those charges at that time?
No, she did not.
Okay. How did you learn that those charges were filed?
All hearsay.
Okay. Did anybody above the rank of officer of the at least 10 people that told you about what happened on the ice, were any of the 10 people who told you what happened on the ice above the rank of officer?
Yes, there were some sergeants.
Okay. What were their names?
I could not recall to you at this point in time.
Okay. But it's more than one?
I would say so, yes.
More than two?
More than 2 sergeants?
Yeah.
I would say about 2.
Okay. Did you ever expect... Did you ever hear anything from anybody above the rank of sergeant regarding what happened on the ice?
No.
Okay. Why did you leave DCI?
Personal reasons? Well, no. I left DCI to promote and transfer to Oak Hill.
Okay.
I'm sorry, because to do what?
I promoted to sergeant.
Oh,
So I transferred and promoted at the same time.
Okay.
and that was to Waupun?
That was to Oak Hill.
Okay.
That's a pretty good position, though, right? I mean, Oak Hill's better than DCI.
No, I hated it.
Doing something every day.
Yep.
Did you ever file any complaints while you were working at the Department of Corrections?
No.
Okay. And do you believe that when you told the Department of Corrections investigation that Miss Miller was discriminating against young females, do you believe that they took that seriously?
In my perspective, I would say yes.
Okay, why is that?
They did follow the documentation that was necessary as far as I was aware of the investigation. As far as however far it went up to Madison,
Okay.
that I don't.
And
Don't know.
how long after you gave this, let me just, on 2/25 of 20, did you leave DCI?
a year and a half later.
Okay. So in that year and a half, did you observe a change in Alicia Miller's behavior towards young females?
Not particularly, no.
Okay. Do you think the rumors at DCI against Joanna Stolar affected her ability to do her job?
It could have.
Cool. And did you ever hear Joanna Stolar complain about how she was treated after the fishing event?
Yes.
Okay. What was the nature of those complaints?
She felt as though nothing had been, or that it hadn't been dealt with correctly.
Okay. And you don't disagree with that, do you?
I can't really say that I do or don't.
Okay. But, and to be clear, you, as far as I understood it, you testified to at least one example of where you believed that Lieutenant Miller was discriminating against you because you're female, right? Okay. Did that happen before or after you gave this interview on the, I think it was 2/25/20?
Before.
Okay. How about after? Anything happened after?
Yeah, actually when I left. I had found out through another party that she was spreading a rumor about me.
What was the nature of that rumor?
That I was a crackhead.
Oh, okay. Are you a crackhead?
No, I've never done crack in my life.
Okay. And how did you learn that she spread this rumor about you?
From a captain.
Okay. What's his name?
Lieutenant Coulibaly.
Okay. And do you have any understanding of why she would make that comment about you?
Because at that point in time, while I was at DCI, I had a very significant amount of events that happened in my personal life.
Okay.
I had my significant other leave me. I changed my diet. I lost a lot of weight. I was working a lot of overtime. So when people do drugs, they lose a lot of weight. Well, I just changed my diet and my nature, but my everything else was intact. So, and I still have my teeth.
Okay. And I know you weren't working there at that time when you learned that, but how did that make you feel when you learned that?
Furious.
Okay. And do you believe that the department had the department taken some disciplinary action against Alicia Miller, that she would have made that comment against you at that time?
No, I don't think she would.
Okay. Really good question. Did you ever observe Lieutenant Miller try to make other younger females out to be slutty or promiscuous?
Yes.
And how so?
There were at least 2 other officers that I worked with that she gave a hard time to about that situation. And there was an investigation that was done about that as well.
Okay. What do you know of that investigation?
I know that these 2 young officers did not do something that they should have done at work. They made a list of all of the male subjects that they thought that they would have sexual relations with, and they would rank them.
Okay. And sorry, and I lost you because I think I've heard this a different way. But
Yes.
how did you come across these lists, if at all?
I was not emailed them or sent them, but they were all through hearsay.
Oh.
And actually, after the one officer that was involved left, the other officer that was involved and I talked about it.
Okay. And
I never seen the list though.
I understand. And is this more than one list or just one list?
One list,
Okay. And how many people authored this list?
as
2.
far as I was aware.
And the sex of these 2 people?
That made the list?
Yeah.
Female.
Okay, and what is the rank of those people?
They were officers.
Okay. Do you believe that Lieutenant Miller knew about that list?
She found out about it, I'm sure.
Okay. Did she do anything about it to your knowledge?
I don't think she particularly did something about it.
Okay.
But I believe I know somebody else did. I don't know who, but it was dealt with.
Okay. And so we understand this is 2 female officers are writing a list evaluating the male officers on sexual attractiveness. Is that fair?
Mm-hmm.
Okay. And the Department of Corrections, you're saying they knew about that?
They found out about it, yes.
Okay, and you're also saying they investigated it, right?
As far as I'm aware, yes.
Okay, would it surprise you to learn that the Department of Corrections has not produced any documents relating to that investigation to us?
Yes. I don't know. I thought there was an investigation done.
And why? How did you come to that belief?
Hearsay.
Okay, somebody
And
said.
it was almost 5 years ago too. So
I understand.
it's a good possibility that I might be getting it mixed up, but
With
I don't-
another investigation?
I wouldn't be surprised.
Okay. And so, again, it's your recollection here today that there was an investigation in regard to the sexual attractiveness list.
There should have been.
Okay, and you also heard that from Lieutenant Koulibaly. Is that fair?
I wouldn't say specifically from. I don't think Lieutenant Koulibaly was working there at that point in time.
Okay, I may have confused that. I'm sorry. And then let me start over because I'm thinking about lunch. Who did you hear that rumor from, if I ask that again? I'm sorry.
The investigation
Yes,
was
please.
done. There were multiple different people. I can't recall of who had stated it otherwise, but like I said, it's wildfire.
Okay.
So everyone talks about it.
And would any of these people have been sergeants?
Oh yes, absolutely.
Okay. And just for recapitulation purposes, sergeants told you that there was an investigation, you don't know the outcome of which, into the sexual attractiveness list. Is that a fair statement?
Yes.
Okay. Great. Now, based on your knowledge and experience at the Department of Corrections, do you believe that the rumors about Joanna Stolar affected people's behavior towards Joanna Stolar?
Absolutely.
Can you give examples of why you believe that?
I mean, it affected my view of her an awful lot. Of even being a female, of trying to relate to her, it was hard.
So, you were isolated from her, more isolated from her than you would have been, is that fair?
I wouldn't say isolated, no, of that we couldn't interact, but it was very, not that you couldn't interact with each other, I chose not to.
Did it affect your working relationship with her?
Yes.
Okay. And so, at some point, it's fair to say that you believed, at least in some part, that Joanna Stolar was promiscuous because of these rumors?
Yes.
Okay, and that affected your working relationship with her?
Yes.
Okay. And you also, based on your knowledge and experience working at DCI, saw other people treat her that way? Is that fair?
Yes.
Okay. And other people made comments about those same things, true?
Yes.
Okay. And just finally, to compare people treating Joanna Stolar a certain way because of the rumors, do you believe, and I guess we're going to have 2 parts to this question. So the first one will be, do you believe that what happened to her at the fishing trip, is it all related to how people perceived her because of the rumors?
Do I believe what happened there is why certain people treated her the way that she was treated?
That's right.
Yes.
Okay. And you also explained to us, and this is the second part of that question, I think, that afterwards there was comments, for lack of a better word, that she wanted it, she invited it, things like that.
Yes.
Okay. And I don't know if I understood this to be the case, but at that time when you heard those, did you believe those to be accurate?
Yes.
Okay. And do you believe the reason that you thought it was accurate was because of these rumors about Joanna Stolar being promiscuous?
Yeah.
Okay. Thank you very much. I don't have any more questions at this time. I assume they will, but we'll see what happens. The judge may also have other views.
Okay.
For example, lunch. Yeah.
Why don't we, can we do this after lunch?
Let me finish writing down what's in me.
Judge, I think people want lunch.
No, you're kidding, right?
Uh-huh.
Okay, all right. Just so we know when to come back, how long do people want? I don't know where anything is in Madison.
Me too.
Have no
45.
clue.
At least 45, please.
Okay, I don't know. There's like a little cafeteria thing in here across the hall. I don't know what it has, if it's even open. Is it closed?
For the duration.
See, you know, it's like they've got the sign. I was all excited.
There should be food carts on the square.
Oh.
There are food carts, and there's a coffee place that serves sandwiches on the corner.
Okay, all right. It is now what 20. What time would everyone like to come back? How long do you think we need?
2:10.
2:10? Or
That's my 50 minutes is my suggestion, but I am willing to entertain anything.
2:10, 2:15? What do we want?
That's an awfully long lunch. Although I happen to be one of these people who sits at my desk and eats.
Well, I do too. But I don't know how far things are to walk. I mean,
Oh, that is true. That is
you know,
true.
and then you got to wait in line because other people might be there, and we're not going to eat in just 2 minutes.
Okay.
So why don't we come back at 2:15? Is that reasonable to everybody?
That's
And we'll go on the honor roll then, and I won't look at your papers and you won't look at mine, and we'll all just deal.
Yeah.
All right.
Great.
I'm now going to stop the recording.
I have to do it. So the best one I got to counter that is I told them I'm way smarter than them.
Did it work?
I mean, based on the answer, the evidence is otherwise, so I had to.
Okay. All right.
It's a long job, but I had to do it.
I appreciate it because it's a constant battle that I just felt like dealing with. It's stupid. It's a dumb assignment. I don't understand why I have to do this. And my response is, because you were told to. All right. Welcome back, everyone. We are back on the record. And CR 2020-02513 appearances are the same. And we still have Miss Alicia Bishop on the stand. Complainant has rested with in terms of direct. And now we return to the respondent for cross. And I don't know who's going to be doing what. So if you could let me know which one of you is going to be doing it.
Yep. This is Attorney Andrea Olmanson for the record, and I will be conducting the cross-examination of Ms. Bischoff.
Thank you. Miss Bishop, you're still in row. I'm not going to make you do the whole
Thank you.
handy up thing again. You're welcome, ma'am.
Okay. Now, earlier you testified that you had not spoken with anyone at the table about the testimony that you were giving today, correct?
Correct.
Did you ever speak with Joanna Stolar about it?
No.
Did you speak with any other person about it?
No.
Okay. You testified that you resigned from the DOC for personal reasons, correct?
That is correct.
Now, you actually resigned under investigation because you were in a dating and sexual relationship with former inmate Brandon Christian. Is that correct?
Yes, that is correct.
Okay. And he was confined at Dodge Correctional Institution at the same time that you were working there, right?
That is correct.
And you were, struck that, you resigned before you could be fired, right?
That is correct.
Thank you.
While we're waiting for the next question, does anybody find it warm in here, or is it just me because my sugar's bouncing all over the place?
It's very warm.
Would anybody object to us trying to turn the temperature down a little bit?
I would not object.
Does anybody who is not vertically challenged know how to reach the thingy up there and turn it down. I'm not 5 feet tall.
Vertically challenged, though. I like that.
Just fun sized.
I heard somebody say that for the first time,
Really?
that they refer to short people as fun size, and I'm kind of, oh, you mean like the Halloween little bite-sized candy?
I feel like it's down all the way.
Is it?
Yeah, maybe we open the door.
Absolutely. I just didn't want people to interrupt or be noisy in the halls. I think we're
close it if
okay.
it's a problem, but okay.
Yeah, absolutely. Great suggestion. I just feel like it's really, really hot.
I'm gonna open this one.
And I just, my sugar seems to be fine, so that's usually an indicator when I start dropping. My apologies for interrupting everyone. Okay.
Now, I'm going to skip, or start that. I'm going to start here by, actually I already did start. Okay. Let's talk about some of these rumors.
Okay.
Can you please identify by name every person who told you any sort of rumor about Joanne Stolar?
I mean, you could probably write down the entire DCI staffing institution during the 2019 period to, at least in my time, DCI. We're pretty close to it.
Okay, name by name every person, please.
Well, Kyle Peters was one of them. Let's see. I mean, that generally talked about the rumors or discussed it or just spread it.
Any person who told you rumors about Joanna Stolar.
I'm going to interrupt just so we can be a little bit more specific, please. There are a variety of rumors going on so far through Ms. Bishop's testimony.
Mm-hmm.
They're just general rumors about sexual innuendo with other co-workers.
Mm-hmm.
And then we also have this whole rumor mill happening subsequent to the lake event. So if we could categorize those and be a little bit more specific, I think it would help for my findings of fact. Any objection?
Thank you, Judge. Helpful.
Yeah, that's fine if you want to do it that way. I was going to get all the names and then go through them to do that.
I just
but-
figure if we can just do it one at a time, because otherwise
Sure.
we're not backtracking, and it might help her with her memory recollection.
Okay.
It's an awful lot, and it's been a long time, so.
And it's okay, if you don't understand a question, please ask them to repeat it, they will. And if they have to repeat it 3 different times to make sense, they're gonna do that too,
Thank you.
okay? And if you don't know, that's fine, okay?
There is an awful lot of staff at DCI, and as far as telling me and specific dates and about what specific rumor is hard to recall. And looking up staffing schedules is one thing. As far as who and names,
We'll start with Kyle Peterson.
yeah.
What did he talk to you about?
Well, he was my representative for this. Even though we talked about all of the rumors together, me and Kyle did. I'm trying to remember names, and I remember faces more than anything, but Andrew Murphy was one. Let's see. I mean, telling me specifically and hearing about it in a general area is another thing. I guess hearing about it, it would be like Michael Severson, Jake Hintz, Noah Bentz, Marty Hoffman, Tom Mariani, oh, that's mainly second intake. Trying to remember a couple of others. Tiffany Ertle might have been one. Michelle Fenz. George Kramer. Kevin Summer. Mackenzie Roberts. Adam Tank. Nate Tank.
Who was the first tank?
Adam. Sorry, I'm trying to go through units in my head and who all worked to all of them.
Do not feel rushed, please. Okay? It's
Thank you.
hard. This is a long time ago.
It was.
Okay. But all these people you've listed thus far talk to you specifically about the rumors, and these I'm assuming we're dealing with first just the sexual relation type thing. We haven't gotten to the
Either talked with me about it or talked with me around.
enough so that you heard it coming from them. Okay, but we haven't gotten to the fishy thing, right? Yet.
Those, I would say, generalizes all of it.
Oh, so this is all these people heard one or the other or both.
Correct. Of all of the generalized
Okay.
rumors.
Thank
I know you guys are trying to do which incident, but I can't.
It gets jumbled after a while.
It does.
But these people you heard say something about one or both.
Yes.
Thank you.
Jeremy Beck. Let's see. Brandon Mason. Cam Anderson. Jeff Dirksen. Joe Radcliffe. And if there were others, I can't recall their names.
Okay. What specific rumors did you hear about Ms. Stolar come out of Kyle Peters' mouth?
Who she was sleeping around with at the time. Rumors about her showing up at a lieutenant's house that had a wife and kids. Rumors about plastic surgery gone wrong.
Pardon? You said God wrong?
Gone wrong.
Gone wrong.
Yes. The multiple people that she slept around with, I think I already said that. I do apologize. The fishing trip was one of them. Why she wouldn't show up to work. Multiple reasons, multiple times. Why she was on like duty. I don't know if there's anything else.
Now, her showing up at this lieutenant's house, okay, could that have been a captain's house?
I do not, he was not a captain at the time,
Okay.
if he ever was. But I only believe he was a lieutenant at the time that I was there.
Was that Nicholas Farley?
Yes.
Okay. Did you ever discuss with Joanna Stolar her showing up at that house?
No.
What did he tell you about her showing up at that house?
That it went very, very bad. He was there with his wife and kids, and she basically said, "You're going to choose to marry her," and he told her to leave.
Now, regarding Kyle Peters, can you identify the name or names of the people that he said she was sleeping with?
So Nicholas Farley, Jeremy Beck, for sure. I don't recall any others.
Did you ever talk with Nicholas Farley about Ms. Stolar?
There was one conversation that was not over in person. It was over Facebook. I don't recall how that went, but I don't believe it went very well. I can't recall the conversation, but I know that there was a conversation.
Were you ever dating Jeremy Beck?
We had relations that were very, very short-lived.
Did you ever tell anybody at work about that?
Yes,
Who?
Kyle Peters.
Anyone else?
Not that I can recall.
Why did you tell Kyle Peters that?
He was my mentor, someone I trusted, someone I looked to as a friend. I actually hung out with Kyle outside of work. I've met his wife, his kids. I actually have 2 pets from him, litter kittens.
What did Kyle Peters tell you about the plastic surgery gone wrong?
So apparently she had a breast job done and it didn't do her any good, and apparently they were hard as rocks.
When did he tell you that?
I don't recall.
Was it before or after the fishing event, if that helps you recall?
I would say before.
Did he tell you how he learned?
I I believe through hearsay.
Okay. Did you ever repeat that to anybody, that rumor?
Not that I can recall.
Okay. Regarding her involvement with Nicholas Farley, did you ever discuss that with anybody other than Kyle Peters?
Everybody did.
I'm sorry, is there facts and evidence that that's the captain/lieutenant that we're talking about? Is there foundation for that?
Yes, there is.
No objection, thank you.
Okay, so can you tell me can you name by name everybody that you repeated that rumor to?
Probably everybody on that list.
Okay. What did Kyle Peters tell you about the fishing trip?
That there was a bunch of people that drank a bunch or way too much than they should have. I don't remember the details of it, but that Jason Toutant had not even brushed. It was, I think they were on a four-wheeler together, and he came up behind her, either on a four-wheeler or they were standing there, and he grabbed her. And I don't think she objected to it, if I remember the story correctly.
But you're not positive you're recalling it correctly, right?
I don't. I can't say.
Was it in front or from behind?
From behind.
Okay.
What did Kyle Peters tell you about why Ms. Stolar allegedly would not show up for work?
That she was lazy, or the fact that she was burned out like the rest of us. She was sick all the time, or calling in all the time. Nobody really knew the reason truly why, but we just assumed, like everybody else, of burnout, and I knew that she had kids too. So, and now being a mom myself, I know that's not an easy thing to deal with, especially with that schedule.
What did Kyle Peters tell you about Ms. Stolar being on light duty?
That it had to do with the fishing trip.
What specifically, if you know?
They were restricting her hours, mainly for mental reasons, as far as I can remember.
But you might not be remembering correctly, right?
Correct, yes.
Okay. Now, regarding Kyle Peters, did you ever discuss anybody else's sexual relationship with him? Like any other coworkers?
It's a good possibility. I know I disclosed my own.
Okay. Did you ever discuss anybody else's non-attendance at work with him?
Yes.
Whose?
Andrew Murphy's. There was a couple of new people. I don't remember their names.
Can you describe them, please?
No.
Were they male or female, or one of each?
Male.
Can we call them male number 1 and male number 2?
Sure.
What did Kyle Peters say to you about Andrew Murphy not showing up for work?
Oh, that he was very weird. He had a lot of mental reasons, but also the burnout. It was a big topic that we discussed. Yeah.
Okay. What did he tell you about male number 1? How about male number 2?
That they had no idea what they were doing. They were putting everyone's safety in jeopardy, not just ours, but the people in our care. They should have never been let out of training. And went online is a term that we use.
Went online?
I'm sorry,
What do you mean?
Went online.
Went?
Went online.
What?
So when we do our how many weeks of training, and then we do on-the-job training, and then going online just means that you are on. You get fed to the wolves. You're on the schedule.
Oh, I thought there was more training online.
No, nothing actually to do with computers.
Huh. So you went live.
Yes.
Okay.
Now, I asked you about rumors about sexual relationships. Did you ever discuss at work people's dating like coworkers' dating relationships?
Yeah, everybody did. I'm sorry, you probably want to elaborate.
Sure. Why don't you explain, please?
I mean, everyone at least tries to be friendly and know, have some interest in each other's lives. So coworkers normally do. Well, how is your wife? How is your girlfriend? How are you doing? What did you guys do this weekend? Stuff like that.
And then some of the information that's related in these conversations then gets repeated to others, correct?
Yes,
And
they
that-
can.
Okay. Do you recall any specific dating relationships involving your coworkers that you discussed with any coworker while you were at Dodge?
Yes. I know Tiffany Erdl and Jeremy Beck had a relationship a long time ago, on and off. I didn't know this until now, of Marty Hoffman and one of the psychologists. Brandon Mason and one of the inmate recorders, or reporters I should say.
One of the inmate who?
So they are a, she worked in records,
Okay.
in intake records, my apologies, is her technical term. Andrew Murphy and I had a relationship, very, very short-lived. Adam Tank and Mackenzie Roberts, Kevin Summer and Mackenzie Roberts. I do believe there are others, but I can't remember who specifically and their names.
For clarification, the question was, do you recall anyone who was dating in their relationships, and if you discussed that with other people? So is that your answer? These are the people you recall and you discussed with other people?
It was very open, but yes.
Okay.
Now, you had testified earlier that you had heard, well, you gave me the list of people that you had heard rumors about Stolar come from. What about, we'll strike that, what rumors about Joanna Stolar did you hear come out of Andrew Murphy's mouth?
The fishing trip was one. reasons for her call-ins of numerous excuses of she was lazy and pretty much that. Of didn't want to come in, didn't want to do her job.
Any other rumors come out of his mouth that you heard?
Not that I can recall.
Okay. Did he ever talk to you about any other coworker calling in?
Any other coworker calling in?
Yeah.
Yes, but mainly his group of people, of the second intake guys,
Okay.
Unit 18 and intake.
Who are those people? What are their names?
So you, Jeff Dirksen, Jacob Hintz, Adam and Nate Tank,
Adam who?
Tank.
Did you say Adam and Nate Tank? Okay, thank you.
Both of them. Are they brothers?
No, cousins.
Oh, Adam and Nate.
Michael Severson. Severson, sorry. I think that's how you say his name. Luke was his first name. I think his last name started with a K. There was also Sergeant Cast. Luke Catsey, that was his name. Catsey. I can't recall any others at this point in time.
Okay. What did Andrew Murphy tell you about Jeff, is it Dirksen? Dirksen, not coming in?
Oh, that he was always fishing, so that would be a reason why he would take off, or that he was hungover. And that's why he wouldn't come into work.
Okay. What did he tell you about Jacob Hintz not coming in?
The burnout.
How about Adam Tank not coming in?
Burnout.
How about Nate Tank?
If he needed a day off to spend some time with his wife.
How about Michael Sievertson?
Section cumulative.
This case is partly about rumors, Your Honor. And there's an allegation that one of the complaints is that all of these rumors surrounding Ms. Stolar constituted a form of harassment. That's the theory of this case, that there were all these rumors circulating behind her back, and that was a form of harassment. And so I think that it's fair to go into other types of other types of gossip that went on to show that it wasn't confined to Ms. Stolar. There was gossip about everybody, and it was about all and sundry.
I'm gonna overrule. It seems like what we've talked about, people being fishing, hungover, burnout, time to spend with wife. I think we've established that there's a variety of reasons that people were talked about. So I don't want to be cumulative, so I'm hoping the list is stopped.
Okay.
Because I think 6 people is more than sufficient for you to establish that there are other rumors going around.
Okay.
She mentioned Michael Severtson, and that's when we had the objection. So I don't believe that that's answered. And then the last person on the list was a Mr. Luke Katsky. I may have spelled it wrong. I have no idea. But that's going to be it with this topic. No more.
Okay. What did Michael Sievert, or start that? What did Andrew Murphy say to you about Michael Sievertson not coming in?
Multiple reasons of being hungover, the burnout. He also had a son himself. And also just because he didn't feel like it.
Okay, how about Luke Katsy? What did Andrew Murphy say about Luke Katsy not coming in?
Pretty much all the same reasons. He had kids, so to be able to spend time with them. He worked third shift, so getting ordered was a big thing too, going from third to first, and having some time, but not a whole lot. The burnout.
Okay. You testified that you had heard rumors about Joanna Stolar that were said by Michael Sievertson, correct? Is that a yes?
Yes.
And what rumors about Joanna Stolar did you hear come out of Michael Sievertson's mouth?
The fishing trip, the relationship with Jeremy Beck, the relationship with Nicholas Farley, reasons she called in, reasons she was on light duty. Basically that she was a whore.
And what did he give for reasons that Ms. Stolar called in?
The burnout, very few times about her kids, just because she didn't want to deal with work, the responsibilities.
And did you ever hear gossip about any other Dodge Correctional Institution employees come out of Michael Sievertson's mouth?
Yes.
And who else did he gossip about?
About Brandon Mason, Andrew Murphy, Luke Katsy, Sergeant Cast. There's probably more, but I can't recall.
Did Michael Sievertson ever discuss with you who might be sleeping with whom other than Ms. Stolar's relationships?
Yes.
And who?
His own with one of my friends. Mine. Adam Tank and Mackenzie Roberts. There's probably more, but I can't recall.
Who was your friend that you referenced?
Samantha Blahovty.
What's her last name?
Blahovty.
Okay. What rumors regarding Joanna Stolar did you hear come out of Jake Hince's mouth?
Not a whole lot, but mainly it was just that she called in again and she was lazy and didn't want to show up.
How about Noah Bentz? What rumors about Joanna Stolar did you hear come out of Noah Bentz's mouth?
The same as Jacob Hintz. But also the fishing trip. I believe that's it.
What did Noah Bentz tell you about the fishing trip?
The same thing everybody else did.
Okay. Was the discussion about the fishing trip something, well, strike that. Do you recall when approximately this fishing trip was?
I don't.
Okay.
I know it had to be in the winter months when the ice was thick enough.
At some point, did the rumors about the fishing trip taper off?
Probably by summer.
What rumors about Joanna Stolar did you hear come out of Marty Hoffman's mouth?
The fishing trip. That would be it.
What did he tell you about the fishing trip?
Same thing everybody else did.
Well, what was his version, if you recall?
I don't.
What rumors, let's see here. What did Noah Bentz tell you about the fishing trip?
I believe he was there, but that he was intoxicated and couldn't recall all of the rest of the details or didn't notice it and didn't see anything happen, but that he was there.
What did what rumors about Ms. Stolar did you hear come out of Tom Mariani's mouth?
That he was there, but, oh, I'm sorry, that's not what you asked, I apologize. Mainly it would be the fishing trip, I don't recall anything else. And the fact that he was there, but he was intoxicated as well, and didn't see anything happen.
How about Tiffany Ertle? What rumors about Ms. Stolar did you hear come out of Tiffany Ertle's mouth?
That she was lazy, she called in again. She didn't do her job. I believe that's it.
What rumors about Ms. Stolar did you hear come out of Michelle Fence's mouth?
That she didn't come in again. She didn't do her job. I believe that's it.
What rumors about Ms. Stolar did you hear come out of George Kramer's mouth?
He was glad she wasn't on his unit as an officer, that he didn't have to deal with her, that she was somebody else's problem. He didn't have to didn't really have to worry about her calling in. That it affected him, but it didn't. The support officers would have to take over her position, or we would have one less person.
What rumors about Ms. Stolar did you hear come out of Kevin Summers' mouth?
that if she was there, but as a support officer wouldn't be, and he would have to work with her. He wouldn't be there. He was one of the support officers on the other end, or the same end as her, and he didn't like to have to go down there.
Did he
Yeah.
say why?
He didn't like the way that she ran her unit.
What exactly did he say?
He didn't like the way that she ran her unit.
Did he give you examples?
The mood chart was one of them. That was a big issue with multiple different people, including Lieutenant Miller.
And getting back to the mood chart, so you say it was a big issue with multiple people?
Mm-hmm.
And did you hear that from multiple people?
Mm-hmm.
Who were those multiple people?
Kyle Peters, Tiffany Ertle, George Kramer, Olive Second Intake thought it was ridiculous. And I know the rumor of how that all happened too, of when Miller came down and tore it off the wall.
Okay. Now you say Olive Sagan Intake thought it was ridiculous. They thought her chart was ridiculous?
Yes, and her.
Okay. What did you hear from Kyle Peters about that mood chart?
I don't remember if he was working or not when she implemented it on her unit. I don't recall. But he said that he would have done the same thing that Lieutenant Miller would have done.
Okay. How about George Kramer? What did he tell you about the mood chart?
He couldn't believe that she did it.
And anything else that he said?
That it was ridiculous and they should have done it. It shouldn't have ever been a thing.
Okay. What did Tiffany Ertle say?
Pretty much the same thing. She couldn't believe that she had even thought of doing that and actually posted it on the wall.
Okay. And getting back to Kevin Summer, are there any other rumors about Ms. Stolar that you recall hearing coming out of his mouth?
There could have been a possibility of her relationship with Nicholas Farley.
That you don't recall specifically?
No.
Okay. What rumors about Ms. Stolar did you hear come out of Mackenzie Roberts' mouth?
That she was a whore. She slept around with multiple different people, who she slept around with. She called in again. She was on light duty. I think that's all I can recall.
Okay. And can you give the list of people that Mackenzie Roberts said that she was sleeping with?
Nicholas Farley, Jeremy Beck. I don't recall if there were any others.
What rumors about Ms. Stolar did you hear come out of Adam Tank's mouth?
Would it be possible if I could take a break?
Yes, oh, absolutely. Yeah.
Thanks for asking. We just keep going if you don't tell us something, so thanks for asking.
Yeah.
Yeah.
So you listened earlier, yeah.
Thank you.
Anytime you need a break, just please speak up, okay?
Thank you.
Yes, absolutely. I'm going to.
Michelle, I would
Okay.
be happy to talk to
We
you
are-
about that first thing in the morning.
Okay.
And we'll sort that out.
We are back on the record. Appearances are the same. Prior to going back on the record, respondent has advised all of us that they have a witness who is going to be leaving the state or going out of country. She wanted to ask if her witness could testify out of order and appear sometime tomorrow. Attorney Hitchcock Cross was consulted. He already has a witness plan for first thing tomorrow morning, but it does not appear that there's an objection to the respondent calling their witness out of order in the afternoon. Is that the general consensus from the parties?
Yes, Judge.
Okay, so we're granted. Just for the sake of my notes and records, do we have a name for this individual so that Attorney Hitchcock Cross can also prepare?
It's Carrie Beyer, B-E-I-E-R.
I don't. Okay, it's on the list, right? The name spelling? Okay.
We're all old friends here, Judge.
Huh?
We're all old friends here, Judge.
Well, I'm not. I don't look at everybody's. It's like I just go by what's filed. All right, Carrie Beyer. Okay, I'm not sure how that's spelled, but I'll look it up. Okay, we are back with Ms. Bishop. You may proceed with your questioning.
Okay. Could you please tell us what rumors regarding Ms. Stolar that you heard come out of Adam Tank's mouth?
Her relationship with Jeremy Beck, Nicholas Farley. That she had called in again. Light duty.
What did he say about light duty?
Not a whole lot, just that she was on it.
What did he say about her relationship with Beck?
It was very short-lived.
What did he say about her relationship with Farley?
Very complicated and ongoing.
Okay. Did he ever talk with you about other co-workers' romantic relationships?
No, not really.
Did he ever talk to you about other people calling in again?
Yes, but I don't recall who.
Okay. What rumors about Ms. Stolar did you hear come out of Nate Tank's mouth?
The fishing trip. What about it? I can't recall. Just that I believe he was there.
That's
I
it?
apologize.
Oh,
Sorry.
that's okay. Did you ever hear gossip about other coworkers come out of Nate Tank's mouth?
Not out of the norm, no.
What rumors about Ms. Stolar did you hear come out of Jeremy Beck's mouth?
Everything that I listed before of the fishing trip, calling in, the mood chart, didn't talk about their relationship.
Did or did not?
Did not.
Okay.
And I believe he mentioned her and Farley's relationship.
Do you remember anything specific that he said about Farley's relationship with her?
That it's been happening for a long time.
What do you recall him saying about the fishing trip?
I don't recall what he told me specifically.
What did he say about the mood chart?
I don't recall specifically. I know it got brought up though.
Okay. What rumors about Ms. Stolar did you hear come from Brandon Mason's mouth?
I don't recall.
Okay. What rumors about Ms. Stolar did you hear come out of Cam Anderson's mouth?
I believe just the fishing trip.
What did he say about the fishing trip?
I don't recall.
What rumors about Ms. Stolar did you hear come out of Jeff Durkinson's mouth?
The fishing trip, she was a whore, relationships with the multiple people, namely Farley and Jeremy Beck. I don't recall any others. Calling in, light duty, what he said about it, I don't recall though.
And did he talk about, let's see here, what did he say about her calling in?
That's happened more than once, and more than once in a week.
Okay.
Sorry, go ahead.
No, you can finish your answer, sorry.
It was a very regular occurrence that she would call in.
Did he find it frustrating that she would call in?
We all did.
And why is that?
One less person around the institution.
Okay. What did Jeff Dirksen say about her relationship with Mr. Farley? If you recall.
No, I don't.
What rumors about Ms. Stolar did you hear come out of Joe Radcliffe's mouth?
It would just be the fishing trip, and I don't recall what his perspective was on it.
Okay. Do you believe that do you have information that Ms. Stolar herself was the source of any rumors regarding her relationships?
What do you mean?
Do you believe that, I'll rephrase it. Do you possess any information suggesting that Ms. Stolar herself was telling people about any sexual relationships that she may have had with any staff member?
Not that I can recall.
Okay. Okay. Just a sec here. Okay, can we please go to, well, actually, it's the exhibit that you've got right there in front of you. Okay. I'd like to scroll down here. Now, it looks like, first of all,
Excuse me, can you identify the exhibit for the record?
I was going to,
complainants
since
one.
I wrote them down.
Excuse me then.
Okay, no, that's okay, because I want to make sure we're on the same thing. Because you didn't take it back, right, after
Right,
this
I
for
think, I
recollection?
assume, I'm not sure. I
Okay.
assume that's the same.
All right.
What's the number on
I'm going to ask you, Ms. Bishop, the piece of paper that you have in front of you should have some numbers on the very bottom of it. Could you tell me what those numbers say, please?
000993
Okay.
and 994.
Okay. Those have been offered by the complainant, and they have been marked and admitted into evidence. That is, for the purposes of this hearing, labeled as C1, complainant's first exhibit. It is ERD bait stamped 993-994. Were you able to pull them up?
Yep. Okay.
Okay.
Now, it indicates on here that you were interviewed on February 25 of 2020. Is that correct?
That's what it says.
Okay. Do you have any reason to dispute that?
Nope.
Okay. Now, I'd like you to go to the bottom of the first page of that exhibit. It's Bates ERD 993. There was a question. Have you witnessed Miller treating females differently than males at work? And the answer was yes. When I started here, that was one of the first things I was warned about. If you are new and a female, you are completely screwed because she does not like you. She has treated me different than senior female officers. She finds things to nitpick about, for example, if you have a nose piercing. I realize it's against policy, but several people, males and females, have facial piercings. So there are many with piercings. But she would nitpick me because I just got it done. She will say things to me about it, but not older staff. Is that something that you said?
Yes.
And was it true?
Yes.
Okay, just a quick sec here. When you were working at Dodge, did you ever learn that Ms. Stolar was attending school for anything?
No.
Okay. Now you testified earlier that you learned through another person that Alicia Miller said you were a crackhead.
Yes.
Who was that other person?
The Tom Coulibaly. I believe she referred to me as Crackhead Bischoff.
Now, you testified that Joanna Stolar told you that the incident at Lake Emily, or the fishing trip incident, hadn't been dealt with correctly. Is that right?
Sorry, one more time.
Okay. Am I correct that you testified that Joanna Stolar told you that the incident that occurred during the fishing trip hadn't been dealt with correctly?
That's correct.
Can you please elaborate on what exactly she said?
I believe it was just that. I don't truly recall, as when she said it to me, I was intoxicated.
And where were you when this conversation occurred?
I was in Watertown at a bar, and I did not expect to see her, I haven't reached out to her or anything. We just saw each other and talked about it.
When did that occur?
Probably about a year later, after the incident.
So maybe in early 2021?
Yeah.
It's okay if you don't know, okay?
I
You
believe
don't feel like you're being forced to pigeonhole yourself into a date,
Thank you.
okay?
Okay. Now, you testified earlier about Alicia Miller focusing on 2 other young officers and something about a sex list. Is that correct?
Mm-hmm.
Can you please elaborate on that?
About her, elaborate on Miller knowing about it.
No, what role, if any, did Miller have regarding the sex list?
She was a supervisor at the time, and I'm not sure how it was handled or if she was the one handling it. But she was a supervisor at the time.
And let me see, what criticism do you have about Ms. Miller regarding how she handled the sex list?
Probably any of the criticism I would have given any of the other supervisors if I don't believe it was handled correctly.
And how wasn't it handled correctly?
They both had jobs still.
Are you sure about that?
I believe that Brooklyn Lutz resigned shortly after on her own, and Martinez, I believe she had a punishment from it, and she ended up, she had a punishment, and either she resigned or she did get fired, but she was able to come back to the state.
And what do you think should have happened?
If they were males, they would have been fired on spot.
Okay.
Some question. So this, I call this the mood chart. Is that what we're talking about?
Talking about the sex list.
Oh, the sex list. Okay. And there was Martinez and a Brooklyn Lutz.
Mm-hmm.
Those were the two that were involved with this list?
Yep.
Okay.
Federal court
I
is
now know
sending
why
me.
this is going so.
What unit did you work on?
I now
Oh, I'm
understand.
sorry.
Ben Hitchcock cross case, Jeff.
What unit did you work on?
I was a utility.
So you moved from unit to unit?
Yes, ma'am.
What does utility do?
So, because we are so vacant, and even at the time that I started, wasn't as vacant as we are now, but basically, utility was a job that you took, that you got put in any unit that was open from call-ins or wasn't staffed.
So basically you just got moved around as needed?
Yes.
Okay.
Later in my career, I received a Monday through Friday transportation job, but also, if I didn't have a trip, I was a utility. So.
Did you ever discuss with Joanna Stolar any rumors about other people?
Not that I can recall. I believe we only worked together a select few of times.
Did Joanna Stolar ever disclose to you that she was in a relationship with Nicholas Farley?
No.
That's all I've got.
Do you need another break? I will have a few more questions.
No,
Okay, I'll try to get you out of here as soon as possible.
that's fine.
Okay, appreciate
I'll have questions for you, don't worry.
it. Great.
Okay, this is called redirect, okay? So he now gets to ask you some questions, but they're gonna be based on this and rehabilitation and that sort of thing, all right? So,
And there is a few things that I haven't understood, so hopefully we can start with that. I think I got, there's the sex list, I guess we're calling it that now, okay? There's another document that's called the mood list. I don't understand what that is. Can you explain that to me?
The mood chart. So That was something that Stolar implemented on her unit. It was a chart with colors of that was directed for the people in her care on the unit. If she had a red color, it was don't talk to me, don't come up to my desk. If it was a blue one, it was more or less tread lightly. If it was a green one, then you were free to talk to her.
Oh, it was posted, and so the people in the charge in your care, it was for them to look and decide whether or not they were going to approach one of the officers?
Just her specifically.
Okay.
Oh, I completely thought that was something. Okay, thank you.
Okay. And then I think there's another question I didn't understand was, and I know this came up earlier, the reason that you're leaving, that you left the Department of Corrections, did that occur at Oak Hill or did that occur at DCI?
That occurred after he was out in the world.
Okay. But the original incident was at DCI?
No,
Okay.
no. Was he an inmate there? Yes, he was. Do I recall him being there? No. I
Okay.
didn't see thousands of faces. And when he got out, he reached out to me because he remembered me.
Okay, and I didn't need to go that far into it. I just wasn't sure when you would answer that the first time if you meant DCI or Oak Hill. But I think I understand now. Okay. We did go through this exhaustive series of all the rumors that you heard, right? Did you ever talk to Miss Stolar about the rumors that you had heard about her?
I might have at the bar,
Okay.
but I don't remember if we gotten to that extent. At that point in time, I was trying to leave, so I don't think we got to talk very long.
Okay.
Is that the same bar you just referred to,
In
like a
Watertown.
year and a half later
Mhm.
when
Yeah.
you had
Yes,
a few drinks?
Yes.
Okay. Were you referring to then or at any time?
I was just wondering. Yeah, okay. I got it.
Okay.
Because I think that was, now I think I got it. So, and going back to just so to help us out here in terms of segmenting this, correct me if I'm wrong, but it seems like there's an original set of rumors that are more or less about her being a whore prior to going to the fishing trip. Does that seem fair?
Yes.
Okay. And then there's another set of rumors after the fishing trip. Is that right?
That has to do with the incident.
Okay. Besides the fact of what happened at the fishing trip, did the nature of the rumors sort of change? Did they get better? Did they get worse? Anything along those lines?
I think they got worse.
Okay. And then at some point, she goes on light duty. Is that true?
Yes.
Okay. And then do the rumors again change to be about her being at light duty at that point?
One more time.
Yeah, and let me ask this question another way. There was a lot of testimony about discussions about her not being at the institution, of other people having to cover for her, etc. Okay, was that while she was on light duty?
Both.
Okay.
When she was full-time before the incident, after the incident, and then I don't even know if you would refer to it as light duty or they restricted her hours to a certain amount. If it was light duty or the restricted. I think I might be getting it mixed up that she was on light duty because she had a medical reason for it. But I remember towards the end, if I'm correct, that her hours were restricted.
Okay. And so did that at all affect or increase the way that people were talking about her being there?
Negatively, yes.
Okay. And did people know that she was out on light duty when they were making these statements? Okay. And again, the supervisors, were they aware of the comments about her being out on light duty?
I couldn't tell you.
Okay. And when we went through the rumors, there was a lot of talk about people being out because they were parents or they had other responsibilities like that.
Yes.
Right, okay. Was there any talk about them being out because they were, acting whorish or something along those lines?
Yeah.
Okay. And was that directed at females?
Yes, but also males.
Okay. And about Miss Stolar in particular, before she went out to the fishing trip, did the comments about her being a whore, did that change after that?
No.
Okay. Then there was also some comments about her, I guess, having plastic surgery. You recall that?
Yes.
Okay, and somebody said something along the lines of her breast being as hard as rocks or something along those lines.
Yes.
Okay. Was that before or after the fishing trip?
I believe both.
Okay.
I think that might have been one of the reasons why the incident had occurred.
Why do you think that?
Because I believe that's where he had touched her.
Okay, and do you think Toutant was aware of those rumors?
I wouldn't doubt it.
Okay, and why do you think that?
Everybody knew.
Okay. And,
If I can put that into perspective for you, I had about a year in, maybe less than that. So a fact of an officer finding that out with less than a year in versus everybody else with so much seniority, I'm bottom of the food chain. So if I'm finding this out, everybody else knows.
okay. And because you've experienced that happening? Okay, I got it. And, did you ever, I guess, let's move on. Do you know Alexander Hartzheim?
Yes, I do.
Okay, and did you hear an allegation that he had requested to see Miss Stolar's breast during the fishing trip?
That sounds familiar.
Okay,
Actually,
did you hear an allegation regarding Mr. Hartzheim and the fishing trip at all?
it does sound very familiar.
Okay.
That from my memory of him being involved in it now that you mention it.
Okay, and other than Mr. Hartzheim, Mr. Toutant, and then the discussion that you had about her plastic surgery or alleged plastic surgery, do you recall any specific incidents about DOC employees discussing Ms. Stolar's breasts while at work?
One more time.
Yes. So we got these 3 incidents of people talking about or allegedly trying to touch her breasts.
Mm-hmm.
Is there any other examples of people, DOC employees, being fixated on Mrs. Stolar's breasts?
Not that I can recall.
Okay. Do you believe that there was a fixation on her breasts at some point during your employment?
Objection, former question.
Well, he's been asking about her beliefs, her opinion, and he's already asked her several questions on that. I'm going to allow the questions to stand. Could you repeat that again, or do you want me to repeat it?
Could you repeat it?
If I can. You had already stated you didn't recall any other conversations or whatever surrounding the breast. And then what was the other one? I'm sorry.
Was it in my time that I had been there?
Right.
Yes.
Right.
Yeah, during the time period, that brief time period you had been there because you had said that's why, if you knew, obviously other people knew because you're at the bottom of the food chain. During that time period, had anything like that, to the best of your knowledge, happened before?
Other than the incidents that we had talked about of
The rumors,
of
yeah.
Kyle Peters mentioning it, and other than the events that we talked about, no.
Okay.
Okay. After the fishing trip, did you ever see Toutant?
I believe I did, but it wasn't at DCI.
Okay.
He was employed by Waupun at the time because I was a transportation officer. I believe I saw him up at the secured ward at UW. But it wasn't there, it was at the bottom. It wasn't on the 6th floor, it was the other one where the holding that I had seen him.
Mhm. Where, okay, and you said DCI and Waupun, are those separate institutions?
Yes, they are.
How far apart are they?
A couple blocks.
Oh, okay. And do they share the same parking lot, for example?
No.
Okay, is it,
Waupun has to park on the street. There's very limited parking for them, whereas DCI has a very big parking lot.
okay, and how about when you're entering the prison? Is there any time that the two groups of officers are interacting during that time?
Not really, no, from the different institutions,
Okay.
between changing of shift, but I don't, unless you have a specific job on like a transportation or anything like that, I don't, there shouldn't be a reason.
Okay, but for the specific jobs, there's crossover.
Yes.
Okay. Okay, and as a DCI employee, was there ever a time that you knew that you were never going to have contact with people from the other prison?
You always had the opportunity,
Okay.
but as far as email was an option, and those specific jobs would be an option to see other people, other employees from different institutions, but
Yeah, okay, but what I'm asking you is, could you be involuntarily placed in such a job while you're at DCI that you would come into contact with Teuton?
it would be a very slim possibility.
Okay. When did you first hear about any rumors about Stolar's breast?
Probably within the year that I was there.
And was that regarding the breast augmentation? Okay. Do you, and I think I asked this for Teuton, but do you believe that Alexander Hartzheim knew about the rumors about her breast augmentation?
Yes, I do.
Okay.
He worked a lot with second intake, I believe, and those guys are a very tight-knit group, and the majority of the people on the list that I had listed, they worked in second intake.
Do you know what the bubble is?
Yes.
What's the bubble?
So the bubble is mainly for, at Dodge Correctional Institution, is what the sergeant controls.
Okay.
So all of the new end units have a bubble where the sergeant controls all of the inmate doors. It's also where officers can take a break to be away for a certain period of time. If they get relieved, you can not be on the unit and in the bubble because you can observe both units from the bubble. So that's, I guess, my best description of that.
Okay. Thank you. I don't have any more questions.
All right.
I don't
I
have any
believe
cause.
that's it. Thank you very much. Appreciate you coming. You are excused. If you want to have that exhibit back to Attorney Hitchcock Cross, you are free to go.
Okay. Do I have to appear any other days?
No. Thank you. I mean, I didn't, you only got a subpoena from us, right?
Yes, I
Yeah,
did.
okay.
It was for multiple days, though.
No, you're done. Thank you.
All right. Awesome.
Okay, the witness is excused. Thank you.
Thank you very much.
Thank you.
All right. Do we have another one?
Yeah, so we've got Andrew Olmanson. We've also got the secretary, Petchacek, and we've got Carr that are supposed to be here ready to go. So we'd like to start with Olmanson and go from there.
Well, let's see. Now,
That's not signed.
yeah, I think that the subpoena wasn't signed for me in any way. You're not going to depose me. You did have this served, what was it? Was it Friday? But
Friday.
Kevin Carzo was already out of the country, correct?
Mhm.
He's not
Yes.
coming back for this, so.
Okay.
So,
All right,
there's
well-
a couple of things I heard
And
there was
actually,
that.
No,
did
no,
I
no.
even get the
No, you
subpoena?
did not. Those are
yeah.
the only
Hold,
two we
hold
have.
on, hold on. Because this is like coming at us. All right, so we're gonna calmly just look at these one at a time.
Sure.
All right.
Can I just, can I start then? Mike?
As soon as I get something up, because I want to be able to keep track of what it is you're saying,
Sure,
if that's okay with you, sir.
please.
Okay, so you have 3 subpoenas out, is that correct?
As far as I understand, if there's an issue with the subpoena, Ms. Olmanson is here, so I don't think that's part's an issue.
Okay, well, I just want to make sure, first, you rattled off 3 names, I want to make sure I write them down
Sure,
correctly.
Kevin Carr,
Okay, that's what I need. Okay, so you sent a subpoena to
Yep.
Kevin Carr,
Amy Petchacek,
Amy Petchacek.
both of them have been served. And apparently we've got confirmation that they knew he's going to be out of the country, but didn't bother to say anything.
Well, we haven't even gotten there yet.
No, I have, but I understand.
Okay, Kevin Carr, Amy Petchacek, you said there was a 3rd.
Yeah, Andrea Olmanson.
Oh,
There's some for her that I see.
all right. Let's go back and take a look at a few things. All right, let's start with subpoenas. All right, because obviously under 218, you can subpoena people for coming to hearing. All right, so you can ask or compel, pursuant to 218.15, to compel the attendance of a witness, right? You have to do the witness fees, mileage fees, blah, 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 blah. And then you need to serve them in accordance with the statutes for service. So let's go take a look at what that is. Because obviously I haven't seen these things, so I'm not making any decisions on anything until I understand what's happened and then I see what's going on here. All right. So everybody can get whatever documentation and things they think they need ready to talk to me about this. Okay, so when we're dealing with so you can do testimony, subpoena, that will run you to 8045, and then that brings you to subpoena statute, which has to be done in accordance with all right. Okay. We know that when we serve somebody, we have to give them reasonable notice. So, when was let's start with him, because that's the first name that popped up, okay? I'm just going down the list that I wrote. When was secretary, it's former secretary, right? I think that was his former title. I don't know what he's doing now. When was he subpoenaed for this hearing?
I have a subpoena here. It was served 4:10 p.m. this past Friday, but it was served at DOC Central Office. I believe that's the only signed subpoena that was actually served. And Stephen, did you accept this?
I did.
And was there a witness fee that came with it? Any check?
Not that I'm aware of. I think Sean technically accepted service.
Okay.
Okay. Attorney Cross, where are we in terms of, because there was a whole lot of I didn't pay it, didn't put, and the check was there. It was just in another envelope.
Right. Remember
So-
they called me a liar several times. Remember that whole one? You didn't respond on that. And
No,
you asked me to
because I'm not
respond
doing
and-
gratuitous stuff.
Right. Remember all
That-
that.
I'm not-
Remember all that. Well, but then you also then asked for the witness fee and got involved
I
in
just
that
said
whole
no. I just have
motion
a
and
question.
said after the time period.
No,
and so
I just
forth.
have a question.
I remember that, and you specifically ordered me to respond to their timeline. And,
No,
yeah, I remember
just
all that.
simply,
I do
it's in
remember
the
that.
file.
Right, I remember.
Okay,
Yep,
yeah, I just
remember.
wanted to know whether it had been paid or not, and you clarified that quite distinctly as to how exactly it was paid. So that was it. I can ask questions. I'm allowed to do that. All right?
No, but the problem wasn't that you asked the question. The problem was you did it for the benefit of keeping Kevin Carr out of the hearing and for the benefit of the respondent. That was what the
That's
problem
your
was.
position.
Right. That's exactly
and you're,
why I said it.
And you're
That's why I said
welcome
it. You got
for that to be your position, as always. But that,
The problem here, Judge, is that you grade your own homework. And 100% of the time you find your own homework to be flawless. And it's a big problem in this case and others when you do that because it's just not objective or fair to the parties here. So,
okay. All right, so
okay.
let's see
So
how...
I'm talking about this person right here who's available. I don't have any idea why we're talking about subpoenas while you're looking at the statutes. The witness is standing right in front of you here. She just
We're
needs to
not
be
here
sworn
on
in.
this one.
I'm
I
here
told
on
you
this one.
we're talking them one at a time.
Mhm.
That I said that before we even started. You listed 3 people. I
Right.
said let's take them one at a time. So I started with Kevin Carr.
Then I
wanted to-
suggest let's just take her and get
I
her
understand
started.
what you suggest,
Right.
but I'm going to do it the way I want,
Okay.
and I want to go in the order in which the names were spouted out, because that's how I wrote them,
Okay.
so that I can take proper.
Well, Kevin
notes.
Carr's not here, is he?
I have no idea who's here, sir.
Okay, so you don't
because
have
I
and you
can't
don't have
see
any
through
power.
the wall.
You have no power to enforce the subpoena, even if you did. The only person who does is myself.
I'm
So I
not
don't-
enforcing anything. I'm just trying to understand who all was subpoenaed and who all was not.
Sure, we
okay?
subpoenaed Kevin Carr through his attorney, Miss Omenson, because she accepted service for the deposition last time.
Okay.
So that's where we're at. Now we're
Okay.
apparently told that he's out of the country. They knew he was out of the country for some time, and they're alerting us to this fact now and have told us that he's not appearing here, is what they've said. So the issue isn't, they knew about his service, apparently he knew all about it, but they are continuing to play games, and that, I submit, is what the issue is. She's testified now and told us all that she was clearly aware of the subpoena, and now said he's out of the country, too bad, so sad. And that's, I would submit, problematic and an issue for us to raise at the circuit court when we enforce the subpoena upon him. But that's all that can be said and done at this period. If he's refusing to appear,
I don't know
that's-
that there was ever any witness fee paid, Your Honor.
Okay. I don't even know that anybody's refusing to appear. This is the first I'm hearing of any of this, okay? So everybody needs to take a step down. I haven't made any rulings on anything. I'm simply asking questions. Since I'm entitled to ask questions. So let's get that all straight. We know that if you're going to issue a subpoena, that it should be done in accordance to 80507, which directs you to Chapter 885. We all know that. Okay?
We also know that when you hold a conversation for their motion to dismiss, that people are going to assume that the case is going to be dismissed.
And it's
And
not,
then when
and it
it
wasn't. Please
dismissed, then
please-
it really screws up service on everybody else.
What-
and you're holding us, when you've prejudiced the parties here, and you're trying to bring up all of these issues for the purpose of further trying to undermine the complainant's case.
No, not at all.
Mm.
I'm just simply asking questions.
Mm.
Okay, so you've got 3 subpoenas. You served Kevin Carr. Apparently you did that on Friday. Okay. And then you have served
Amy Petchacek.
Amy
through her
Petchacek.
attorneys.
Okay.
Right.
That one, everybody should probably check their email. Apparently there was something filed. I haven't looked at it yet. That came in, I guess we're in the middle of this. It came in at 11, mine's showing 11:50, saying that everybody in this room is copied on it. Apparently on September 27, 2024, complainant served a subpoena on Amy Pachasek during her testimony at a hearing dated October 1. I don't know what that was. Anyway, despite protective order in this case, deposition in this hearing, filed attached motion for an order quashing the subpoena. I've already discussed and directed that quashing a subpoena is not appropriate, and I don't know why people keep filing for motions for quashing, because it's not a thing. Which I believe I'd also addressed countless times. So let's go see what the order was that I issued, because that's his contention in terms of that. Okay.
If it does say what he alleges, that would be evidence of a priori decision-making on the evidence in this case, and would also be grounds under Bowen for your necessarily recusing yourself.
Okay, well, that's all things that you can include in any, we're still on the record. Those are obviously grounds, in your appeal. Should it come to that after eventually we're done with this and I actually write a decision on this case. The relief, let's see, what did we... The relief he specifically asked for, the original reasonable notice. It was all in the brief and motion. Not only is it pertain to in my decision and order, we did discuss and I did analyze the case in regards to a deposition as well as any testimony. Went through the factors outlined in Beloit. And I granted his motion for protective order. That was done when? On August. And what he had requested an order prohibiting the complainant from being required the testimony at either deposition or hearing. And so given that order, that's where we're at. I have not read his I have not read any of the stuff he's filed here, and I just haven't. Okay, we've all been in hearing. I just got a pop-up saying that something popped up in the inbox on this file, so that's why I'm looking. That my email is flagged for this. So everybody should be aware of what it is. Anybody wants to address this, we can take this up tomorrow. All right. So that's being said, where that one's concerned.
Can I clarify that one today?
Says, I want to clarify. My order says that you are prohibited from deposing her or from having her testify at hearing. And there's a huge discussion statement. I mean, this is a 7-page decision. I go through all the applicability as well as all the statutes. I discuss the case law. I explain it in great detail, the rationale for the decision that I came to and how I came to that decision, as well as the rest of the case law. So it is.
So the problem with that is this. You've got an application of Beloit Stone, which only talks about depositions. And the only issue at hand with Beloit Stone is whether or not a secretary is immune from being deposed.
Correct.
They are under certain circumstances.
Correct.
Then if you go into the question here now is the hearing.
Correct. And go further up in my decision, and I already explained that to you. It's in here as well, because the Attorney General was wrong. There is no such thing as quashing a subpoena to compel the attendance of a witness. 805.073 does not authorize what he was requesting, a protective order where a subpoena is used to compel the attendance. So in other words, I have no authority. It's not a thing. So why anyone would continue to quash subpoenas at an administrative hearing, I don't understand.
Great.
The case log is very specific.
I don't contest that. I don't think it's an issue.
I did not quash it because it's not a thing. I cannot do that. However, and it only pertains to a subpoena ducis tecum, but you can't quash a person. Okay? So that's how that comes about. And then I delineate the rest of my argument. So if people would read, they would see. So my order says her testimony at a deposition as well as her testimony at hearing. I did not quash a subpoena because at that time you had not subpoenaed her for hearing. Apparently you've done that now, but my order has already said you can't do it. So,
but that's an illegal. Can I make my argument now and explain that, please? Or we're going to talk
Sure.
about why it is that you can't quash the subpoena for.
Sure, go ahead.
Okay. So the case that you need to look into is Bowen versus U.S. Government Services, and that case, Alice DeLau had a two-time. She was a two-time loser in that case. She went to Lurk twice. And during Lurk sent it back twice, and then directed the third time that case be handled over to ALJ Schacht. ALJ Schacht then adopted all of the findings of Alice DeLau in favor of as a courtesy to her, and Lurk found that was completely inappropriate. And one of the reasons that it did that, ALJ Benitez Morgan, is because it's completely improper for you, because you hadn't heard a single iota of evidence when you made this decision. Now, so far, you've heard from one witness. And the problem is that you did not have the basis to exclude, and you cannot, according to both Bowen and appeals court cases, exclude people's testimony from hearing because you don't have enough information to do it. And Lurk has absolutely commanded you to liberally hear all of the witnesses that are put before you. Please stop breathing so heavily. It's highly distracting.
Could you please not yell?
Yeah,
Could you
you're
please not be
yelling.
unreasonably loud?
Okay. So then when you look at that, you need to understand that you aren't able to say that her testimony is irrelevant, or that your opinion on how we said that Kevin Carr is the one who knows, and how you came up with this mutually exclusive theory that only one person can know how the Department of Corrections made that. That's something entirely different. But nevertheless, you're walking into appealable grounds that you should know about, because Bowen is very clear on that subject, that you cannot make exclusionary evidentiary decisions prior to the hearing, which you've done. And to do that is automatically reversible and calls for a new hearing. Mm-hmm. Right, because why? Because you've showed that you're wedded to a particular conclusion. And so when you look at Bowen there and you make that's what the problem is. You're saying, hey, we can't hear Amy Petracek because of the way I've decided on, ultimately it's Olmanson's testimony. And that is what the problem is, because until you've heard evidence, you cannot make a decision. And because you haven't heard any evidence when you did make a decision, it was a legal a priori decision that warrants that the whole entire hearing be redone. And that is what I submit would be a further waste of everybody's time here.
Okay. Well, the way these motions were argued is everybody submitted motions on all of these, and according to statute, everybody should have put their positions in, supplemented with whatever documentary evidence they wanted, and according by statute, I make a ruling on those motions based on what has been submitted in writing, and I did so. Everybody weighed in. The Attorney General presented whatever it was he did. You presented your position on whatever it was you did. The respondents presented their position on whatever it was that they did. I then read everything, researched some case law, and then I made a decision, and that was that.
That's not an excuse for making an illegal order, Judge.
Okay, and that's your position, is it's an illegal order. My position is it's not. So it's ripe for appeal, and at the end of this hearing, it could be yet one more ground for appeal. But right now, I have an order that says that. So I'll have to figure out how I'm going to address that. It's just come in. The chances are, I'm kind of thinking he's not going to produce the person you've subpoenaed. So that's kind of where you're at with that one. As far as Carr goes, I don't know. I haven't seen the subpoena. I don't know if it's proper. I don't know if it's not. I'm not making that decision right now. You know, people can show me whatever they want. I don't know if witnesses' fees have been paid. That's not the issue. I can tell you 10 days to send somebody a subpoena on a Friday for a hearing on Monday that has been scheduled since March is really probably not sufficient notice to provide a subpoena. And, you know, there may be some problems with that. Now, if we want to move on to Attorney Olmanson, we can more than happy address that if you want. I believe that has already been addressed. If you want to, and let's see, where is it?
First of all, I don't think there's even a subpoena requiring my attendance.
Well,
Do you want to leave?
What are you talking about?
Well, you're here.
So?
so just because somebody's here doesn't mean you have a right to call them.
It sure does. She's on my witness list, and she's here. That's what a right. I can call her. I have a right to everybody's evidence who's on my witness list.
Actually,
That's what
you
that
don't
means.
if there's privilege.
Okay.
I fully recognize that you made a decision in which you had no discussion whatsoever about whether or the fact that she signed her interrogatories on behalf of this defendant, respondent, makes her a witness. And that's the central issue that needs to be addressed.
Well,
So until we get that issue addressed, she's a witness on our witness list, and we're calling her. And that's where we're
part
at.
of the problem, which I brought up in your motion, is, I'm looking at this 15-page motion. It's 85 with all the attached exhibits. Don't get me wrong. Of the 15 pages, 7 were blank. The first, the conclusion says, "Judge, for all the following reasons, we want this motion granted." I'm trying to figure out what it is you're even asking for. I look at your motion, and your motion is motion to compel the production of documents, but yet in the first paragraph you just want people to answer 2 interrogatories. So I look at the interrogatories trying to figure out, what are you asking for? So I read those 2 interrogatories and try to figure out what's going on with that. I get to the next section, which is entitled Argument. Your header makes no sense, telling me that the complainant is under no duty to produce anything. That's nice, but your complainant is your client. I'm assuming you mean the respondent. So we go through that. You argue about statutory 804, and then immediately you jump into this 2-paragraph discussion on Cone v. Bryden Motors, which where you're talking about how in another case, but the Court of Appeals, an attorney signed something, and the Court of Appeals did X, Y, and Z. What I found rather disturbing was that you cited a decision from 1989 Court of Appeals that is unpublished. You made no reference to being unpublished. Everyone in this room knows that an unpublished decision that is unpublished prior to July 1 of 2009 may not be cited. It has no persuasive, no precedential value, and yet that's what you did. You then proceed to tell me how they haven't met their burden, but it's not even the respondent that you're referring to. I spent an hour and a half trying to figure out who in the heck Creedy was, because I'm not aware of who Creedy is. Did I miss something in this case? Is that a co-defendant? Is that somebody? Apparently, that's obviously just a typo, Scribner error. Move past that. And I'm moving on. But you never once, the relief you asked for was whether or not they needed to respond to those interrogatories. I went through great length to explain the rationale behind interrogatory number 6 as to what that is. And you're asking for why. Give me every reason why you think it's relevant. That is clearly you're asking for their mental impressions, thoughts, strategy. I mean, this is just basic, attorney work product. And there's a difference between work product and attorney-client privilege, which we can get into momentarily. What 804 requires them to do is identify the objection and then explain why. They noted in their response that it was privileged work product and possibly privileged attorney-client communications. The statute doesn't really require any more than that. Number 7, you wanted them to identify every respondent, manager, authority, employee, any other person who Attorney Olmanson may have spoke to on or before, December 18 of 2019 about somebody else's testimony in a 2-day hearing on 2 other cases that aren't before me. So you're going through this case to try and find information on an unrelated case from years ago that is not relevant to this, who somebody may or may not have spoken to, again, is it's unrelated, and it exceeds the scope of discovery that is allowed for under 80401. Oh, what is it? I think it's 80401 2 sub A. But anyway, asking them to disclose any possible confidential, discussions with their client. And once again, you can't obtain privileged matters. And in these responses, because I also looked at their responses as well and all the exhibits and additional documentation that everybody submits, I always go through all of that. With the exception of anything filed on August 8th, I did not read the 650 million pages that were filed. That just went in the file. It's there for appeal. I'm not reading through all of that because I wasn't going to deal or issue a decision on those things. But they've identified it in their responses. Wisconsin, when I was dealing with federal court, sure, you provide a privilege log, you provide all those things and all that. It might be best practice in Wisconsin, but it's not a requirement to do so. So it really doesn't make a whole lot of sense as to what it was you were asking for. You asked for a motion to compel, basically them answering the interrogatories, not providing you documents. That was the relief you requested in the first paragraph of your motion, and that is what I addressed. I mean, I don't know what else. You
Great.
said,
well, so now that we're done with that, can we at least address what I think we're talking about now, which isn't your critique of my motion? And to be clear, Judge, from my reading of the metadata there, you spent less than 3 hours on this, that this was available to you for almost a month and a half at that point, and you had also commanded us to respond to at least 2 motions that were filed after that point. So we need to be clear, but the issue that I asked you at the beginning of this before you went on that was simply this. When an attorney signs interrogatories under oath on behalf of their their client, they are then able to be a witness, and that is what the issue and the question that is before you. Simply this: your critique on my brief is both irrelevant in terms of and ad hominem, and it doesn't have to do with the issue because you didn't answer the issue in my brief, and you're not answering it now. That is what the question is here: is she available to? I'm saying that she is a witness because she signed the interrogatories under oath. That's what the issue is. You've never made any determination on that, and you keep going around on that. So that's what we need to hear about.
And if you hadn't interrupted me, that was coming up next. I'm explaining to you why it wasn't addressed, because it wasn't relief you had asked for within your motion. Now,
it was precisely relief I was asking for, because you found these things to be privileged, where I'm saying because she signed those, that pierced privilege, and that was precisely the issue that was being addressed there. Again, there was no other issue raised in that motion. She had signed, both of these attorneys, Zakard and Olmanson, had signed their, because they said that they did the investigations. They also had told you repeatedly, time and time again, and you acted on it, their opinions on this case. They put before you in this motion to dismiss that their letter in response to the investigator was to be taken as fact. And you backed out of that at the last minute. Nevertheless, this is the problem, Judge, is when you make faces like that, you
I'm
can't
not making
ignore
faces. You're raising your voice.
You can't
You're raising
ignore
your voice.
the fact.
You are raising your voice.
You can't
It hurts
ignore
my ears.
the fact that you sent us 2 communications that direct on the subject of this meeting. And when we appeared at the meeting, that wasn't the subject to be had at all. That is what the problem is.
No.
Is that when you're going off
We're-
on my credibility,
We're-
the problem is
okay,
that
Attorney-
your credibility is also...
Stop, please. We're done with that. When it comes to attorney-client privilege and signing of a document, you have provided me unpublished case law and no statutory authority for that, as well as you pinpointed to a site that once again does not speak to that specific thing. Again, that's in my motion, or that's in my decision for that. Now, if you want to know whether something has been breached in terms of attorney-client privilege, that privilege lies with the client, and that's where it is. Now, should an attorney have breached any of that, there is basically no exception of privilege under the rule as it pertains to 90503. But the relevant inquiry starts with, it's twofold. One, is there an existence of the relationship? Here, the respondent has counsel. So obviously we have a client relationship that exists. But the inquiry does not end there. Next, the inquiry is the information sought an attorney's mental impressions, their thoughts, their strategies, as opposed to a particular document?
Great.
Okay?
We'll be happy to ask her all about
I'm
particular
not done,
documents.
please. Please. In this circumstance, what the analysis that has to be done is you have to look through a variety of things. I don't know what you intend on asking her. I don't know whether I will allow you to question her. But based on those 2 interrogatories that you submitted in your motion, both of them do not pass the second prong of that test as to whether the information sought is someone's mental impressions, thoughts, strategies, what's going on.
Great.
Okay?
I
so
accept
I'm
that.
still... So, given you cited unpublished, given it didn't pass the 2-prong muster of the information you were requiring, and your motion, the relief you requested in your introductory paragraph, was what I addressed in the motion. That being said, you believe you have every right to subpoena Ms. Olmanson as a fact witness. You've stated your position not only in your motion, but you've argued it again here. I'm going to give either Attorney Olmanson or Attorney Zacard an opportunity to say what you have to say.
Because I think that, just a sec here. I'm trying to find this. Just a sec here. it's privilege, let's see. Okay, we've got Dudek here. Let's see. Okay, in response to that motion to compel, I briefed the law in general, not just as it pertained to the narrow discovery there, but plain and simple. We've got the Dudek court. It says the areas an attorney should be most encouraged to cultivate are those of his personal knowledge and legal theories of the case. Diligence in such cultivation is hardly encouraged by a practice which allows a lawyer to be wrung of facts and ideas.
I think we all agree on that.
Okay.
The question that I want you to focus on is somebody apparently signed an interrogatory, and it sure as heck wasn't an HR person.
For example.
For example, right? Because that's the
Or the
contention.
secretary, yeah.
Whomever.
Right.
Somebody from DOC. Instead, we have attorneys acting as agents for them signing. We all know attorney always signs the objections. But when it comes to the actual answers themselves, I have two attorneys, one or both, have signed these things. That's what I want you to talk to me about.
Okay.
Please.
Here's what we have. One interrogatory signed by Olmanson.
And which number was that?
The interrogatory number 5. It says, in accordance with complainant's above definition of identify each respondent employee who admitted to respondent during a 2020 respondent investigatory interview that they were present at Schaumburg Dinner Club located at N11935 County Road A, Randolph, Wisconsin, 53956 on January 27, 2020. For each identified employee, respond to the following questions and requests. A, state if the employee admitted to respondent that they had alcohol while at Schaumburg Dinner Club. B, state if the employee admitted to respondent that they had driven a vehicle after they alcohol while at Schaumburg Dinner Club. C, explain in precise detail upon respondent first learning the employee admitted to consuming alcohol while at Schaumburg Dinner Club, why respondent failed to ask the employee if they had driven a vehicle after leaving Schaumburg Dinner Club. The only answer was, to the extent that the only answer that I signed was, to the extent that the consumption of alcohol might be relevant in terms of the employee's observations, processing, and recall of events, upon information and belief, the questions asked and answers given in the two-ton disciplinary packet will identify which employees stated that they had consumed alcohol. Then I gave various objections. Now we have section 804.808, interrogatories to parties. Sub 1, sub A, it says, except as provided in section 804.015, any party may serve upon any other party written interrogatories to be answered by the parties served, or if the party served is a public or private corporation or a limited liability company or a partnership or an association or a governmental agency or a state officer in an action arising out of the officer's performance of employment by any officer or agent who shall furnish such information as is available to the party. Interrogatories may, without leave of the court, be served upon the plaintiff after commencement of the action, etc. So I did exactly what was allowed by statute. And, you know, in my brief, I also discussed the similarity of our statute in Wisconsin to the federal rules. And, we've got this 2007 case, Desert Management Corp versus U.S., 75 Federal CL 571. The attorney of record for the IRS was an officer or agent who was authorized to sign the agency's responses to the interrogatories.
Yeah, I know
You
the Federal Code of Civil Procedure
Yeah.
mirrors very much what we do here in
Yeah.
Wisconsin in terms of interrogatories and things of that nature. So, okay.
Can I have a chance to respond?
Of course, but I've got some questions here. Okay. So we have one interrogatory, and that was number 5, and that was dealing with everybody who went to the restaurant. What did they do? What did they drink? What information did you find? Why didn't you ask people whether they came, went, who was drinking, how much, what responsibility, all those things surrounding that dinner at wherever that place was. Correct? Or the party, or bar, or wherever.
Yeah.
That was associated with this fishing trip.
Yeah.
Whether it was before, after, during, but at some point, people were in a bar drinking.
Yeah.
Okay, all right.
And they were drinking before being in the bar.
On the lake or wherever this happened. I haven't heard testimony on that. Those are all allegations that people were drinking. She heard rumors of it. Unfortunately, she didn't get invited, but I guess Miss Bischoff says she was glad. But in any event, so that's what we're dealing with. Anything else that was signed?
Did you sign an interrogatory response?
Yeah, I can't.
Let me
into
just-
the document.
Okay. Let me just try to find it. If we want to go down this route, Attorney Cross has put a lot of his clients' information online, and it looks like she may have waived attorney-client communication or attorney-client privilege.
Well,
Okay.
Okay.
I won't
See,
go.
this is
I won't go
where
there.
This is where we start throwing all this minutia. I have read so many briefs and motions with hundreds and hundreds of pages of stuff that I realize people want to put out and get on the record, but it really has no business in dealing with the direct issues that are before this tribunal. I realize it's difficult, but we're going to stay straight and narrow. Okay? So I literally just want to know what else it is that somebody, if anybody else signed another one, I want to know which one it was.
Okay, and then we have, let's see. Okay, would be interrogatory 6. Let's see.
Okay, see?
I think that was
If it's interrogatory 6, that is the
Or-
same one that's the subject of complainant's motion.
It may not be. It may not be. I'm
What are
trying
we
to
talking
find.
about?
I want them to tell me every interrogatory that they claim.
Okay,
to
She
here we go.
signed the last set, and she signed the set before that.
Okay, actually, here we go.
It's in our exhibits. It's the last 2 exhibits in our exhibit
Interrogatory
list.
9.
I know what you
In
submitted.
accordance with complainant's above definition of the word identify, identify all respondent managers, authorities, etc., all other persons who were provided with respondent's investigation, January 27, 22 incident between Jason Toutant and complainant. It says answer 9. Respondent has already provided the investigation materials as well as the routing slip that indicates who would have been involved in the disciplinary process.
So essentially, as when you signed these, did you do them as upon information and belief?
I did it upon information and belief.
Attorney Zacard, how about you?
I don't know because I can't get into the document right now.
Okay.
I'm sorry.
I know they were attached as exhibits.
It's not in here. Are we going past 5?
I'll go as late as anybody wants to go.
I would hope we could not go too late.
Well, let's get this issue
I
resolved
can't.
as soon as possible.
You can't stand any longer?
No.
You can't sit any longer?
No,
Okay.
I'm sorry. It's just too much today.
Okay.
And I have to drive an hour home, so.
Oh, golly.
That's not good. All right. Well, this is where we're going to leave off.
Discovery here.
Is it the
So, well,
Okay, here we go, I think. Let's see, it starts with, what would it
what's
be?
the date on that?
Okay, Bates, 10/23, signed and sworn July 18th.
The respondent?
Yeah, here it says, as to answers, I, Michelle Zacard, am the assigned legal counsel to the State of Wisconsin Department of Corrections, and am authorized by the State of Wisconsin Department of Corrections to answer these interrogatories. I have reviewed the above answers to interrogatories, which were prepared in reliance on information from officers, agents, employees, and records of the State of Wisconsin Department of Corrections. The
Wait a
answers.
minute. Bait stamped as in your hearing exhibit bait
Oh,
stamped?
wait,
it's in
just
my
a
hearing
second.
exhibits, yeah.
Okay.
Yeah.
Let me go to complainant's hearing
I
exhibit.
think it's the
Stolar
last
1023, I believe.
two. Thank you.
Let me look
I
at it.
can't open it. It's okay. Thank you.
All right.
Finally got cold.
Okay. So, Attorney Zacard also answered those and as to upon information and belief as well. Okay. And that would have been
We did raise this issue in briefing. It's possible our pin sites went right.
and that also.
Do you want me to just pick over?
Okay. All right. So I've got objections here that pertain to interrogatory 10, 9, 8, 7. The third set as of June 20th. Two, 1. So once again, we're dealing with 6, 7, I believe 8, 9, 10, 8, 9, and 10. And the other one was interrogatory number 5, which was signed by Attorney Olmanson. I can't find immediately right in front of me which exhibit that was, but I will find it tonight. Maybe that's the 5th set, perhaps?
That sounds right to me. I just saw.
Those are requests, response, those are production, response, that's not it. Nope. Missions, that's not it. I'm sure you have it in, it's here. I just like to find things quickly. And unfortunately, I can't find things as quickly as I would like. I will look for it. I'll have an answer to everybody in the morning.
But Judge, don't forget that I'd still like that chance to add something here. I think I can be brief. I understand where everybody's at.
What's because I'll
I
stay till
understand.
10 o'clock
I
tonight. It
understand.
doesn't matter to me.
So I'll be very brief then.
Okay.
Let's be very clear. Their answer is not on point. And it's simply this. They do have, and I already anticipated this argument and addressed this in the brief, although it's not responsive on this question. It was simply this. They have the choice to sign that. There's no question that they can sign, that they had the ability to elect to sign interrogatories. The question now, what happens to that? Because we're able to ask them questions under oath about what, as she just said, she got all this information from all of these people about what happened in their investigation. There is no other issue that's of greater importance to this case than how did the investigation happen? Was it adequate? Was it sufficient? Did it meet the needs of the sexual harassment complaint? And that's what the issue is. That's why we need to have their testimony here. They placed themselves into the record here. The law was, I mean, they have the choice. Yes, they're an agent. No question about that. This agent chose to make these statements under oath and chose to do this. Therefore, when we're talking about privilege, we're talking about work product, we're talking about all of those things. Most importantly, again, it's you're not able to tell if they're a witness, if they're an advocate. And here they chose to do both. An advocate objects, the witness signs under oath. And that's what the law says. And if they didn't sign under oath, then this case needs to be dismissed because they have not complied with their discovery objections, and those are we have three faulty discoveries. That's what we brought to your attention when we filed this way, way, way before the deadline was even reached, Judge. That's why we filed this in the last date. And maybe this was an issue when they briefed it. And I mean, these are real issues. That's all I'm saying. And I think, and I get that you're considering these here now. But again, they made the choice, and we all know with waivers. And whether or not it belongs to the respondent chose this attorney. This attorney chose to sign this document as to the facts. And now we have the opportunity to question those facts because as they put in their motion to dismiss, they're relying on those. They called me personally a liar based on their investigation. And so now they called the complainant a liar based on their investigation.
Because it also involves the complainant's responses to and her sworn testimony. There's a lot more. It isn't just based on our investigation. I also would like to correct the record because Attorney Cross is well aware that we had somebody else, we amended the responses because he wanted us to stand on our heads and have somebody else respond to those interrogatories. We did that. So who was it? Was it Carrie Beyer? I can't recall. I think it was Carrie Beyer.
Where is that? Where is that?
I emailed them to you.
I don't have them in the record. I got your interrogatory responses. I don't have any of that in the record.
Well, enough correspondence was sent back and forth in exhibits to this motion, which was filed on the very last day, which was August the 8th. Mm-hmm. You had 14 days to respond to that. And you did. And then we, obviously had
we prioritized
holidays and everything else. I'm sorry, what?
We prioritized their motions over the ones that were already filed by the complainant. I think it's very significant that there was a motion that was fully briefed and sitting there, and instead of doing that, you directed us to respond to their non-existent, non-respondable motion to dismiss. I think that's very significant, Judge.
Why?
Okay,
because we're entitled to a fair hearing. There's nothing wrong with advocating for a fair hearing.
I agree. Please don't raise your voice, but why are we going to keep going over the same thing again and again and again?
Because
I did not entertain a motion to dismiss. I wanted to know if you had anything to say about it, because I had plenty to tell them there's no such thing. There's no such thing as summary judgment. Why do we keep doing this? Why do we keep hearing this nonsense? Why do we keep following these things after the time? I wanted to know if you wanted to chime in and add anything to that. And instead, I heard everything else from you. Okay? That was the purpose of that. There wasn't to hear from them again. They had already filed 85 pages after the fact.
Judge, okay? We're entitled to advocate for a fair hearing.
And I understand that. But everybody knows I will address motions as they're filed after the responses. This is not my only case. I have other hearings going on. Okay?
Yeah, I have other responsibilities. I can't respond to their motions in 3 days, Judge.
Oh my gosh. Okay. You know what? We're over all of this. I'm going to render a decision on this in the morning, but there are plenty of emails in that in the the responsive brief in opposition to this motion, as well as the documents that you filed where people have repeatedly offered, who do you want to have sign it? We can have the HR person who conducted the investigation. We can have all these things. So if they amended their responses, which they have a duty to do, and they provided those amended responses to you, then...
Let me explain to you why that's wrong, and I appreciate that opportunity. The fact is that they signed it under oath, and so that they're a witness under there. If they want to go ahead and wash it and have Carrie Beyer, that's perfectly fine. That doesn't wash the fact that they signed these under oath as witnesses, and that's what the problem is. And so whether they have submitted, I don't know that I have one submitted from Carrie Beyer on her at all, and I don't know that you have that in the record as testimony. You're talking about
because
going...
I don't ever want to see anybody's interrogatories or answers or things like that. The only time they ever show up is when somebody's done a motion to compel or saying something's done. I don't want to hear what you guys send back and forth to one another. That's not evidence. Don't show it to me. I don't want it.
Well, you're just citing it.
No, because you guys filed it in your motion. What am I supposed to do with it? Ignore it? You give me 755 pages, I will read each and every one of them. That's just what I do. I don't know about anybody else, but I will read everything that's been submitted on a motion that is timely filed from both sides before I ever render any decision. I just don't start reading anything until day 15.
Right, what I'm talking about is that this hearing right here today, the evidence before us is not what you have their testimony, not evidence.
I don't have anybody's testimony. They don't even have a witness. The only evidence I have before me right now is from the young lady that was here.
That's wrong because you've accepted what she said as fact. That's the problem.
No, there is no fact. I asked you in the beginning, both of you. It's argument. Just tell me, what is the main issue? Are we hearing stuff about Alicia? I'm sorry if that's her name or not. The Miller lady, or are we not? We talked about these things because that seems to be a contention. I've given everybody an opportunity. Give me a summary and let me decide what's going on because everybody's known from day one.
Says
I haven't
enter
paid
the
attention
network
to.
Security key. Oh, jeez.
I haven't entertained what happened in the no probable cause because it's not my issue. It didn't pertain to me. I'm only certified for one thing. But if there are things from your hearing that overlap that should have moved on to this, I want to know from you.
And I think you're just misunderstanding me with one point. This is the last thing I'm going to say for today. And it's simply this, that the fact of the matter is that they have conducted an investigation in this case, and they have represented to you facts based on that investigation, not out of advocacy, but because they are the ones who have personally investigated and signed their names under oath to that. That is what I'm submitting to you makes them fact witnesses in this case. And whether or not they have Carrie Beyer or anybody else replicate that, the fact of the matter is they are the ones who ultimately receive that information, investigation, and put that before you in terms as fact in these motions. And that is what, again, I'm saying that I think you're being confused here by them playing both witness and advocate, which is exactly what the dilemma and the reason for the rule is, and it's exactly why it prejudices us as a party because it's unclear whether or not she's testifying or advocating at any given point because she is a witness advocate.
Well, and I think that's you make very valid points, sir, and I think that's part of where it comes down to: is this on information or belief or not? As an attorney, you have a client, they give you whatever facts, whatever their arguments are, and then you look through those things. You look through the reports, you look through the emails, you look through all those things. That's not conducting an investigation any more than you conducted an investigation on behalf of your client. I would imagine you interviewed people. Maybe you've got an investigator. Maybe you have a paralegal. You're going to research the facts of your case, and you're going to look at those facts of the case. That doesn't mean you actually conducted the actual investigation of the employee.
Right,
to
because I didn't
determine
sign
anything.
under oath that I did that. These people have signed under oath that they have done that. And when you say that is you didn't under information and belief, those were leading questions that you asked them to elicit that response. They signed under oath these documents here that say that they were the ones who committed the investigation and that these facts are all true. That's the distinction. I have
Actually,
never
that's a false
signed a
representation.
document that
That's
said
a
that these
lie.
facts are true.
That's a lack of
Okay.
care to the tribunal.
What you put in your interrogatories are not true
Please.
statements or
Look,
something
look,
else.
You're
look,
lying.
decorum. No, we're all going to calm down, okay? Yelling over one another accomplishes nothing. First off, I don't even know what got recorded just now with everybody yelling over each other. Good luck with anybody trying to make a transcript out of that. All I ask is for people to be civil. We can all have different opinions. There's nothing wrong with that. We can all argue different positions of the law. That's great. That's fantastic. Maybe one of us, me, might learn something here. Or maybe we might help one another. But when we start getting into, well, that's not candor. This person lied. This person did this. Now the attacks aren't more so in terms of legal argument. It becomes personal. And this has been my biggest contention with this case, is that for whatever reason, that's where things want to go. And I don't get it. You know, maybe there's something in the background I just don't have a clue about. And that very well could be. But I'm going to be up quite late tonight doing some research on this as to whether it was these interrogatories, you conducted the investigation, you're swearing you did this, or you're simply referring to the records in your records, and this is what you came up with on information and belief. Should you probably have had somebody else other than you guys sign for it? I don't know, because the statute says as an agent you can. Might it be better practice to have never done such a thing? My gut is telling me, yeah, probably, but I don't know.
And Your Honor, it was maybe 10 minutes ago, something happened, I got booted off the computer. But as far, just want to make a record here regarding the lack of candor. There were misrepresentations made regarding the language that we used in responding to those and objecting to those interrogatories. And the lack of candor was not on our part. I would like the record to reflect that.
I will tell everyone once again, the record is what the record is. It's all recorded. I do not envy whoever it is that has to go through each and every email, each and every motion, each and every exhibit, when there's just a plethora of stuff. The record does state what the record is. I will not get into a tit for tat. This person said this person said this. We are beyond that. I think everyone in this room is of an age, at least have some semblance of, we all know better, okay? Myself included. So I just would like everybody just to take a deep breath. Attorney Zacard, I'm sorry I'm rambling. I know you're hurt, and I know you're in pain. I really apologize. It is now 5 o'clock. If anybody wishes to, don't forget, you have until 9 o'clock. Just a brief paragraph. Don't give me something that's 42 pages. You can even, listen, rule change, okay? We're in the middle of hearing. Just put it in an email. Give me a paragraph or two of what you think in terms of your position, okay? Same thing with you all, okay? Please do not submit 50,000 pages, because at some point I would like to get a couple hours sleep. But I just want to know about the no probable cause versus the probable cause and a brief summary. I don't want to hear about why the case got dismissed, how it came about, because I don't care about that. I need to know is there something from that case that would have survived even the dismissal because it's also could be an allegation that falls within what was certified for merits? And Attorney Cross has presented some arguments that are very persuasive in that regard. I would like him to sum it up just to make sure I didn't mess it up when I wrote it down, sir. If you feel like it, okay? Not forcing you, but by 9 o'clock.
Yeah, I'm a first thing in the morning person, not a midnight person. So I'll get it before that, no problem. We're all sharing right now, Judge.
How early in the morning?
No, 8 o'clock is fine. I'll do it.
By 8?
Yeah, by 8. We'll be done.
Oh, that's fine.
All right.
That's fine.
I'll be here by 9:30.
Well, I'll probably be here by 6:30, just like I was this morning. Okay, but if you guys can at least give me your portion, that way I can at least have some. Basically, if anybody could, okay, it's going to be very hard to read all of that and everything else and make that decision. In the meantime, I'm going to do some research and figure this whole nonsense out about when you sign versus a government employee versus everybody else, and what you may or may not have, in doing so, revoked. Okay?
Okay.
So, that's how we're going to leave it.
Are we good?
Yeah, unless there's anything else.
Does the internet here like go down at a certain point?
No, I'm still on. I don't know.
That'd be a really good way to kick out these.
I don't work here.
I don't think you have to.
I don't know. I have 24/7 access to this building. So I'm going to go from here over there and grab an empty cubicle. So I don't know. Okay. We are now going off the record. Okay?
Thank you, Judge.
Thank you.